Vallow versus Chad Guy Daybell. Continuing with the state's case in chief, we had a witness on the stand, Ms. Heidemann, yesterday that I believe will be continuing with testimony today. I'll note that the prosecutors are present as well as the defendant and defense counsel. Is the state ready to proceed with further evidence this morning?
Yes, Your Honor.
Is the defense ready to proceed?
Yes, Your Honor. Thank you.
Okay. Let's go ahead and have.
Oh, okay. I won't touch it. Thank you.
All right.
The jury is present and accounted for.
All right, thank you. Please be seated. All right, good morning, everyone. We're on the record on case CR 2221-1623, State of Idaho versus Chad Guy Daybell. The state is present. Ms. Blake was conducting direct of the witness yesterday and will be continuing with the same witness this morning. Is the state ready to proceed?
Yes, Your Honor. Thank you.
Thank you. I'll note also the defense is present as well, the defendant and counsel, Mr. Pryor. The court will note, again, there is a courtroom conduct order in effect, and I appreciate those in attendance adhering to the terms of that courtroom conduct order. We did have a few members of the public yesterday that were not permitted to re-enter the courtroom later in the afternoon for not complying with that. Again, today it will be in effect, and I appreciate everyone in the audience here following those admonitions in that order. In addition, I'll note that this trial is being live streamed. We are showing that directly through the court's official channel, which is the best signal if anyone is following the trial through that for public access. And no, we did confirm that the signal coming through off the court's website has the best quality if anybody's interested in following it that way. A few other things I'll note that the jurors are all present today. The court has received the declarations or acknowledgements that they followed the court's admonishing instructions. And so all are present and seated, and I appreciate you continuing to follow the court's admonition at the conclusion of trial each day. Ms. Heidman's on the stand at this point and is still under oath for testimony. And I will just inquire to make sure you didn't do anything to go back and review or look at any other testimony before returning today. Is that correct?
That's correct, sir.
Okay, thank you. So we'll conclude or continue then with direct examination of the witness. And as you testify, Ms. Blake and Ms. Heidman, please talk right into the microphone so we get a good, clear audio. And with that in mind, you can continue with your direct, Ms. Blake.
Thank you, Your Honor. Ms. Heidemann, we left off yesterday going through phone attribution, but just since we had a break, will you remind the jury where you're employed?
The Federal Bureau of Investigation,
And what is your job title?
tactical specialist.
And in assisting with this investigation regarding the missing children, did that investigation ultimately expand into more than just missing children?
It did.
And what did it expand to include?
Into the deaths of Charles Vallow, JJ Vallow, Tylee Ryan, Tammy Daybell, and shooting attempts of Brandon Boudreaux and Tammy Daybell.
And as part,
Tammy, yes.
as part of your role in the investigation, were you tasked with looking at some Google searches done in association with a Gmail associated with Chad Daybell and a Gmail address associated with Lori Vallow?
Yes,
And did you in fact look at some searches that were conducted by both of those two
yes.
or their emails?
Their email account's correct.
And in looking through those, did you focus on a specific time date?
Yes.
And what was that?
In general, from October 2018 through January 2020.
And was it a similar time frame that you looked at in the phone attributions as well?
Yes,
In looking through those searches, did you prepare an exhibit today?
yes,
And did you prepare that exhibit based off your searches and what you reviewed in relation to the evidence or discovery?
yes, I did.
Do you believe that that would assist in your testimony today?
Yes,
And do you believe it would assist the jurors in understanding as well?
I do.
Your Honor, I'm going to ask that the witness be shown what's been marked as State's Exhibit 184A. I do have a copy for the court. I gave counsel a copy yesterday. Similar to the exhibit yesterday, there is actually a thumb drive that contains this actual exhibit, but these are printout slides from a PowerPoint.
Okay.
Sir.
And if you could look at those pages. Is that an accurate depiction of the PowerPoint that you put together?
It is.
And when we look at that, looking at these searches, were the children still missing?
Yes,
And in part of what you were looking for, were you still focused on attempting to locate the children or learn information about them?
yes,
Does this accurately reflect a summary of the searches that you pulled out as relevant at that point in time?
yes,
Do you believe these are still relevant?
I do.
Your Honor, I would move for the admission of State's Exhibit 184A.
Any
Judge,
objection?
as a summary, there won't be any objection.
All right, 184A is admitted. And again, to be clear, that's not the printed off sheets. That will be the PowerPoint on a file contained on a thumb drive, correct, Ms. Blake?
Correct, Your Honor.
All right, it is admitted.
And Your Honor, may I publish to the jury?
Yes.
Sorry, my computer is thinking a moment. On this first slide, can you walk us through what we're seeing here?
Yes, this is a summary of account titled chad.daybell@gmail.com. We started the review on October 1st, 2018 through the end of the production when legal process ended.
And do you recall approximately when that would have been?
I don't remember off the top of my head what the search warrant dates were, no.
Is your recollection that they would have been around the same time as that phone attribution?
Probably pretty close, yes.
So again, when the children were still missing.
Correct.
And if we look at that first search there, and I say search, let me back up. When we look at the first date there, can you walk us through what those searches were?
Yes. On January 28th, 2019, there was searches for Ned Snyder, 1996 death, Louisiana. Ned Snyder, Louisiana. Ned Snyder, Louisiana, born 1951, died 1996. And bodies possessed after original occupant dies.
And in looking at that, there's some semicolons. Why are those there?
They were separate searches, or the way that the return comes in, it might have been a search and then visiting a site, for example. So I didn't separate out which ones. These just appear in the search history under different times, different searches, but on the same date.
So several searches done on the same date for Ned Snyder.
Correct.
Why did that stick out to you?
That is connected to other portions of this investigation, wherein Charles Vallow makes a comment right around this time.
Judge, I'm going to object at this point.
Basis.
Well, it's hearsay. And in addition, Judge, there's no foundation to establish where this witness gained that information. So at the very least, I'd like some foundation. And then in addition, there's also a hearsay argument as well.
It's sustained on grounds of hearsay, calls for hearsay.
Thank you, Your Honor. As part of this investigation, we talked earlier that originally you get involved in looking for missing children.
Correct.
And at some point that expanded to include other acts.
Yes.
And you mentioned previously that one of those acts was the killing of Charles Vallow.
Correct.
Through your investigation, did you come to learn anything in relation to Charles Vallow and Ned Snyder?
Yes.
What did you learn in relation to the investigation?
Judge, I'm going to object at this point. There hasn't been sufficient foundation to establish how this witness learned of this information as it relates to Charles Vallow.
I will.
Investigation, did you review multiple documents?
I did.
Did you review multiple reports?
Yes,
Did you review phone data that was recovered?
I did.
In your review of reports and phone data, did you learn anything regarding the name Ned Snyder?
I did.
Did you learn of the importance of the name Ned Snyder?
Yes.
And what did you learn regarding the name Ned Snyder?
Judge, again, I'm going to renew my objection on the basis of foundation. The only reference to knowledge was from reports or documents that are unidentified. If this witness is going to start relaying information about what she learned, I would think at least I'd be entitled to know what document she's referring to, where this information was gained from.
At
And
this-
Your Honor, may I respond?
Go ahead, Ms. Blake.
Your Honor, I think under the collective knowledge doctrine, she's already talked about it being a joint investigation that she reviewed and discussed the matter. And in relation to hearsay, it's not coming in for the truth of the matter. It's coming in for why she does what she does and why it's relevant to her through the investigation.
I am going to overrule the objection and allow it to be answered at this point with sufficient foundation.
Thank you. What did you learn in relation to the relevance of Ned Snyder and Charles Vallow?
In reviewing police reports from Chandler Police Department and body cam footage, I believe from Gilbert Police Department, Charles Vallow makes comments that his wife, Lori Vallow, was referring to him as variations on the name Ned Schneider. Additionally, the name Ned and variations of the name Ned Schneider appear in Lori Vallow's iCloud accounts, again, in reference to Charles Vallow.
And then there's also one on there, bodies possessed after original occupant dies. What was it about that that stood out to you?
The concept of possession is sort of prevalent through this investigation. This is, I believe, the first time we start seeing it, wherein Charles Vallow has become possessed by an entity named Ned. So again, I spoke yesterday about there being a lot of aliases in this case with Chad and Lori, but also with some of the victims in this case where they are possessed by entities of them for Charles.
And then the next search on there, can you read the date and what that search was?
January 31st, 2019, Ned Schneider, Louisiana, obituary 1997.
And did that stand out to you for the same reasons you just explained?
It did.
And then the next one on there, can you read that and what the date and what the search was?
March 6th, 2019, June 26th, star sign, are Cancer and Leo compatible. May 4 sign, Taurus and Leo compatible.
And when we're looking at this one, what stood out about this particular search?
Lori Vallow's birthday is June 26th, making her a Cancer. May 4th was Tammy's birthday, making her a Taurus, and Chad Daybell's birthday is August 11th, which makes him a Leo. And then the search of the compatibility between those signs.
And on March 6th of 2019, do you know if Tammy Daybell was still alive?
She was.
And you indicated Chad and Lori had met approximately when?
October 26, 2018.
And looking at the next search, can you read the date and talk a little bit about that one?
May 5th, 2019, malachite and eBay malachite jewelry.
And what stood out about that to you?
Malachite stone wedding bands.
And again, May 5th, was Tammy still alive?
She was.
What stood out about, or excuse me, on the next one, can you say the date and what that search was?
June 1st, 2019, Iplos.
And what caught your attention with regard to that search?
In reviewing the iCloud data and seeing text messages, it becomes apparent that Hiplos is another name, another entity name for Charles Vallow, replacing Ned.
So both Ned Schneider and Hiplos or Iplos are names associated with Charles Vallow.
Correct.
And on June 1st of 2019, do you know if Charles Vallow was still alive?
He was.
How about the next search, the date and that search?
July 9th, 2019, when you surprise someone with accusations.
What caught your attention in relation to that search?
That search was conducted 2 days before Charles was shot and killed.
And then the next one, the one on September 8th, 2019, you could talk about that search.
SSW Wind And what is the definition of SSW direction?
What caught your attention with that wind search?
That search occurred the last day of Tylee Ryan's sighting, and we believe she was burned and buried on his property the following day.
We talked a little bit before, there were other searches in relation to this email. Is that accurate?
Oh, absolutely, yes.
In your review of those, were there any other searches for wind direction?
Not that I saw.
So this was not a common search done by or associated with this email address.
No.
And then the last one on there, if you could say the date and what that one is.
October 8th, 2019, Rhode Island area code.
And what was it about this search that drew your attention?
As mentioned yesterday, there were numerous phones involved in this investigation. On October 8th, 2019, the 401 number we spoke about yesterday was activated, which is the 401 is the area code for Rhode Island.
And as you said, we talked about that one yesterday. And is that one that Chad had let Lori know he was going to text her from that 401 number?
That's correct.
And did that occur around this same day?
I believe it was the day after. Yeah, it was. I think there was an issue setting up the actual account. So it was the 9th. I believe that he texted from his known number to Lori saying he would call from a 401.
And then if we move to the next slide, can you talk a little bit about what we're seeing on this slide?
Again, it's a summary of search activity of interest observed in the lollytimeforever@gmail.com account from March 7th, 2019 through December 14th, 2019.
And that lollytimeforever@gmail, did you determine who the associated user is?
Lori Vallow.
And on this first search, can you talk about what we're seeing there?
May 7th, 2019, malachite.
I think you've already talked about the malachite. I believe you said that's a stone that was originally, that ended up in Chad and Lori's wedding bands or wedding
That's
rings.
correct. Yes.
And when we look at the date there, was that date significant to you?
May 7th or 27th?
Well, I guess let me ask it this way. On May 7th, was Tammy still alive?
Yes, both Charles and Tammy were still alive at this point.
And the next search, if you could talk about the date and what that one is.
July 21st, 2019, Gerber Life Policy, Life Insurance for Children, the Grow Up Plan.
And what was it about that search that stood out?
We found it of interest seeing how children were missing and she was searching for life insurance for children.
And to be clear, through the investigation, did you ever determine if life insurance had been purchased for the children?
No, we did not.
And to the best of your knowledge, there was no life insurance.
No.
And the next search there and the date?
July 26, 2019, Phoenix Pet Services, Craigslist, Self-Service Dog, Little Angel Service Dogs for Sale, and Offer Up Phoenix.
And there's several searches there.
Correct.
And they appear to be in relation to a service dog.
That's correct.
Why did that stand out to you in this case?
JJ had a service dog at the time, and this search occurred roughly 2 weeks after the death of Charles Vallow. So to attempt to sell a service dog for a child after the death of his father seemed of interest to us.
And again, to be clear, JJ was still alive on July 26th.
He was, yes.
And the next search there?
August 25th, 2019, wedding bands made of malachite.
And I think we've talked a little bit about this. Did that stand out to you for the same reason?
It did, although at this point, Charles Vallow is no longer alive.
Was Tammy Daybell still alive?
She was.
And the next search?
September 20th, 2019, Kennedy Elementary, Rexburg, Idaho phone number and define possess.
And then if we also look at that next search, Can you read the date on that one?
September 24th, 2019, Kennedy Elementary, Rexburg, Idaho phone number.
So for both the September 20th and September 24th, looking at that common search for the Kennedy Elementary phone number, why did that catch your attention?
We believe that JJ died around the 22nd, 23rd. So these searches would have bookended that death
And do you know where JJ was enrolled in school around the time of his death?
at Kennedy Elementary in Rexburg, Idaho.
And on the 20th, there was that one additional search to find possessed. What was it about that stood out?
Similarly to the first Ned Schneider searches that also included that possession, the concept of possession and deaths sort of going hand in hand was of interest.
And this search occurred 2 to 3 days before, or I guess 2 to 3 days before JJ's last seen alive.
That's correct.
And then if we move down to the September 30th one, can you talk a little bit about that?
How to get the back seat out of my Jeep Wrangler. Jeep Wrangler JK rear seat removal, how to DIY. Yeah. Rear seat removal, how to DIY -YouTube.
And it looks like there's essentially two searches there.
The way that it's written, it looks like it was probably a search and then clicking on like a YouTube link to show this,
Okay.
if I remember correctly.
And what was it about that stood out to you?
Tylee Ryan had a Jeep Wrangler as her everyday car. At this point, she is no longer alive, or her last proof of life has passed. On September 30th, well, on October 2nd, Brandon Boudreau is shot at from a Jeep Wrangler, from somebody in the backseat or the rear area of a Jeep Wrangler in Arizona. So the search of how to get the backseat out of my Jeep Wrangler by Lori, who has access to a Jeep Wrangler. Alex Cox is believed to have been the one that attempted to shoot Brandon Boudreau, who would have had access to this Jeep Wrangler. Additionally, on October 2nd, there's a video of a storage unit in Idaho where Chad and Lori are on surveillance video storing a tire, like a spare tire, and what looks like the back seat of a Jeep or some sort of vehicle in a storage unit just a few days after this search.
And then if we move to the next search.
October 2nd, 2019, Gilbert, Arizona News.
What stood out about that search?
Brandon Boudreau was shot at in Gilbert, Arizona on October 2nd.
And then the final search on here?
October 22nd, 2019, wedding dresses in Kauai.
And why did that search or those searches draw your attention?
The search was, again, wedding planning. And then also it's just days after Tammy's death and the same date as her funeral.
And when you say just days after Tammy's death, do you know the day Tammy was pronounced dead?
October 19th, 2019.
So just 3 days after Tammy's death.
That's correct.
No, that's okay.
And you also indicated this search was done on the same day as Tammy's funeral.
That's correct.
Do you know if Chad and Lori ultimately ended up getting married?
They did.
Do you know approximately when?
In early November.
If I may have just a moment, Your Honor.
Yes.
Your Honor, I have no further questions at this time.
All right. Thank you, Ms. Blake. Mr. Pryor, cross-examination.
Thank you, Judge.
Well, I'm not sworn, so probably I'm tactical specialist is my title. TS if it's easier.
Mr. Pryor, your microphone's not working.
All right, Judge.
There you go.
Blake pulled one on me here.
Okay.
Turned off the phone, microphone. So you're not so how would you like me to refer to you again? I'm sorry.
Tactical specialist is my title.
Okay. Is there an easier, so
TS or
T.S. Heidemann, would that be fair?
that works, yes.
Okay. Okay. So, T.S. Heidemann, it sounds from your testimony that you've spent a considerable amount of time going over the evidence in this case.
That's correct, sir.
And you've familiarized yourself with a variety of topics. Those would include what happened in Arizona, right? What happened with Brandon Boudreaux?
Correct.
Okay. And what has happened here in terms of the facts and information? You spent a bit of time, right?
That's correct.
Okay. So you're also aware that Chad Daybell is not implicated criminally in the death of Charles Vallow, Lori Vallow's fourth husband, correct?
That's correct.
And you're also aware that Chad Daybell is not criminally implicated in the attempted murder of Brandon Boudreaux in where Brandon Boudreaux was shot, correct?
That's correct.
Okay. All right. So before I get into the gist of what I'm going to talk to you about, I noticed that there's an FBI representative in the court today, and that he has been here on a number of occasions watching the testimony. I can't. Is that your officer supervisor that's here supervising your testimony?
He's not my direct supervisor, but I do work with him, yes.
Okay, so what is he here for?
Observation,
Okay.
just observe the,
And at any time prior to your testimony, did you discuss with this FBI person anything you were going to say today, since he's been watching the testimony for several days?
we have not discussed it he's been a part of the investigation for quite a while, so he knows of it, but we haven't discussed in detail what I'm testifying to now.
And I appreciate you saying it that way. When you say he hasn't discussed it with me in detail, what I really want to know is he discussed it with you at all in any regard, in any capacity since this trial started.
Your Honor, I'm going to object on relevance and beyond the scope of direct.
All right. Well, the issue goes to the exclusionary order, and we need to just get to that point, Mr. Pryor, as to whether or not you believe there's been any violation of that.
And in essence, Judge, what I'm asking is whether she's in any regard spoken to that representative of the FBI about this case.
You can ask the question.
That's the question I'm asking. Judge.
About this case, yes, we have spoken about this case.
And when did you speak?
Over the last 4 years,
Okay.
4.5 years.
Did you speak in the last week during the testimony of this case?
Possibly. I don't remember off the top of my head if we had any other than if I was going to testify or
Okay.
timing.
And what I'm concerned about is this, is that he's not your direct supervisor, right?
That's correct.
And there's no need to report to him, right?
It's a co-situation. I don't necessarily need to report to him, but I do, as a courtesy, I am on his squad, but I have a different direct supervisor. So as a courtesy, I like to let him know if I'm
Okay.
in the office
All
or
right.
not.
And
Yes.
I'm going to move on. I just wanted to actually, part of that was the judge's exclusionary rule and whether or not you folks are communicating about this case. And your answer is maybe a little bit, but not in any significant way, right?
Not in any significant way, not beyond what we've talked about in the last 4+ years now.
And even though this FBI officer isn't your direct supervisor, you're just talking in general about this case, right?
I can't say in the last week or so if we have or not. Any details? Nothing that stands out, no.
Okay, so you don't remember whether you talked to somebody or not in the last week about a very important case in your life. Is that what you're telling
Your
me?
Honor, I'm going to object as argumentative and asked and answered.
Sustained.
Now, you identified that you were looking into attribution information and looking for Google searches as it related to this case, correct?
That's correct.
Okay, now you know the circumstances regarding JJ Vallow's death, correct?
As much as I can.
Much
yes.
as you can,
Yeah,
right? And you have an approximate date as to when you believe JJ Vallow was killed, right?
correct.
And what date was that?
Well, the last proof of life was September 22nd, 2019 in the morning. We have a photo of that date. So somewhere between then and approximately September 23rd.
All right, so the afternoon of September 22nd until the morning of September 23rd, correct? Is that fair?
Yeah, morning, early afternoon, correct. Yes.
Morning, early afternoon of September 23rd.
I don't remember the exact time.
Oh, it's
but yes,
okay.
those time frames.
Well, this is a problem. Our court reporter is never going to be able to keep up when you're talking at the same time and you're both actually doing it. So please wait for an answer, wait for a new question, and don't talk over each other. Thank you.
Yes, sir.
So if I, and please don't let me misrepresent your testimony. You believe that JJ Vallow was murdered the afternoon of September 22nd up until either late morning or sometime early September 23rd, correct?
That's correct.
And at the time, are you aware of the 4 people who were around JJ Vallow at that specific time?
What four people? I'm sorry, I don't understand.
Well, that's what I'm trying to get to. You're aware that JJ Vallow was allegedly murdered either in an apartment of Lori Vallow's or a close proximity to that. Do you agree with that, right?
I don't know that we know exactly where he was killed. No.
Okay. But you do know that JJ Vallow was being watched by Alex Cox that day and that evening of the 22nd, correct?
Partially, yes.
Okay. And you know that Melanie Gibb was there on the evening of the 22nd at Lori Vallow's apartment, correct?
That is correct. Yes.
And you know that David Warwick was there on the 22nd on the evening of the day or the day that JJ Vallow was murdered, right?
Yes.
Okay. And so we have Lori Vallow, correct? On that day?
Yes.
Alex Cox on that day, correct?
Correct.
Melanie Gibb on that day, correct?
Correct.
David Warwick on that day, correct?
Correct.
So I'm having some difficulty with you bringing up these Google searches. And this is why I'm having some difficulty is you're talking today about searching these people's and talking about events, and we'll get to these events in a minute. I don't see any Google searches on Melanie Gibb or David Warwick. And why is that?
Your Honor, I'm going to object as argumentative.
Overruled.
Why don't I have any Google search information on Melanie Gibb or David Warwick?
I'm not aware if I don't know off the top of my head if any legal process was served on those individuals or not.
Well, and this is what I'm having some difficulty with. This is what I'm struggling with.
Your Honor, objection to the narrative. If he wants to ask a question.
I'll sustain that. Just
Okay.
questions, Mr. Pryor.
Okay. Well, if David Warwick and Melanie Gibb were present for the murder of JJ Vallow, why aren't we looking into their Google searches?
I don't actually write the search warrant, sir, so
Okay.
I'm not sure if they were who would have done that.
Okay. But it's common knowledge that they were at least there, right?
For a partial time, yes.
Right. Okay.
Yes.
Okay. Now, you're also aware as part of your investigation that, and we can discuss when we think this took place, but Chad Daybell and Lori Vallow were having a relationship, correct?
Yes, sir.
And they were engaged in a romantic relationship.
Yes, sir.
And it may have been when Charles Vallow was alive. It may have been after that, but we do know that after Charles Vallow's death, Lori Vallow and Chad Daybell were in a relationship.
That's correct.
And Chad was still married to Tammy Daybell at that time, correct?
Yes, sir.
Okay. When someone's in a relationship, and you're looking at Google searches, could some of these Google searches be explained that he's trying to hide his extramarital affair with Lori Vallow?
I'm sorry, I don't quite understand the.
Well, let me go over it this way. You saw on 3/6 of 2019, May 6th of 2019. Would you like me to put this up so we can look at this? Would that be easier for you?
Sure. Yeah.
Oh. Now tell me how I operate this. That's going to be a problem.
Which exhibit is this?
Judge, I don't have the number on it. It was what Ms. Blake was just talking to as part of the Ocean and the Googles.
That 184A?
I think so.
Okay, 184A, then I'll note, not the PowerPoint, but the printout copy can be displayed to the witness and published for cross-exam.
And please excuse me, at my age, technology is just getting hooked up to Bluetooth is a challenge for me. So we're looking at 3/6 of 2019, right?
Correct, yes.
Okay. Now, before I start, one of the things I have some difficulty with is we don't know who did these Google searches, right?
Correct. I cannot say that I witnessed Chad Daybell type these into a search bar, but somebody with access to the Chad Daybell account
So if there was,
conducted searches, yes.
Judge, I'll pause. I'm sorry. The next questions are already in my head, and it's just getting it to spit out, and I'll try to control myself a little bit. So you put this off of a computer at Chad Daybell's house, right?
I reviewed a search warrant return from Google is what I
Okay.
was looking at. So not the computer directly, no.
So other than the time when Tammy Daybell passed away, are you aware that there were 3 or 4 other people who were living in Chad Daybell's house at the time?
I don't know. I think at least one child, but there could have been more. It's possible,
Okay.
yes.
Okay. So we don't know who actually did these searches, right?
Or I don't know from what device these were searched. No, I mean, it could have been a phone. You could be logging into from different devices, correct?
Okay. So I want to start, and we'll deal with the Ned Schneider ones in a minute here. 3/6/2019, Tammy Daybell's still alive, right?
Yes.
Now, I'm looking at that, and that on 3/6/2019, Chad Daybell was already in this relationship with Lori Vallow, right?
Correct.
So, and I don't want you don't have to say what you're thinking, but it looks like June 26th star sign are Cancer, Lead compatible, and Leo compatible. And also May 4 sign Taurus and Leo compatible. That's what that is, right?
Correct.
And what your test said is that it looks like someone's trying to see whether, if we assume that it's Lori Vallow and Chad Daybell in the Cancer and Leo, right? That's what you're sort of implying to this jury, isn't it?
Well, based on the birth dates, May
Right.
4th and June 26th, correct? Yes.
Okay. And based on the birth dates, May 4th of Taurus and Leo compatible as well, right? On March 6th.
Yes.
So if someone is trying to find out and is involved in an extramarital relationship, and you're Googling whether or not your current spouse or your new girlfriend are compatible, that would be a reasonable explanation, would it not?
Yes, sir.
Okay. And then we go back and look at the malachite, eBay malachite jewelry on May 5, right?
Correct.
Okay. And if you're talking to a someone that you're having an extramarital affair. And they encourage you to say, oh, someday maybe we could be together. I love malachite. And she starts dropping hints. That could be an explanation for that as well, right?
It could, but I believe that Chad's malachite searches began before Lori's.
Oh, but I understand the searches.
Oh, I'm sorry. Okay.
I understand that. But why don't you show me the phone records where they talked about malachite and that Lori Vallow and Chad Daybell discussed the issue of malachite? Did you see any of those?
I can't remember if they were in any text messages or not, but ultimately they purchased wedding bands that were malachite wedding bands. Yes.
Okay. And were you also aware that during this time, there was discussion with Alex Cox and Zuluma Pastenes about malachite as well?
I don't remember off the top of my head. No, sir.
Okay. All right. So we don't know whether this search for malachite was a discussion between a boyfriend and a girlfriend, or whether or not it was about Alex Cox and his future marriage to Zuluma Pastenes, right?
Objection, Your Honor. States facts not in evidence and argumentative.
Sustained.
Now, the Ned Schneider issue. Again, when was Charles Vallow murdered by Lori Vallow and Alex Cox?
July 11th, 2019.
Okay. So there was a discussion about this. And the first time you ever heard about Ned Schneider was when Charles Vallow brought it up in an audio recording about his wife at the time, correct?
I believe that's correct. Somewhere in early January.
And the date of that was when?
I don't have the exact date of the body cam recordings or the police reports, but I believe it's pretty close to this time frame.
Prior to that time frame, right?
Yeah, right in that general time frame.
Okay. So, and in that general time frame, there was a discussion of Ned Schneider, right?
Yes, sir.
And at that point, it's your position that Lori Vallow and Chad Daybell were involved in an extramarital affair at that point.
Yes, sir.
Okay. Did you happen to look into the fact that Charles Vallow and Lori Vallow called off their divorce and tried to reconcile their marriage in February of 2019?
I do. Yes, I do remember that. I don't remember the time frame, but that sounds probably pretty close. Yeah.
You don't remember exactly when in February, but they did attempt a reconciliation and basically tried to renew their relationship, right?
Yes, sir.
Okay. So the idea of Ned Schneider, you didn't see anything else, did you? Chad Daybell making any look into what Ned Schneider was all about, right? Prior to this?
This was, I believe, was the first search, at least in this time frame,
Okay.
that Ned Schneider appeared in Chad's Google searches.
Okay. So at that point, we can't make any assumptions, obviously, right?
No.
Okay. But we do know that as far as you're concerned, on the 28th of January, 2019, somehow Chad Daybell learned about the topic of Ned Schneider and decided to do a Google search and see what that was all about, right?
Objection, Your Honor. Misstates the testimony.
Overruled. You can answer.
I don't know if he learned of it or if he was doing searches. He did searches for various individuals pretty frequently.
Right.
This is the only one that we found that had connection to other pieces of evidence in the case.
And you just led into my next question, and thank you for doing that.
Yeah.
Because when I reviewed all of this evidence, I saw that it was not uncommon when a topic came up for someone who was using that computer to do a search on a number of different topics. That would be fair, wouldn't it?
Absolutely.
Okay. So if he were to learn about the name Ned Schneider, it would be consistent with his or whoever was using that computer to Google it and see what it was all about. Would that be fair?
Potentially, I can't speak of when he learned that name or if he was
Okay.
searching it like he was a lot of other names. I'm not sure the
Right.
order of that. No.
But his history shows that there's a lot of inquiry into various names, various topics, and that was something that was going on that computer quite frequently. Hundreds of thousands of searches, right?
Certainly lots of searches, yes.
Right, right. And then we go down to Malachite, and we don't know where he got the name Malachite from, but then he started searching that as well, right?
Correct.
And then he got to Hiplos, and we don't know what the story is on Hiplos, but he typed in that name, so he must have got the name from somewhere and started as that, right?
Correct.
And then you get down to 7/19 of 2019. Now, when you say you surprise someone with accusations, we don't know who typed that in, right?
Again, somebody, I can't say specifically, but somebody with access to the chad.daybell@gmail.com account.
So it could be someone's trying to learn about how you react when a spouse finds out that you're cheating on her, right?
Yes. It could be.
Okay. And we don't know who did the south-southwest wind and what is the definition of that, right?
Again, all I can say is it was somebody with access to that account.
Right. And when you're talking about the day before, the accusation is, or the prosecutors claiming that may have been the day that Tylee Ryan was put in the ground on 9/9, but you're also aware that on 9/9, Chad Daybell sent an email to his wife at the time, Tammy Daybell, and said, "I'm going to burn some limbs in the backyard." The next day, right?
I believe that that text message was sent on the 9th that he said he
Right.
wanted to burn, yes,
Yeah.
limbs, yeah.
Right. So on the 8th, he's checking the wind. And on the 9th, he sends an email to his wife saying, "I'm going to burn some limbs in the backyard." Right?
Correct.
Okay. And then Rhode Island area code. Now, you don't know what kind of phones we're dealing with. These aren't like track phones, are they? Or do you know what kind of phones these are?
I believe they might actually be track phones.
Go ahead.
No, that's,
Oh, you believe they are all track phones, right?
I don't remember off the top of my head. I mean, so track phone is kind of a provider. So if you're asking, like, is it an iPhone or an Android? I'm not.
If you don't have knowledge, but the way the track phone works is you buy the phone for a period of 90 days. It expires and you can either buy another phone rather inexpensively, or you have to buy the adding the minutes thing. And there's no real discernible difference in the cost, right?
Correct. Yeah, you can keep the phone and change the number, correct?
Right. Or you can just get a different phone and same thing. And you buy that at, I don't want to give anybody publicity, but large retail stores that sell a lot of groceries and other things, right?
Yes.
You know what we're talking about.
Yes.
Okay. So if you're having an affair with somebody and you don't want to get discovered that you're having this affair with another woman while you're still married, it wouldn't be illogical for you to buy a number of phones. And as the phones expire, you just buy another phone to sort of protect yourself from being discovered that you're having this affair. Would that be fair?
Correct. I mean, in this
Okay.
situation, he's not buying phones. It's changed. It's the same phone. The IMEI number stayed the same on all of them. So
Right.
the device didn't change, but the phone number did. Yes.
Okay.
Same idea.
So that would be, it's possible that what he's trying to do is he's trying to cover up the fact that he doesn't want to be discovered by his wife that he's cheating on her, right?
Correct.
Okay. And Judge, if I can ask the court again the number for the summary of search activity with Lolly time with Lori Vallow, what that exhibit was again?
It's 184A.
If I have permission, Judge, may I have permission to publish?
You can publish that page, which is a printed copy of the PowerPoint presentation.
So again, we see the subject of Malachite and whoever is on Lolly time, whether it's Lori Vallow or whatever, is doing that, correct?
Correct.
Now, this is what is interesting to me on 7/21 of 2019. Okay?
Objection, Your Honor. Again, there's a narrative. I'd move to strike and counsel and ask that he ask a question.
Yeah,
I'll ask him.
it is sustained. And Mr. Pryor, please refrain from that as
Okay.
questions.
All right. So 7/21 of 2019, and my notes seem to indicate that you said that was a short time after Lori Vallow and Alex Cox murdered Charles Vallow. Is that fair?
Yes, that would have been approximately 10 days after Charles's death.
Okay. And prior to Lori Vallow moving to Idaho, correct?
That's correct.
Okay. So you know from the facts, and you familiarized yourself with the Charles Vallow case, right?
That's correct.
And you know from the facts that at the time Charles Vallow was murdered, Lori Vallow was there, wasn't she?
At approximately the same time. I don't know the exact timing. I know she left
Right.
at a certain point, but I don't know exactly the time frame. Yes.
Well, you know that after the murder, that Lori Vallow was interviewed in front of the house right after the murder.
That's correct. Yes.
You also know that she left a little bit of time because prior to the murder, Tylee Ryan was present, and so was J.J. Vallow at the time, or at around the circumstances relating to the murder of Charles Vallow, correct?
Correct.
So it seems then that at least Tylee Ryan and J.J. Vallow would have knowledge, or at least information as it relates to the murder of Charles Vallow. Would that seem logical?
Yes, it would.
Okay. So if someone's looking and realizing that their children witnessed the murder of their father by their own brother, that's a motive for a number of things, right?
I suppose.
Okay. It's also a motive on 7/21 of 2019 to come up with a reason to get rid of a child if that child witnessed the murder of their stepfather, correct?
Potentially.
Okay, potentially.
I don't know if they saw that. I believe that Lori and the children left.
Ugh, when is my allergies freaking kick in?
You need Astapro.
Astapro?
It's fast.
They listened to there's an argument. Yes.
And
Correct.
there's a discussion because part of the FBI and the officers down there interviewed witnesses who suggested both sides of that issue, correct?
Correct. I don't know if we know. I mean, Tylee obviously isn't here to ask, so we're not sure what exactly she saw at the time.
Yeah. So we don't know what JJ saw. We don't know what Tylee saw because the evidence goes both ways in terms of what exactly did they see in regards to the murder of Charles Vallow, right?
I believe Tylee was interviewed, and I don't recall what her interview stated,
Okay.
but I don't remember about JJ.
Okay. But you also know that one of Tylee's very close friends was interviewed and provided information about what Tylee said as well, right?
I don't remember that, but
Okay.
that makes sense. Yes.
Yeah. So then that's why there's some discussion because we don't know exactly where Tylee was when Alex Cox murdered Charles Vallow, right?
Correct.
Okay. So Lori Vallow, before she comes to Idaho on 7/21 of 2019, searches a life insurance policy for her children. Okay. Now there's no equal discussion I didn't see it and I went looked at the stuff. I didn't see anything where Chad Daybell talked about life insurance for the children. He didn't, did he?
No, sir.
And there's no email or search on let's kill 2 kids, right? By Chad Daybell?
No.
Okay. And would you agree with me that part of the rationale of bringing up Hiplos and James and Elena is because of the religious connotation, right?
Not necessarily the religious connotation. It just provides some context in other evidence because of the aliases, and it gets complicated with the names that they call each other.
Right.
So to see that they're being searched by these individuals and to provide context for later of where these names are coming from.
Okay. Now, so we have some references to religion, calling each other religious names. And you're aware that both of these folks have strong religious beliefs.
Yes, sir.
And you're aware Melanie Gibb has strong religious beliefs.
Yes, sir.
David Warwick has strong religious beliefs.
Yes, sir.
Zaluma Pastenis, Alex's wife, strong religious beliefs.
Yes.
In fact, the circle of all these people, there's repeated references to religion, right?
Absolutely.
Strong references to religion.
Yes.
Okay. So I guess what I'm kind of wondering, is it a bigger motive to kill two kids by their mother and brother to cover up the murder of a fourth husband? Or is it because they killed the kids because Chad, Lori, Melanie Gibb, and David Warwick and Zuluma Pastenes have strong religious beliefs? Which one is a greater motive to murder children?
Objection, Your Honor, argumentative.
Sustained.
9:30 of 2019. How to get the back seat out of a Jeep. And that's Lori Vallow, right?
Yes, sir.
There's nothing about Chad Daybell trying to figure out how to get the back seat out of a Jeep, right?
No, sir.
And I guess if a girlfriend asks you to help me get a tire because somebody wants to use the Jeep, that would explain why Chad was helping his girlfriend load and unload a tire, right?
Yes, sir.
Okay. Gilbert, Arizona News on the day that Brandon Boudreaux, and you've previously testified that Brandon Boudreaux, Chad Daybell is not criminally implicated in anything with Brandon Boudreaux, correct?
He's not being charged. Correct, sir.
He's what?
He's not being charged.
Right,
in
not
Arizona.
being
Correct.
charged, not
Yes.
being pursued for anything for any reason. But
Objection, Your Honor, that misstates the testimony.
Sustained. And again, counsel, try to let the witness finish her response before you get into another question, please.
Your Honor, and I would move to strike counsel's last statement.
I'll strike that. I'll instruct the jurors not to consider that last statement.
okay, so your comment is Chad Daybell has not been charged. Is that fair?
Yes.
Okay, thank you. Did you see a likewise Google search on Chad Daybell's Google account that talked about Gilbert, Arizona on that day?
Not that I recall.
Okay. And then you're aware that that on 10/22 of 2019, are you aware that Lori Vallow was in Hawaii by herself with a friend?
Yes.
And you were aware that her friend was Audrey?
Yes, Audrey and maybe Melanie Boudreaux. I know there was some shuffling there, but I don't remember the exact time frame. But
Right.
yes.
But they were, about 10/22 of 2019, Lori Vallow and a couple of friends went to Hawaii, and I believe they were in Kauai, I remember. Is that fair?
I don't remember what island, but yes, that sounds fair.
But the purpose of them being there was to start the process of getting a wedding dress for Audrey Boudreaux, right?
I do not know that. No, sir.
Okay. But the three of them were there, right?
Yes.
Okay. You just don't know why they were there and what they were doing there on that day, right?
Yeah, it seemed like kind of a spontaneous.
So if Audrey Boudreaux was looking for a wedding dress on 10/22 of 2009,
Your Honor, objection. Counsel's stating facts not in evidence.
Yeah, there's no Audrey Boudreaux, Mr. Pryor.
I'm sorry, Judge.
Audrey Boudreaux.
Baratori, Judge. I'm sorry. I said Boudreaux. It's Baratori. I got the name wrong.
Fair.
No, is that the correct name?
Audrey Baratiero or
Baratiero.
Melanie Boudreaux. Yeah.
I got them backwards.
They both were in Hawaii, but yeah, I'm not sure which one you're
With her.
correct. I think some of
They
them,
were not on that particular day. They were looking for wedding dresses, right?
I don't, other than that search, no.
Okay. Judge, I think that's all I have. Thank you.
All right. Ms. Blake, redirect.
Thank you, Your Honor. We'll start with the last question. You were asked about Audrey Baratario and searching for wedding dresses. Are you aware if Audrey's married?
At the time, I don't believe she was, no.
anything in your investigation or records you reviewed that showed she was engaged?
I believe she'd mentioned, or I don't think she was actually married. No, I'm trying to remember now. I don't think she was.
And you were asked about the attempted shooting of Brandon Boudreaux. And I think you indicated Chad has not been charged in that. Is that correct?
That's my understanding, yes.
And in relation to Charles Vallow, Chad has not been charged. Is that correct?
Yeah, I believe so, yes.
Are you still part of any active investigation in those cases?
Am I on to testify in those cases?
Are you assisting in any further investigation if there is any going on?
No,
And those are being handled by agencies in Arizona, is that correct?
I believe so, yes.
So all you can say right now is that Chad hasn't been charged.
Yeah, I haven't really followed that portion of it, no, other than what was included in this investigation, yes.
You were asked about those Ned Snyder searches. Are you aware through your investigation who designated Charles as Ned?
I guess Lori calls Charles Ned is the first time where you sort of hear that on the body cam footage. Charles is relaying that Lori refers to him as Ned. I don't know where that name comes from, no. I don't know if she brought it up or if Chad gave her that name. I don't know how that worked.
And the searches from Chad were being done around the same time Charles is reporting that Lori's calling him Ned Schneider.
It's around the same time, yes.
Asked about the potential for someone else to use Chad's email to do some searches.
Potentially, yes.
Did you find any searches in related to that email, to Chad's email regarding divorce or separation?
Not that I recall.
You were also asked about people changing phone numbers to hide an affair.
Yes,
Are there, in your experience, do people involved in criminal activity also switch phone numbers?
yes.
And then there was some talk about Melanie. Actually, let me back up. There was some extensive discussion regarding the killing of Charles Vallow and where JJ and Tylee were. Do you know where they were at the time Charles was actually shot?
I don't believe they were there. I believe the report said that Lori took the children to, I think they went to Burger King or something. But I don't know if that was corroborated or not.
And we talked about the phone attribution earlier, and with one of Chad's numbers, you'd made reference to attributing that number to him in part because of a mortuary call. Do you recall that?
Yes,
And that call to the mortuary, do you recall what day that took place?
I believe it's July 11th, 2019,
And when was Charles killed?
the same day.
And do you know where the mortuary was located that he placed that call to?
In Arizona, but I don't remember which city.
And Charles was killed in Arizona?
That's correct.
Then you were asked quite a bit about Melanie Gibb and David Warwick. Their names came up at least. Is that fair?
Yes.
Did Melanie, through your investigation, did you determine whether, or was there anything to indicate Melanie Gibb or David Warwick profited from JJ's death?
Judge, objection goes beyond scope.
Overruled.
I did not learn of anything why they would benefit from JJ's death now.
Thank you. I have nothing further.
All right. I don't believe that opened any doors for additional recross. Did you have anything, Mr. Pryor?
Judge, I would have a couple subjects, but if the court's determination is that there's nothing open for recross, I'll defer to the court's wisdom.
All right, that'll conclude then the testimony of this witness. Practical Agent Heidemann, you are done testifying. Is this witness going to be recalled, do you believe?
She is going to be recalled by the state. I'm not sure if she's being recalled by the defense.
Not by the defense, Judge.
Okay, since you are going to be recalled, I'll just remind you there is an exclusionary order in place. You're not permitted to discuss your testimony or review the testimony of other witnesses in the case in between now and the time that you're recalled. If you don't comply with that order, you may be prohibited from further testimony. So please comply with that.
Sure.
All right. You can go ahead and step down then, and I'll inquire of the state momentarily as to who they will be calling as their next witness. All right, who will the state call next?
And thank you, Your Honor. I'm just looking at the time. I think it's about 15 minutes to 10. The next witness, I believe, will be on the stand for quite some time. I'm not sure if the court would like to take a break now or how soon you wanted to take the mid-morning break.
My preference is to probably get started with this witness if they're a longer witness anyway, and then go for maybe another 30 minutes.
So trying to take a break at about 10:15.
I think so.
I will try to keep an eye on the clock for that. The next witness is Detective Duncan.
Okay. Go ahead and call your witness then.
Swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you.
All right, the court will note that the witness, Detective Duncan, has been placed under oath. I am going to inquire as to whether or not you have viewed any of these trial proceedings because it is being live streamed. Have you listened in on any of the testimony that's been provided in trial since the case started?
I have not.
All right, thank you for that affirmation. With that, Ms. Blake, you can go ahead and inquire on direct if you'd like.
Thank you, Your Honor. Would you please spell your name for the record?
Good morning. My name is Nathan Duncan. It's Nathan. Last is Duncan, Duncan.
Where are you currently employed?
I'm currently employed with the Chandler Police Department in Chandler, Arizona.
What is your current title and or position?
I'm currently assigned to the robbery homicide unit as a detective.
How long have you been with that unit?
Robbery homicide unit, I've been there for 10 years.
Have you held other positions within the Chandler Police Department?
I have. I was hired with Chandler Police Department in year 2000, June of 2000, went to the academy, graduated in September. After graduating from the academy, I was a patrol officer for roughly 3 years. And after that, I went to the property crimes unit as a detective for approximately 11 years.
Do you have any specialized training in order to be a law enforcement officer?
So our training, like I stated, in June of 2000, we attend the Arizona Law Enforcement Academy as a program. I believe it was 16 weeks. And then afterwards, we attend a field training program with our own department. After that, every year, for the last almost 24 years, we go through advanced officer training, and we also do additional training in our specific area of expertise, if you would.
And were you working with the Chandler Police Department on July 11th of 2019?
I was.
Do you recall if you were on shift?
I was, yes.
And do you recall responding out to a report of a shooting?
Yes.
Do you recall where that was?
The report of the shooting on July 11th, 2019 happened at about 8:36 a.m. at the address of 5531 South Four Peaks Place in Chandler.
And you said the call came in about 8:36 a.m.?
Correct.
Were you one of the first responding law enforcement?
I was not.
Do you recall approximately when you responded out?
I would have arrived probably 20, 30 minutes after that original call.
When a call comes in of a shooting, who goes out first? Is it a patrol officer or a detective? Can you talk a little bit about that process?
So the immediate response to a call for service, in this case, a 911 call, a patrol officer will respond, or multiple patrol officers will respond for that call of service. They will get there, triage the situation, assist in any way they can. and then determine what they have. If additional resources are needed or investigative resources are needed from detectives, then detectives will be called in.
And in this case, did you learn who made that 911 call?
I did.
And who was that?
Alex Cox.
Did you learn what was reported?
Yes, Alex had contacted 911 and reported that he had shot his brother-in-law, Charles Vallow, in self-defense.
Prior to that, had you ever heard the name Charles Vallow?
I had not.
Had you ever heard the name Alex Cox?
I had not.
When you arrived on scene, were you given specific assignments?
Yes, in homicide investigations, we were given assignments. The case agent in this case was Detective Nathan Moffat, and he will assign tasks, if you would. In this particular case, I was assigned along with Detective Coons to document the crime scene.
And I think you've said, and that's common in a homicide investigation.
Yes, there are many multiple parts to go into a homicide investigation, interviews, scene processing. So we have a team of 6 at our particular unit, so we will divide up tasks.
At some point, did your role within the investigation change?
It did.
And can you talk a little bit about that?
So with the promotion of Detective Moffat in June of 2020, I was assigned to be the case agent in the death of Charles Vallow in June of 2020. However, I had done work prior to this date on this case.
And backing up to that July 11th, you're one of the scene detectives.
Yes.
Can you walk us through what you observed when you got there?
So as our job as a scene detective, we are there to document the scene, and we are assisted by crime scene technicians in this effort. So our first move that we'll make is we'll have the patrol officers who are present, who can provide some of the information to us as to what took place, give us a briefing. From that point, one of our crime scene technicians will enter and take overall photographs. And during this time, we will make observations of our own. The crime scene in this case was very simple relative to other crime scenes. The residence on Four Peaks Place, single family residence. You enter the residence through a front door on the west of the residence. As you enter, you come into a small foyer, and then it opens up into a large living room. This one was unique in which there was a wood plank floor. There was no furniture in this living room. There was mirrors along the north side, an open window along the east side, mirrors on the wall on the south side, and mirrors on the wall on the west side. So as indicated, it was very sparse. There was no furniture at all. Inside, when making my observations, I noticed the body of a Caucasian male, later identified to be Charles Vallow, laying on the west side of this room. North of where he was laying, there was an aluminum baseball bat. And then a little bit north of this was a baseball cap that we had found out was worn by Charles earlier. To the west of Charles' body, there were 2 .45 caliber casings that were recovered. Also noted during this time was a bullet strike and a lodged bullet, or what we refer to as a projectile, that had lodged into the baseboard along the east side of that particular room.
And as you walk in, that's your initial scene observation.
Yes.
As part of the scene detective, or just as part of the investigation, did you make observations regarding the body of Charles Vallow?
I did.
And I guess to back up a little bit, are you aware as to Charles' condition when first responding officers arrived?
When first responding officers arrived, he was pronounced dead by the Chandler Fire Department.
So upon your arrival, he'd already been pronounced dead.
That is correct.
Do you know if prior to your
There were reports in that Alex Cox had done CPR. And there was also indications, evidence left behind that the fire department had placed EKG or AED pads on Charles to determine whether life-saving efforts were needed.
And you said it was reported that Alex had done CPR. Did you observe any signs that would support CPR having been performed?
So in examining, looking at Charles' body and the position that was found, his head was to the north and his feet were to the south and his arms were to his side. I did see one wound consistent with a bullet wound in the front lower left quadrant of his torso. And that's the only wound that I noticed at the time. His shirt was cut open. He had a black t-shirt on. It was cut open by fire department. And as indicated, AED pads and EKG leads were put on for medical intervention. I did notice a lot of blood that was present on the floor or surrounding his body. Did not notice a lot of blood, which in my opinion, having given CPR and having been shot multiple times, I believe there should have been more blood.
And in relation to the CPR, had it been performed, you would have expected to see more blood?
I would have expected that, yes.
So based on your experience, you didn't see signs of CPR having been performed?
Correct.
And additional observations of Charles' body, were you able to see how many wounds he had initially?
So as indicated initially, it was just the one that I noticed with the front of his body, the lower left quadrant of his torso.
And at some point, did you notice any additional injuries to Charles' body?
I did.
And can you tell us what those were?
So in this case, in all homicide or death investigation cases, when the medical examiner is coming out to assist in these cases, the body is considered evidence, and we do not touch the body until the medical examiner arrives. They have jurisdiction over the body. So my initial observations were that one wound consistent with a bullet wound to the front lower left quadrant. After the medical examiner arrives, they take their own series of photographs, and we provide them with information that we know at the time. At that point, the medical examiner will then begin to examine or manipulate the body as they choose. During this time, the AED pad that was placed in the center of Charles's chest was removed, and an additional wound consistent with a bullet wound was noticed in the center of his chest. Additionally, when Charles' body was rolled, there were 2 additional wounds on his back consistent with bullet holes.
And when you talk about the 2 injuries to the front and the 2 to the back, did they appear to be, one being an entry wound, one being an exit wound, did they appear to be linked?
We try not to make that determination at the time. A lot of that goes in as far as entry, exits, and we also do the totality of the circumstances. In this case, Alex had mentioned that he had shot twice, so we would assume that they would be entrance wounds and exit wounds.
And so you talked about, Alex said he'd shot Charles twice, correct?
Correct.
Are you aware of what else Alex had claimed in relation to the shooting?
As indicated, he claimed that he had shot him in self-defense. He had indicated that he had the baseball bat, and Charles had struck Alex in the back of the head with the baseball bat and refused to drop the bat, and that's when he shot him.
And based on your observations, were you able to form any opinion in your training and experience as to where they would have been where Charles would have been in relation to the shooting?
Yes. So Alex had informed us that he was standing in the southwest corner of this particular living room, as described, and he was facing in a northeast direction, and he and Charles were face to face with each other. He indicated that he shot him twice standing up, and he shot him twice in the chest from a standing position.
And are you aware, if you talked about the medical examiner's office showing up to take Charles' body?
Yes.
Do you know if an autopsy was ultimately conducted?
It was.
And are you aware if there was any determination made as to whether or not Charles would have been standing when both shots were fired?
So the two wounds, according to the medical examiner, the wound described in the center of the chest was front to back, exited his back, and it was slightly at a downward angle. The second wound that I'd mentioned, the lower left quadrant, that bullet traveled upward at a very steep angle, exiting the back of Charles's shoulder. When examining and observing the original scene, we had brought Alex back to do what's called a walkthrough to have him explain exactly where he was when all this took place. He indicated, like I stated, that he was standing and fired 2 shots standing, and while Charles was in front of him. Prior to Alex coming, we made the decision to cleaning up the blood that was left. And when we did clean up that blood, noticed a indention in the plate wood flooring that was near Charles's left shoulder, and that would be consistent with the exit wound on that back left. Also near Charles's left shoulder was a bullet or a projectile that was present when first responders arrived. So based on the autopsy reports and the scene evidence, the first shot fired on Charles would have been the center of his chest, exiting the back and then lodging in the baseboard. The second shot fired at Charles would have been while he was laying down on the ground.
And you talked about this room either not having furniture or being very sparsely furnished. Based on your investigation, were you able to determine whether or not a struggle had occurred?
Obviously, one thing we look at, we're trying to determine and prove or disprove the self-defense claim. And with the room being sparsely furnished, we were unable to see if anything was knocked over, broken, anything like that. Charles did have some wounds or some abrasions to his knees. He was wearing shorts at the time. So he had some abrasions to his knees and also some scrapes on his hands or arms, some minor scrapes there. So those two things would indicate that a struggle took place, but other than that, there was nothing that would indicate that.
And you talked about, we've talked a little bit about the blood in relation to at least the CPR. Was there any additional blood located in the residence?
There was.
And can you talk a little bit about that?
So Alex had indicated that he had washed his hands in the sink at the residence. The only other location that blood was present, besides underneath Charles's body, was on the faucet in the kitchen sink.
And was this, based on the report of the shooting, was this investigated as a homicide?
Yes, it was.
And we talked a little bit about, you ended up taking over the case or being assigned the case agent or the lead on this in June of 2020.
Correct.
You initially responded out on this July 11th date of 2019. Did you continue to work on the case after July 11th, 2019?
Unfortunately, right after this homicide, I had another homicide, so I did not work on it for a period of time. I then picked up this case and assisted Detective Moffat roughly January of 2020 with looking at phone extractions and iCloud information.
And when you picked up again in January, you talked about you started looking at phone extractions.
Correct.
As part of that, did you end up seeking some search warrants?
I did.
And was one of the devices that you reviewed the content of Charles Vallow's phone?
Yes, it was.
And do you recall how you came to be in possession of Charles Vallow's phone?
Yes. Through our investigation, we had determined that Charles's phone was pretty much the catalyst of an argument that occurred between Lori and Charles on this day. After the shooting, or shortly after the shooting, Lori had left the house, taking Charles's phone with her. She would later return that phone to detectives, and that phone was now in our possession, and an extraction was done on that actual device.
And did you in fact review the extraction?
I did.
And in reviewing the extraction, was there a significant amount of information contained on that device?
Yes, there is.
And as you went through it, did you look at things that seemed to have significance to you in relation to the investigation?
Yes,
And in preparation of your testimony today, did you prepare an exhibit related to that content?
I did.
Do you believe that it would aid in your testimony today?
Absolutely.
Do you believe it would aid the jurors in understanding the evidence and information?
Yes.
Your Honor, I'm going to ask that the witness be shown what's been marked as State's Exhibit 49. I do have a copy for counsel and a courtesy copy for the court as well. Again, as with some of the last exhibits from the state, these are printouts of a PowerPoint. The PowerPoint itself is on a jump drive.
Counsel, these are three different exhibits, right? Or looks like they're all the same.
I believe there are some other exhibits. That should all be one exhibit. Or
And is it your position I get one of these?
yes, there would be a copy for you.
Thank you. Thank you, officer.
And Detective, I would ask you to just look through those if you could.
Okay. Okay.
Do those appear to be an accurate depiction of the PowerPoint that you prepared?
They do.
And again, they are taken from an extraction from Charles Vallow's cell phone. Is that correct?
That is correct.
Did that include looking at an iCloud account?
It does include an iCloud account. Yes.
And does it include messages or other content from that phone as well?
Yes, it does.
Your Honor, I would move for the admission of State's Exhibit 49.
No objection, Judge.
All right, Exhibit 49 will be admitted, and again, this will be actually the PowerPoint on a digital format, and the court has reviewed a printed copy of that. Ms. Blake, with that being introduced, if you'd like, I think this would be a good time to stop for the morning recess before we start with the publishing of this, if that's where you're headed.
That is where I'm headed next, Your Honor.
Okay, let's go ahead and take our mid-morning recess then, 30-minute recess, and we will be back on the record after that.
Thank you.
Thank you.
All rise, please.
Okay, so we have our morning break. Let's take a look quickly at
Witness the lies.
I didn't lie to you on that polygraph, I promise.
The cover-ups.
I could see his brain.
The moments they confessed.
I grabbed one of the kitchen knives. I killed him.
Outrageous police interrogations.
I know, I forgot the head. I wanted the head.
You have to see to believe.
Oh my God.
Law and Crime interrogations. Subscribe today.
that sounds like that would be interesting. Okay, let's take a look at Twitter and see what observations have been made, which may not have jumped out at me. The key one that struck me yesterday was how Chad told his daughter Emily that he wasn't coming back. If he was innocent, you would expect there wouldn't be any issue with him coming back, because why wouldn't he? Let me refresh the Twitter thing. Let's see. Doesn't look like anybody has tweeted anything in the last 15 minutes. Somebody is contending that the only reason the FBI got involved in the case was to get money from the state of Idaho for their work. That seems kind of lame. Let's see what is... Not much on Twitter today. Surprised we don't have anything from Nate Eaton or Gigi or Lauren. Interesting. Okay. Let's take a look at... Oops, let's see. Oh. Let me see. Where's my playlist? Oh, here we go. We've got Jesse Kershevsky, 2 hours long statement ahead of her sentencing. So let's listen to what she had to say since we followed that case. Oops. Let's see. It looks like I've got it muted.
Please bear with me because this will take a lot of time, but there is a lot I need to say. Before I read what I wrote, I want to go backward for a moment and share some of Lynn's words. Days after Lynn died, I found a large envelope full of letters all from Lynn, 10 in total written to my mom, Jenny, Anthony, Corrine, Jim, Judy, Jean, Keith, Lisa, Scott, and I, all dated between September 3rd through the 16th, 2018. These letters contain personal things as well as things I have never known. These letters were admitted and published to the jury and briefly mentioned during sentencing, at which time some called them goodbye letters and others said suicide letters. But nothing was read from them or shared, and as I sit here today, I want to be able to share 2 of hers before my own. The first is what she wrote to me, that was Defense Exhibit 506, starting with page 18. Jesse, I love you as if you were my own child. There is so much you don't know, so much most people would not understand about me. I have concealed so many secrets that the guilt is too much to carry any longer. My dad was my world, and when he died, a part of me died with him. Life wasn't what it once was. My loss turned to depression that was a daily struggle inside me, to where I tried to numb the pain with drinking combined with my prescriptions to forget life. Times used to be much simpler than today. Madison is where I was raised and where I had called home until I was kicked out of town. My dad has never been so disappointed in me as he was that day. He eventually forgave me, but not my mother. I was forever a disappointment in her eyes, and she never let me forget it. Back then, I first got into heavy drugs, and for that, I needed money. A friend and I began getting high and robbing homes. We mostly stole checks to obtain money. Remember years back when you went to prison for stealing from your mom and grandma? I was so disappointed in your behavior because I stole from strangers, not family. As I said, times were different back then. My punishment was that I had to leave Madison, my home. My mistakes have cost me my whole life. I have done the same things over and over for so long, looking for a different outcome. In the end, it is just a slow walk to the bitter, sad truth of regret that weighs heavily on me, where I foresee no future left. As much as I have tried to move forward with my personal demons, like to come trampling into my dreams of fear, loneliness, despair, and death. Upon leaving Madison, I became only more heavily involved in drugs. I have tried every drug, my favorite heroin. It was such a push. I'm so proud you never seemed interested in drugs. Don't start now. The drugs today scare me. Too many people experimenting with people's lives. For me, it was all about drugs and money, how to get more of both and not get caught. I have spent years trying to figure that out. Twice I was close to robbing a bank. I used to watch a bank in McGuanago for so long I actually thought I could pull it off, but never moved forward in my plans. Later, going to prison myself was a wake-up call until I found out my dad died and I couldn't go to the funeral. I snapped. Everything changed. Doubt, speculation, confusion. Sure, I filled the voids best I could, looking for any way to avoid the inevitable. But no matter what I did, my dad was still gone and I was still in prison. Another failed mistake, and this time there was no goodbye. I withdrew, shut down, my anxiety was maxed. I was paranoid of everything and everyone. I had COs and inmates out to get me on a daily in prison, and no one believed or helped me. I was released as a different person. I never went back to my passion of hair. I drank myself into deep depression and began the drugs again when the prescription didn't seem to work. As you have heard, my mom and I were never close, like your mom and you. But like you, I was an only child, like you, so when my mom first started to need help and started to forget things, I was there. I began helping her and going up every couple of days. I thought she would be better with me. If anything, things were only worse and harder. She remembered enough to remind me I was a mistake. How my dad believed my lies and wasted money time and time again, and how my father went to an early grave because of my incarceration. It was hard on me, and I was conflicted because my duty was to care for her, but it was emotionally tough on me. Over time, I got a better understanding of my parents' finances, and what's truth was why I continued to help when I didn't want to. In my eyes, we were both failures, her as a mother and me as a daughter. I ultimately couldn't be around her anymore, listening to her accusations of me stealing from her. She kept threatening to change her will, and I was not going to lose the money I felt entitled to. I don't really know where our relationship went wrong, but in the end, I said and did things I can't take back. I live with it every day, and it haunts me. I had no right. I was raised better than this, and I am now taking full responsibility as I should have years ago. I spend every day with regret, worry, and dread. I have not told a soul the truth until now, although KD did figure out some while we were high together. I'll explain more on that later. I have been afraid daily of being arrested for her death. I cannot go back to prison. I lied to everyone about everything for so long to oblige my own selfishness. I tried to build up the courage to confide in your mom or you so many times, but I couldn't put that on either of you. My mom was sick and dying. I helped her along. 2 days before she died, I spiked her hot tea with water and 12 bottles of Izine. I saw a TV show where a girlfriend tried to kill her boyfriend, that there's a chemical in it that's deadly. Her boyfriend didn't die. She was charged. My mom was never my dad, but what I did was wrong. I believe all of my ailments of sickness sense is payback for all of my wrongs I have done in life. I was senile to believe I could do something like this without consequences. Do you remember after her death, your mom came up to help me pack up the house? I couldn't be there alone, and she woke up to me destroying the basement. My mom came to me that night, and it scared the shit out of me to where I never slept the same again. I drink with too many prescriptions to numb the pain until I would black out, for the weight of my wrongs is heavy, way too heavy to deal with. I sit in misery and self-pity reflecting on my life, for I have helped, borrowed, and gave everyone, trying to build forgiveness for my actions. I thought I would be happy having more money, bought the condo, sold my parents' home, closed my mom's estate. This condo was a huge mistake. I hate it here. The neighbors are not friendly. One admitted he thought I was a drug dealer. Do not keep this condo. Sell it and take the money and run. Had it not been for the rambling to KD, I would have had the money to get out here, maybe even get the side-by-side with your mom. The aftermath of my breakdown with KD was my next nightmare. He was the one person who knew enough about my mom's death and my hand I played in it. He blackmailed me for almost a year and was terrified. I was terrified with anxiety. Do I keep paying him for his silence? Remember all those checks I wrote you? That was why. He tapped me out a large chunk of my inheritance, but kept me from prison. Never, never tell your secrets to your drug dealer, ever. Afterward, it ruined all my plans. I had planned on my saving grace was when Katie overdosed and died, before I was broke. That's when I became obsessed with trying to build my nest egg back up. I cheated the system any way I could. My credit has never been better thanks to a new life with money. I got every credit card I wish I could with limits I never had. lines of credit and loans. My plan was always to max out debt before I die and live it up. I learned with my mom's estate by attorney Bob Gonzalez that you only pay the creditors that file a claim. If they don't file or they are out of luck. Keep that in mind when you handle my estate. Jesse, listen to me when I say, use the new will. Anthony doesn't need the money. I want it to go to you. I have spent months lying to you about everything, and you deserve so much more for putting up with me. I only wish I could do more. You are hard-headed like your mother, and if you still insist on Anthony being a part of the old will, then remember to try Anthony in the estate and see what he does. See if he helps you, see if he fights you on issues. Put an ad in the paper for the creditors, only pay the creditors that file a claim, give Anthony $10,000, $15,000, make accounting paperwork to match, showing the account, wait 2 to 4 months and decide and see what Anthony does or says. Then either correct paperwork or file by Anthony, have or do correct paperwork, file new will, removing him. Contact Bob with any help or issues. But word of advice, easier to submit new will. I know Keith, Jim, or Corrine will fight you every step of the way, and might influence Anthony too. Do not let them walk all over you. I left you in charge because can handle it. I do not want Jim or Keith in the condo. I am not trying to control how you handle things. I just want to help and prepare you for them so they don't walk all over you. I have argued with you many times about my will. I know you always hated talking about it, but remember, I prepared everything so you wouldn't have the paperwork mess I had to deal with. I want you to live without the worry and stress because you and you alone have been here. When I've been at my worst, I've had enough money for a cushion for you, but to listen to me here. I know you don't want to upset anyone, Anthony, but that's not on you. I changed my will because I wanted to. It's my wishes. Jesse, I've cheated, lied, and stole my whole life, and for me, I would do it all over again the same way because I loved it. I don't want that for you. I know you've grown past all that. I can see how happy you are and lovey-dovey with Scott. I hope one day you have a child of your own because you are an amazing mom to his kids. I want to take my mom's antique charm bracelet to pass it on to your family. Kids were never in my cards. I had abortions because I wasn't ready. You are the closest to my own. I love you as if you were my own and hope you know that. You have been my rock. You are always here for me, and you never complained. The reason I've told you things I never wanted you to know is because I don't ever want you to be like me. I have done so many things I am not proud of. Looking back, I should have been locked up for life, and that's half of why I can't do this anymore. I'm so sorry for the messes I have caused you along the way. The pain in your ass I have been, and all the lies I told you, and mostly for putting you in many uncomfortable positions for me. I am sorry I asked you to help me die. That look in your eyes when I asked was enough to know that it was a mistake to ask, and you would not help. I want your mom and you to be okay when I am gone. I have done all I could to help and take care of you both. There will be even a few more surprises before I am gone. Jesse, I am not proud of the mistakes. Lord knows I have more than I can bear anymore, but I am so proud of you. You were stupid young and had mistakes, and you turned your life around. You learned from it. I'm scared daily of the things I have done. I don't know what I did with that. I don't know what you did with that gun you took away from me. That was beyond stupid, but I hope you got rid of it. I don't need you getting in trouble because of me. Truth is, that was the second gun from both the same place a few weeks apart. I drilled the hole incorrectly in the first. Being a felon, buying that gun the way I did, I kept waiting for the police to show up. I am sorry about the lying and damage I have caused these past few months. I don't know how to make that right. I worry about your mom too. I wish she'd find a decent guy like you. Whatever you do, I know you will help your mom, and I want you to, but do not let her even know what you obtained when the estate is closed. Don't give her too much at once. I'm sure you know, just like I used to. I'm sure just like I used to worry about you when you first got out of prison, your mom isn't good with money. Remember that credit card I had for her for emergencies? She always racked it right up. None of us ever have been good with money, the more I think about it. I never had so much fun racking up my credit cards these past few months. I wanted to make sure you were out of debt and could build for your future. I am only sorry I lied about it to you with the cancer. I had reasons for all I did. I just didn't know at the time. I hope you understand and forgive me one day. Make sure you take the Swan ashtray from the bathroom and the old pinball game in the bottom dresser drawer. Throw away my drug stash, dining room hutch. My important papers are together and also my lockbox. Make sure you think about all I said. Anthony will take extra care of your mom. Remember the good days, not the bad. I love you, Jesse. Love, Lynn. September 16th, 2018. Destroy this letter after reading. I don't want everyone to know the things I have done and told you. No good would come from it. The other I want to share is the last known letter Lynn wrote and was dated October 1st, 2018, and goes along with the tape recording she made, which was buried in Whitnell Park, that was Defense Exhibit 506, starting on page 26. Jesse, I am sorry to leave you like this, and I am assuming you will be the one to find me. After all you have done for me, all the times you have saved my life, I know if it wasn't for you, I would have been dead months ago. You have been my rock. You're stronger than anyone I know, and I know, and now I need you to take care of your mom for me. I know you did all you could to keep me alive, as being sick, complaining about being sick, and just sick of it all. I want to be free from the pain, and this is my time. I love you and your mom very much. Take care of each other. I am following the yellow brick road to see my dad. Jesse, stop listening to this tape and put it safe and hidden. I, Lynn Hernan, being of sound mind and body, want to state I record this statement of record today, Sunday, October 1st, 2018. I have been sick long enough, seen enough doctors to know that I will never be the same, and I no longer want to live my life as it is. I have done things that I cannot take back. I took a life that I had no right to do. I am choosing on my own free will and my own time frame to take my own life. I have tried more options than most would know, from purchasing a gun, overuse of medications, to poisons. I assumed poison would be the fastest and easiest. Little did I know it would be just as hard. Visine is one I stumbled across prior and tried without success, but ended up using it. Now for almost 3 months. The way it makes me feel is something undescribable. My body is numb. I feel no pain from my constant pain, and it makes me tired, where I sleep a kind of sleep I haven't experienced in years. I became quite fond of it. It was a new medication to me. I enjoy my medications, and now Visine has become one of them. At first I was drinking a bottle almost daily, mixed in my water or vodka, then increased over time. I was purchasing Visine on my own for over a month until I could no longer drive or shop. I did stock up on it and had my caretaker, Jesse, did not know what I was doing with the Visine until recent. Jesse is one person in the whole world who knows everything I went through and out, except my mother's death. Seen all the good and bad. She has been there when I fell in the middle of the night, shit on myself, or puked, and came to clean it up. She caught me in the act of trying to take my own life. She has seen me at my worst, and there regardless. I owe her everything for all she has done. Her mother, my best friend, and Jesse are my only family left, and mean more than I know. I did the unthinkable to Jesse, and it ruined her. For months I lied to her, and I had her lie to everyone in the process. It destroyed her. She knew I was suicidal, but I told her I was sick and dying from colon cancer. I didn't want to see people or talk to them, so I had Jesse lie to everyone. I didn't want anyone to know. Truth was I was sick with colon cancer. Truth was I wasn't sick with colon cancer or dying. One afternoon, Jesse came to check on me, as her usual, caught me unexpectedly while I had a gun to my head. She screamed at me, crying that when I came clean with her about not having cancer and lying. I lied to her because she was so concerned about being suicidal that saying I was sick was easier to do. I never seemed seen her so hurt, saying I was sick I'd never seen her so hurt, and she lied to everyone. She knew and didn't know what to do now. She told me that I was either going to get help or go to the hospital, and she was calling the cops. I let her take me to the hospital the next morning where they admitted me, and I stayed for weeks. I wanted to get better for her, but deep down my decision was made long ago. I cannot go on anymore. My mom's death haunts me daily. I tried to take my life twice while in the hospital. I had a camera put in my room. After arriving home from the hospital, Jesse stayed the weekend, and per my discharge, I was to get in home care that week. I had planned on different ideas, but Jesse did not leave me alone, ending the weekend. Came and went, and now it's Sunday morning. I took all of my remaining Visine bottles and put them into my last water bottles. I have stashed Visine for months and been emptying over time to the water bottles. I now have 3 bottles filled with only Visine, over 30 bottles, and will start drinking those tomorrow along with my medications. I am hoping that by drinking an extreme amount, this will work as planned. I am choosing this on my own terms and how I see fit. No one played any part in this decision or acted in it. I have chose to drink Visine to end my life. Look into my mother's death to better understand. I came into this world fighting like hell and lived a good life, and I am going out of this world on my own terms. Soon I will see my dad again. I would like it known that Jesse and Jenny are in charge of my final wishes. They know where the paperwork is and what to do. I want to make sure it is known in case she doesn't listen, because she didn't want any issues. I changed my will in July 2018 to remove Anthony and Corinne Poza, along with a letter as to why. They haven't been my friends or hear from me. Do not let them, but keep their nosy asses out of my shit. I want to thank Jean for all of her help. Judy, I am sorry. I know you strongly disagree with suicide. Keith, I love you as a brother, but do not want you to obtain the. Jim, I don't want you to get a thing of mine, and I don't want you or any of you in my condo. I made a list of items for you in the last year with others. To date, you owe me a ton of money. That list is now null and void. Fuck you all. None of you gave a damn about me, and it was about what I could do for you, or no contact at all. Jenny and Jesse, I am sorry for everything. I hope you know I will no longer be in pain and be with my dad watching The Wizard of Oz. There is no place like home. Sorry, most of this is terrible to read, and I made a tape after I wrote it. Lynn, I sent your mom a rent payment and car payment. You will also relieve a check to buy until the estate is settled. 2 days later, on October 3rd, 2018, I was with her in the morning. I left to run some errands and to return later in the day to find her dead and life forever changed in that instant. I will fill in some gaps shortly, but I want to fast forward 9 months to July 9th, 2019, where I was arrested and have been in custody ever since. I was first revoked and sent to prison for almost 2 years on decade-old forgery charges for assisting in her suicide. On June 4th, 2021, the day before I was to release from prison, I was charged with first-degree intentional homicide and thefts. I was transferred to Waukesha County Jail, where I have remained incarcerated 2.5 years on $1 million bail awaiting trial. It has now been over some days it feels like yesterday. Others, it's as if all time stopped. Or others, I feel as though I've been locked up forever, screaming and fighting. Well, nobody is listening or doing anything in this reoccurring nightmare, only by a protective order. Meaning I wasn't allowed to speak many conversations with my attorneys, not to take the stand, which I deeply regret. It was a huge mistake in my eyes. I went against what I have always said and believed for people who are innocent. I was not able to take the stand because we were talking daily about all that was happening during trial, which nobody got to know. I sat here every day during my trust and I bit my tongue, which is extremely difficult. And today, as I sit here at my own sentencing, again, I have listened to everyone else talk and what I should have done long ago. It is time to speak out. There is a time for everything, a time to be silent, as I was, and a time to speak, as I am now. I know it doesn't matter what I say here today. It won't change my conviction or what you already decided for my sentence or what people may think of me, but these things I need to share and say because there was and is so much to this case. First, though,
The jury is present and accounted for.
All right, thank you. Please be seated. All right, we are back on the record now on KCR 22-21-1623, State of Idaho versus Chad Guy Daybell. Just concluded our
And Detective Duncan, we've already talked about, but just to remind the jurors, the information contained in this slide, can you please read this into the record?
Yes, I can. Hello, Chad. I hope you are doing well. This is Charles Vallow from Arizona. We really enjoyed having you stay with us back in November when you came to the Preparing a People conference. I appreciated you taking the time to talk to me about the book I've been working on. Well, more than 6 months later, I still haven't made much progress on it, but I feel an urgency to get it done. As the managing partner of Right Planning Group, I'm going to have the opportunity to speak at various conventions beginning in the fall, but everyone says I need to have a book available that summarizes my life and shares the principles I follow. So I will cut to the chase. I'm willing to pay you well to help me get this book into shape as my ghostwriter. I really liked your autobiography and the tone you took in sharing experiences without preaching. Is there any way you could come here for a couple of days and help me get the book underway? I feel talking in person would be much more valuable than a phone call or video chat, mainly because I would like you to read through some of my journals and explain to me how the publishing industry works. It would help me know whether I truly have a book in me and whether you want to team up on it. I played minor that my audience could relate to, along with the knowledge I've gained running my own company. So I do feel the book would contain valuable information even beyond the convention circuit. I'm out of town until Sunday, but I would gladly fly you down here next week before the holiday and cover your expenses. You could stay in our guest room like before, or in a hotel if you prefer. I hate to take you away from your family, but I know this book is vital to my speaking success. I understand the project, but I would definitely make it worth your time. With admiration, Charles.
And through your investigation, what did you to this email or this message, if anything?
So this particular message was all indications in Charles's phone fictitious, and this was not created by him.
Bit what you were looking into.
Yes, in January of 2020, when going through these extractions, I was aware of multiple investigations. I was also aware of the attempted or the shooting on Tammy Daybell, as well as Tammy Daybell's death. In addition to that, this is attempted shooting at Woodrow.
Looking through this phone extraction as well as others, were you also paying attention or looking for anything in relation to those other investigations that you thought could be helpful?
Yes, while going through these records, this particular record and subsequent records, I was mainly focusing on the Charles Vallow investigation, but anything that I saw that could have been pertinent to the locating JJ and Tylee and the other investigations, I would pass that along to other investigators in Idaho.
And as we talk through this, just to make clear to the jury, do you know how many, did Lori have a brother named Adam Cox?
Yeah. He did.
Did he also have a brother named Alex Cox? Or did she also have a brother, Alex Cox?
Yes, she did.
Was Adam Cox at any point
Fair. He did not stay with us in Arizona in November. Who are you lying to now? Trying to destroy another family? You're evil. Period. I may take JJ back to Houston unless you have a great explanation for all of this. Message from Charles to Lori, June 29, 2019 at 6:04 a.m. Just so you know, I have Tammy, Chad's wife email address. I will you're up by now. You have until 10 a.m. your time to respond, or I see us.
and Tammy Daybell still alive?
Yes.
And you had that email appears to have been written by someone holding And we talked about any indication did in fact email Tammy. Did you uncover anything in your investigation regarding whether or not he ever attempted to visit her in person?
I did not.
And looking at this date of June 29th, this is just a few weeks before Charles is shot and killed. Is that correct?
Correct.
And turning to the next slide, when we talk about the email, is this the one you were referencing?
Yes, it is.
And could you read this into the
Daybell, and it was sent to tdaybell@sugarsalem.com on June 29th, 2019 at 9:06 is the stamp that was on the email. Tammy, my name is Charles Vallow. I have some vital and disturbing information Lori, I know you don't care much. I know you don't much care how I feel, but just imagine this. How could my actions or breaking your heart result in what you've done? You accuse me of infidelity, but it's you who have been having an affair. It just keeps killing me. Maybe that's your goal. How can you live with yourself destroying our life, Mel and Brandon's, probably Mel and Brendan too. Now add Chad Daybell family, and you've got a home run. The fact that you continue to go to the temple after all you've done shocks even more. Shocks even me. There really is something wrong with you. I really don't want to do what I have to do, but you have to be exposed for what you really are. You won't even deny it or talk to me as to your reasons. That's what's amazing to me. You could allay some of what's about to happen, but I don't think you will. Lying has become second nature to you. You have been impressive in blaming me for all that's happened. You have destroyed me. I've never been lower in my life. It's you that has done it. Please tell me why, please. I will slow or minimize what's about to happen. It's you who has caused it. We have a son to raise, but that's all we have in common. I will work with you in his best interest and will be there Monday evening. You owe me an apology for all the false accusations you've made. You know I've been entirely faithful to you since the first day we met. I deserve an apology from you. Please respect that much.
So this message is sent around the same time the messages are being sent to Chad confronting him about the affair, correct?
Correct.
And this is also sent around the same time Charles reaches out to Tammy.
Correct.
Through your investigation, did you learn whether or not there were any divorce proceedings that had been going on between Charles and Lori?
I was not aware of any.
Do you know through your investigation, did you learn if at times they had separated?
There was indication that they were separating, living in different locations, yes.
And on this next slide, can you talk a little bit about what we're seeing here and then read these into the record?
Yes, once again, additional messages found on Charles Vallow's device. Charles to Lori, July 1st, 2019, 10:31. I'm going to Idaho first to meet with Tammy Daybell. Lori to Charles, July 1st, 2019, 10:32 a.m. She won't see you. She is my friend. She won't listen to you. Go ahead. You're ridiculous. Are you coming to JJ for the 4th or not? Charles to Lori, July 1st, 2019 at 10:37 a.m. Then you tell me why you used my name and a fictitious email to send a BS email about a book I am having him ghostwrite for me. It's fraud and a lie. There's no other reason for it other than to get him to Arizona or AZ, get him in AZ and have an excuse for his wife. Charles to Lori, July 1st, 2019, 10:38 a.m. You did this. I had nothing to do with it, and you know it. Also, he did not stay with us in November. I will find out.
Did you learn what that reference of he did not stay with us in November was in regards to?
That was in regards to the letter found on the Chad's device, and then also another, what is a KK Walker email where Chad was being requested to come to Houston. I believe those were the two.
And one of the emails referenced him being in Arizona the previous November.
Correct.
And that would have been November of 2018.
Correct.
And there's also a response there from Lori saying she's friends with Tammy.
Yes.
Did you also review data in relation to devices or accounts linked to Lori Vallow?
I did.
In your review of those, did you find any communications between Lori and Tammy?
I did not.
Any indication that they were friends in those devices, at least?
No.
Did you find communications between Lori and Chad?
I did.
And on this next slide, can you talk a little bit about what we're seeing here and then read it into the record?
So once again, in Charles Vallow's actual phone extraction, the day of his murder, and these text messages take place between 7:35 a.m. and 7:37 a.m. between Charles and Adam Cox, who was Lori's brother. Charles sent Adam a text, "Al is here." Adam responded, "At Lori's?" Adam responds, "Really? I wonder why he never called me back." Adam responds, "They're planning something." Charles responded, "Absolutely." Adam responded, "I was supposed to spend the night at his house last night. She probably blocked that." Charles responds, "What you do is up to you."
And up until this slide, or actually, excuse me, just the slide before this, we're in July when he and Lori are exchanging those messages. Is that correct?
So from June 29th was when that letter was discovered and the communication starts. So up until then, yeah, or from that day on, yes.
And you indicated this is the day that Charles is killed when these messages are exchanged.
Yes, it was.
And again, Adam Cox is one of Lori's brothers,
Yes,
and he was not a suspect, correct?
correct.
And when we look at the time that these are exchanged, it's early in the morning.
Yes.
Were there any additional communications on Charles' phone? Charles was shot and killed shortly after these messages were exchanged.
Correct.
Little bit about that you reviewed. And actually, I apologize. I'll get this submitted to the court first. And we've already discussed a little bit that as part of your investigation, you also reviewed some accounts associated with Lori Vallow.
Yes.
Did those include some iCloud accounts?
2 of them were yes.
And do you recall what those iCloud accounts were?
So the first iCloud account that Lori used was Lori 4 style, the number 4. So Lori, the number 4 style at iCloud.com. And from that extraction or from that information, we were able to determine a second iCloud that was created, which is lollytime at iCloud.com.
And in reviewing and specifically looking to that Lori for style, was there a significant amount of information?
Yes, there was.
Excuse me, on that account or link to it?
Yes, there is.
And from that information, and then also same question with the lolly time, was there a significant amount of information?
Yes,
And in preparation for your testimony today, did you prepare an exhibit?
I did.
And does that exhibit pull some of the information that caught your attention?
Yes, it does.
And given the amount of information within those accounts, do you believe that it would aid you in your testimony today?
It sure would.
Do you believe it would aid the jury in understanding the evidence as well?
Yes, it would.
Your Honor, I'm going to ask that the witness be shown State's Exhibit 48. I believe defense has. And similarly, these are printouts of a PowerPoint, so we have an actual jump drive, but as a courtesy, we printed these out.
I already have done. No objection, Judge.
Okay, I'll just quickly review them.
And Detective Duncan, if you could look through those as well.
All right, I'll note there is no objection to the offered exhibit 48. The court will admit the exhibit, noting again, the actual exhibit's a PowerPoint XLS digital file, and what the court's reviewed is a print-off version of that.
Okay,
And does that appear to be an accurate representation of the PowerPoint?
it does.
Thank you, Your Honor. Now that it's been admitted, the state would ask to publish.
You may publish it.
And you talked about the first iCloud account. What are we seeing on this particular slide?
So in this particular slide, I'm showing you the Lori Forstyle at iCloud.com account name, username. Under this account, these 4 numbers are registered under that account.
And as you went through the account, is that where you located these numbers?
Yes,
And so these are numbers that ended up being associated with Lori Vallow, is that correct?
that is correct.
And looking at the next slide, can you tell us what we're seeing here and then read the messages into the record?
Yes, so on the iCloud account, Lori Forstyle, the following messages were seen between Lori Vallow and Alex Cox. On 3/9/2019 at 11:27 hours, Lori sent Alex a text that says, apparently it is tied to Ned being gone. There's an emoji in there, but the emoji is not included. Hopefully today or tomorrow. On 3/10/2019 at 8:41 in the morning, Alex sent Lori a message. Love you too. Have fun and get rid of Ned already. 3/26/2019 at 17:36 hours, Alex sent Lori a message. Ned is still alive, just confirmed. 3/26/2019 at 18:17 or 6:17 p.m., Lori sends Alex a message. It's not Ned, and it's a new one.
What about those messages caught your attention?
So in the weeks and months following the death of Charles Vallow, we received information that Charles was possibly killed by Alex because he was a dark spirit or a zombie. The name Ned is a name that even Charles would tell people that Lori was referring to him as. So the name Ned is the dark spirit's name that was given to Charles Vallow.
And in that last message, we see reference to it's not Ned, it's a new one. Did you learn anything in relation to what that message may have been referencing?
To me, and
Judge, I'm going to object. That calls for speculation.
I'll sustain that.
Through the investigation, you reviewed other phone records.
yes,
And did you discuss the investigation with other individuals involved in it?
yes,
And did you review reports and interviews?
yes,
And based on your review of that through your investigation, were you able to make a determination as to what that may have been referencing?
yes.
Judge, and I'm going to renew my objection that it's speculation.
And Your Honor, if I may respond.
Go ahead, Ms. Blake.
Your Honor, I think under the collective knowledge doctrine, the officer's already established that if he can answer from his investigation what he believed it to mean, and it in relation to, although I haven't heard it, any hearsay, I think under the collective knowledge doctrine, it's not being offered for the truth of the matter. It's being offered as to what the officer determined in the investigation.
All right. Well, go ahead, Mr. Pryor.
May I respond? Judge, using that notion that it's as part of the investigation, it still calls for this officer to make a guess as to exactly what is meant by a particular phrase. So regardless of the investigation, regardless of whether he's looked at documents, he's still guessing. He's speculating, he's hunching, And he's not able to do that, and he's not allowed to do that.
All right, well, there's been some additional foundation laid. At this point, I am still going to continue to sustain the objection, just looking back at the question, which was whether or not the witness was able to make a determination as to what that may have been referencing. So I do think it's speculative at this point, Ms. Blake. Any additional foundation you could lay may change that.
Through your investigation, did you learn if Charles was designated by any other names?
Yes.
And what were those names?
Garrett and Hiplos.
And based on that, what was your belief with regard to it's a new one?
A new entity or a new dark spirit.
Thank you. And looking at this next slide, can you tell us what we're seeing here and then read the messages into the record?
So on the Lori for Style account, you see messages between Nicole Earl and Lori Vallow. These took place on 10/19 of 2019. At 9:18 in the morning, Nicole sent Lori a message. "I'm not sure if you heard, but Chad's wife died last night." Lori responded at 9:33 a.m. "Oh my gosh, I did not hear that. I'm in Hawaii and it's 6 a.m. Lori responded to Nicole at 9:34 in the morning. "Do you know what happened?" Nicole responded to Lori at 9:37. "Yes, she awoke in the night coughing, threw up, collapsed, and passed away."
Through your investigation, did you learn on what day Tammy Daybell was pronounced dead?
Yes.
And what day was that?
October 19th, 2019.
So the same day these messages are exchanged.
Yes.
And we talked before that as you were looking through these, you were also cognizant of some other active investigations.
Correct.
Did you pass this information along to other law enforcement?
Yes.
And looking at the next slide, can you tell us what we're seeing here and then read it into the record?
Once again, these are messages between Melanie Gibb and Lori Vallow on the Lori for Style account on 10/19, 2019. Melanie Gibb sent Lori a message at 1:16 p.m. "I heard what happened to Chad's wife. Oh my gosh." Lori responded to Melanie at 1:18. "Hello, what?"
So on that last slide, we saw communications between Lori and Nicole Earl that took place in the morning hours of October 19th, correct?
Yes, correct.
And now on this slide, later in the day, these are messages between Melanie Gibb and Lori Vallow.
Yes.
And what was it about these messages that caught your attention?
What caught my attention is the communication between Melanie Gibb and Lori Vallow, indicating that Lori was unaware that Tammy had passed away.
And that's even though there were the messages with Nicole Earl earlier in the day.
Yes.
And on the next slide, can you tell us what we're seeing and then read it into the record?
So on the Lori for Style account, on November 22nd, 2019, a text message is present from Lori Vallow to Colby Ryan, who is Lori's son. "I text Ty to send it, but I haven't heard back yet. She will probably just do it before she tells me. Hope you got the Venmo. Ty said she sent it late. I'll call you when I get a break. Hope you're having a great day. I love you so much."
And in this message, were you, based on your investigation, did you know who Ty was that they were referring to?
Yes.
And who was that?
Tylee Ryan.
Did you learn when the last known sighting of Tylee was?
I believe it was the beginning of September 2019.
So this message is sent months after the last known sighting.
Yes.
And then you had indicated you also looked at another iCloud account.
Yes, so from the Lori for Style account led us to the lollytime@icloud.com. This information provided indicated that this particular account was created on July 1st, 2019. And the cell phone numbers listed are the numbers that are attached to that account.
So this particular account was created just 10 days before Charles is killed.
Yes,
And again, during this time, Tammy is still alive. Is that correct?
yes.
Turning to the next slide, can you tell us what we're seeing here and then read it into the record?
Yes, this is communication found on this iCloud account between Lori Vallow and Alex Cox. On July 9th, 2019 at 1:49 p.m., Lori sent Alex a message stating, "So the plot thickens. Call me when you can." She sends another message to Lori, or another message to Alex Cox, 7/9/2019 at 9:50 p.m. "Getting sleepy, so I'm going to need you to stay close to me the next couple days. Mel too. She can't go to Utah. They are planking some kind of intervention, but want Mel out of the way, so I'm left alone. I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you."
And when these messages are copied over, do you copy them over as written?
Yes, I do.
So some may contain spelling errors,
Correct.
and the only difference is you did not include the emojis.
Correct.
What is it about these messages that stuck out to you?
This is 2 days before Charles would have died. Also, in looking at Charles Vallow's account, Charles was talking with Adam Cox about planning some sort of intervention, if you would, and talking to Lori about her radical beliefs and the letters that he had found. So this stood out to me as some sort of plan that was taking place.
And again, this is just 2 days before Alex shoots and kills Charles Vallow.
Yes.
Were you able to determine who the Mel is that's being referenced in that second text?
That is Melanie Boudreau.
And who is she in relation to Lori Vallow?
That is Lori's niece.
And then moving to the next slide, can you tell us what we're seeing here and then read the messages into the record?
So what you're seeing here is oftentimes in what appears in an iCloud or what doesn't appear in an iCloud, you can capture in an actual phone record. Phone records and phone extractions are different. Phone extraction it's a copy of the actual device, where a phone record or a phone, they call them call detail records, are actual phone calls, text messages that are sent, and records are retained by the actual phone carrier. So in looking at a timeline of Charles Vallow's death, I was able to look at Lori Vallow's phone call detail records, and I noticed that there were phone or messages, text messages between Lori and Chad the day of Charles Vallow's murder. The times are at 6:12 a.m., 7:01 a.m., and 7:33 a.m. There's a record that this text occurred, but there's no content of what the actual text is.
And through your investigation, were you able to determine a span of time in which you believe Charles Vallow to have been shot?
Yes.
And when was that?
Based on our investigation, you look at the record of Adam Cox and the last message sent by Chad and Adam, 7:37. So he arrives at the residence based on location data on Chad's phone.
And Sorry to interrupt. I think you said Chad's phone. Do you
Sorry,
mean
I
Charles?
apologize. On Charles' phone. So Charles Vallow had location data on his phone, so it shows when he arrives. So it's around that 7:30 timeframe that that Charles arrived at the Four Peaks address, and then obviously the call placed by Alex Cox at 8:36, indicating the shot. So somewhere between the 7:30 and 8:30 timeframe.
And so these messages with Chad are essentially stopped just before Charles arrives or around the same time.
Correct.
And then turning to the next slide, can you tell us what we're seeing here and then read them into the record?
So these are text messages between Lori Vallow and Chad Daybell, and the text messages were on July 18th, 2019. Lori sent Chad a message. I just got the letter from the insurance company saying that I am not the beneficiary. It's a spear through my heart. Who do you think he changed it to? Brandon or probably Kay? He left nothing for JJ. Chad responded to Lori, wow, that's terrible. There's no way to find out. Lori responded to Chad, I might be able to see when I get his computer on Sunday. I could check the emails sent to the insurance company. It will show change in beneficiary. He must have done it recently. Chad sent Lori a message. It seemed you would have had to agree to the change. Maybe your name was forged. You should have a good paper trail to prove it.
And then going to the next slide, is this a continuation of that conversation?
Yes, it is.
Would you please read those into the record?
Chad sent Lori a message stating, I love you. This is terrible, but it is probably another step in bringing down the Gadiantons, especially Brandon. Lori sent Chad a message to Chad. Nope, he can change it anytime he wants. He's the agent and anyone can change their beneficiary anytime with their own signature. I'm thinking it must be Kay. Chad sent a message to Lori. It will be interesting if it got changed after he had 2 bullets in his chest.
Charles was shot and killed.
Correct.
What was it about these messages that stood out to you?
Obviously, what stood out is the Lori's concern with beneficiary money from a life insurance policy that she felt was coming to her after Charles's death.
And at the time these messages were exchanged, had Arizona publicly released how, or if you recall, had they released how Charles had been killed?
I don't recall.
But it's just 7 days after.
Correct.
And the indication to you was at the time Charles was killed, Lori would have believed she was getting insurance money.
Yes.
Did it also appear Chad would have believed that?
Judge objection calls for speculation.
Sustained.
Looking at the next slide, can you tell us what we're seeing here and read it into the record?
So this is another message on the Lori Lolly time, I believe. Lori Vallow to Chad Daybell, 7/18, 2019 at 12:19 hours. Lori says, so I talked to the insurance company. He changed it in March. So it was probably Ned before we got rid of him. They can't tell me to who, of course, but it's done. I still get the $4,000 a month from SS.
Did you learn through your investigation what the SS stood for?
Yes.
And what was that?
Social Security.
And did you learn through the investigation whether or not Lori was getting Social Security money or if her kids were?
Yes, she was. Yes.
And looking at this next one, can you tell us what we're seeing here and read it into the record?
That was a message from Chad to Lori on 7/26/2019 at 8:13 p.m. Tonight I figured out who I feel like. I'm a grown-up version of Harry Potter who has to live with the Dudleys in his little space under the stairs. Every few weeks I get to escape and have amazing adventures with my goddess lover. But then I have to return to my place under the stairs feeling trapped, but I sense permanent freedom is coming.
And this message would have been just 15 days after Charles' death.
Yes,
And was Tammy Daybell still alive at this time?
yes.
And then turning to the next message, if you could let us know what we're seeing here and then read it into the record.
So on 7/30/2019, Chad sent a message to Lori. An SMS message is just a text message that read, I got the inspiration to go back to my original death percentages that help us track Charles, Ned, etc. Tammy is very close. Her percentage has fallen steadily since Hiplos left. It is encouraging.
And through your investigation, I think you've already talked to us about it, but did you learn who Ned and Hiplos were referring to?
Yes.
And who was that?
And those were dark spirits that Ned and Hiplos and Garrett were dark spirit names referring to Charles Vallow.
And in this, there's reference to helped us, correct?
That's what I see, yes.
And this was from Chad to Lori?
Yes.
And then on this next slide, can you tell us what we're seeing here and then read it into the record?
So on this account was a text messages between Alex Cox and Lori Vallow, September 3rd, 2019 at 10:02 a.m. Alex to Lori. Network name is Anti-Layman. PW is too many kids.
And through the investigation, did you learn the last known sighting of Tylee was around September 8th?
Correct.
And the last known sighting of JJ was around September 22nd?
Correct.
And this message was sent on September 3rd?
Yes, it was.
So when the kids were still around?
Yes.
Your Honor, that exhibit is ready to be submitted to the court.
Very well. Thank you, Ms. Blake.
As part of your investigation, did you also review content from an individual named Zulema Pastenis's phone?
Yes, I did.
And you've already referenced and talked about looking into content on Lori's iCloud accounts, correct?
Correct.
And we just saw some of that.
Yes.
In looking at Zulema's phone and some of the iCloud accounts, did you end up creating another exhibit?
I did, yes.
And again, given was the content of Zulema's phone voluminous?
It was, yes.
And were you able to determine certain messages that you felt had evidentiary or that you felt were relevant to today's proceedings?
I did.
Do you believe that they would assist you in your testimony today?
Yes,
Do you believe they would assist the jury in understanding the evidence as well?
they would.
Your Honor, I'm going to ask that the witness be shown State's Exhibit 51. And similar to the last, these are printouts of a PowerPoint presentation. The actual exhibit would be a jump drive.
Very well.
And Detective Duncan, would you just look through those?
Okay.
Do those appear to be an accurate representation of the PowerPoint you created?
They are.
Your Honor, the state would move for admission of State's Exhibit 51.
No objection, Judge.
All right, Exhibit 51 is admitted. And again, that is the digital file on the thumb drive. The court has received a printed copy as well.
The NBA play-in tournament on TNT. We gotta win before these teams make it to the playoffs.
Pastenis.
Yes.
Through your investigation, did you learn who Zulema Pastenis is?
Yes, through our investigation, we learned that Zulema Pastenis was a friend of Lori Vallow.
And do you know if Zulema Pastenis eventually was married to someone related to Lori?
She was. Eventually, she would marry Alex Cox.
And we talked a little bit about Ned and dark spirits. Did those kind of things come up through your investigation?
Yes, they did.
And in looking in Zulema's phone, was there reference to things of that nature?
Yes, there were.
Your Honor, I would ask permission to publish State's Exhibit 51.
You may.
And looking at this slide, can you tell us what we're seeing and then read it into the record?
Yes, so on Zulema Pastenis' phone, an extraction that was actually done by the Gilbert Police Department. I reviewed this phone content and I saw messages between Lori and Zulema. So on May 29th, 2019 at 10:32 a.m., Lori sent Zulema a message that read, "Perfect. I found out there are 4. One is a level 4 entity. His name is Hiplos. The H is silent. The other 3 are level 3s. Let's do this." And the following message from Lori to Zulema, June 2nd, 2019 at 11:54 a.m. "Yes, it does. Let's put some fire energy towards Hiplos now. He is driving now, and today is the day. I can do it spiritually. Let's go to him and hover over the truck till we do it. Are you ready?"
And looking at the next slide, if you could tell us what we're seeing here and read these messages into the record.
So the messages continue. July 2nd, 2019 at 7:52 p.m. Zulema sends Lori a message that states, "Also, I was given instructions today to rip, tear, or burn the aura of Hiplos to let the body energy out so he can't re-enter." There's a message from Chad Daybell to Zulema on July 2nd, 2019 at 8:35 p.m. "I am very happy to find out these estates. You and Lolo have doing amazing work. Mother Earth is so grateful to you both. Thank you as well for your help with Hiplos. He is so very close." Chad then sends another message to Zulema on July 13th, 2019 at 9:57 a.m. "Hi, Zulema. Yes, I would be happy to give you a blessing, possibly this evening or tomorrow. It's crazy about Charles, but such a relief."
So in looking at that second message from Chad Daybell, there's a reference to Lolo. Did you determine who Lolo was in your investigation?
I did.
And who is that?
Lolo is a nickname for Lori Vallow.
Was there anything else that stood out about that message in relation to your investigation?
On the message, the second message?
Yes, the second message.
That Chad was thanking Zulema for her help with this evil spirit that Charles was referred to.
And this message was sent just 9 days before Charles Vallow was killed?
Yes.
And then looking at the next message, is there anything that stood out to that one about you?
Other than the last sentence, it is crazy about Charles, but such a relief.
Had you looked through these phones and iCloud accounts, did you ever see any indication of grief over the loss of Charles by anyone?
I did not.
And then turning to this next slide, I think you've already talked about the KK Walker. Can you tell us what we're seeing here, though?
Yes. So this is a email that came that we recovered from the kkwalker75@yahoo.com address. And this particular email was sent from KK Walker to chad.daybell@gmail.com on April 21st, 2019 at 6:20 a.m. Yes, April 21st, 2019. So the email reads, Dear Brother Daybell, hi, this is Karen from Vallow. I contacted you a couple weeks ago to see if you would be willing to come speak to our youth here in Houston, Texas. You said you probably could if there was a way to cover your expenses. Since then, I can't shake the feeling that you need to come share your story, particularly about chasing paradise. We are near the Houston Temple, and this summer our stake is focusing on family history work. My reason for contacting you again is that we have a stake youth conference planned for all day on Saturday, April 27th. The focus is on the temple, and I know you would energize the kids with your stories. We expect about 400 kids to attend, including some parents. I know it is extremely short notice, but is there any chance you could come? A high councilman is currently the main speaker, but he said he would be happy to let you speak instead. My husband and I have been financially blessed and would pay for your flight. We also have a casita attached to our house where you could stay and not be bothered. Also, my daughter mentioned the young single adults would love to put together a fireside on Sunday evening. I realize your main goal is to sell books, and that wouldn't be possible at these events, but I know the interest in your novels would skyrocket here. I'm sorry it's so late. If possible, please let me know as early as possible in the morning so we can include it in the Sunday announcements. Also, we'd want to get your flights booked. If you are able to do both events, we could fly you in Friday, then depart on Monday. Please let me know if this is possible. We would love it. Karen Walker.
And again, who did you link that KK Walker Yahoo to?
So the KK Walker was linked to Lori Vallow. The information provided by Yahoo indicated that the IP address where this account was set up was in Katy, Texas, near where Lori was living at the time. The date of birth associated with the account was a variation of Lori's date of birth, but the phone number linked to the account was the same phone number that Lori would use.
And again, the date on this is April 21st of 2019. Was Charles Vallow still alive at that time?
Yes, he was.
And was Tammy Daybell still alive?
Yes.
Did Chad Daybell respond to this email?
Yes, he did.
And if we look at the next slide, can you tell us what we're seeing here?
This is a response to that email obtained through Yahoo. Hello, Karen. Yes, I will be able to come. So let the wards know. I can talk to you later about arranging the flight, Chad.
And through your investigation, did you learn whether or not Chad did travel to this event, or in response to this email, I should say?
I don't have independent knowledge of whether he did or not.
Did you, in fact, pass your findings along to other law enforcement?
Yes, I did.
And other law enforcement may have followed up on that?
Yes.
And Your Honor, this exhibit is ready for submission to the court.
All right.
Detective Duncan, do you recall being contacted about a call placed to a mortuary?
I do.
And do you recall who contacted you?
Yeah, it was Agent Ricky Wright with the FBI.
And did you end up following up on a call made to a mortuary?
I did.
Did you learn where that mortuary was located?
Yes.
And where was that?
This is the Valley of Sun Mortuary located in the southern portion of Chandler, Arizona.
And did you end up recovering a copy of a recording of the call?
Yes, I did.
And was it actually a two-part recording?
Yes.
And Your Honor, it's my understanding that these exhibits have already been stipulated to by the parties. They've been marked as states 44A and states 45A.
That's correct, Judge.
Okay. And to be clear, explain what they are again, Ms. Blake.
They are a recording of the calls just referenced by the detective.
Okay, so each one of those exhibits contains a digital file of a recording individual.
Yes, Your Honor.
Okay. 44A and 45A are admitted.
And Your Honor, I do have a copy of those for counsel as well.
Judge, I have copies. Thank you.
Okay.
And I would, now that those are admitted, I would ask to be able to publish those.
You may publish them.
If I may have just one moment, Your Honor.
Third ring answer.
Funeral home.
Hello, my name is Sarah. I'm assisting them with their calls. How can I help you today?
We just had a death in the family, and we really don't want anything but a cremation, and then to send the cremains to a family in Louisiana. Just a simple, nothing other than a cremation and sending him to his family for a service in Louisiana. So, is there any way to know a ballpark price on that?
Yes, and I'm sorry for your loss.
Thank you.
Okay, let me transfer you over to the director who can assist you with the pricing. What is your name, please?
It is Chad Daybell.
How do you spell the last name, please?
Dabal, Daybell.
How are you related to the person who passed?
I'm his nephew.
And then also, this is for the Valley of the Suns in Chandler, correct?
Yes.
Thank you.
Yes, he lives there in Chandler. I live in Iowa, so I'm just trying to help out.
Oh, okay, thank you. Yes, what is your uncle's name for reference, please?
He is John Daybell.
And last name?
Well, Dabal.
Okay.
The same. John.
Do you have a middle name?
Myron.
Myron?
Yeah.
And Chad, what is your phone number in case we get disconnected?
Yeah. This number 515. I don't actually know my own number. Let me look real quick.
Thank you.
Five 402-0143.
Thank you. Is he at a nursing home, hospital, or residence?
He passed away in a hospital. I don't know the details.
Yeah, it's just for, to know, because sometimes it's different if it's a residential or hospital or a nursing home. Okay.
Thinking they're sending him to the medical examiner. I'm not sure. I should have had more information before I called. I'm sorry.
That's okay. All right. Cremation with shipping. To which, which city?
New Orleans. Again.
Okay, one moment, please, Chad. Stay on the line. Let me transfer you over to the director who can assist you with that.
All right. Thank you.
Thank you. Hello, Chad.
Yeah.
Thank you for holding. I do have the director, Carissa, on the line to further assist you.
Okay. Thanks.
Thank you.
And Your Honor, that was State's Exhibit 44A.
Okay.
And I would now ask to publish State's Exhibit 45A.
You may.
So, my name is Chris. I'm a senior director with Vallow System Mortuary and Cemetery. I understand that your uncle passed away.
Yes. And I'm just starting the process for the family. He didn't have many relatives. I'm his nephew. I live in Iowa. But what
So
they
sorry to
want
hear
to do is, it's sad to see him go. Yeah, I think he's going to the medical examiner. I don't know all the details, but what the family basically wants is just to have him cremated there in Chandler and then have its cremains shipped to New Orleans. And we'll deal with the service later. So just trying to get a ballpark price.
Okay, so for a cremation, we are able to do our cremation for $1,695. Now, what that's going to include is the transportation into our care, the transportation to and from our crematory, our basic professional fees, as well as our crematory fee. Now, there's going to be a couple other charges there for you.
Okay.
So we are going to have death certificates, which are $20 a piece plus a processing fee.
Okay.
A $15 permit fee.
All right.
And then we're able to do that transfer through the mail for you, and that's $150 fee for you.
Okay. Like UPS or something, I guess.
Okay.
So close, about 2,000 probably, kind of a ballpark, yeah.
Close to, yeah.
Okay. Well, that helps me a lot. I'm going to call one or two others, but I'll get back to you if we come that direction. Thank you so much.
You're welcome. If you need anything else, give me a call.
Okay. Thank you.
All right. Thank you. Bye-bye.
Bye.
Could I have a sidebar with council, please?
Yes.
All right, council, we had a sidebar just discussing scheduling here. We're going to go ahead and take the lunch break at this time. I am going to advise the jurors, you're going to have a slightly longer lunch break, maybe not slightly, probably more like an hour and a half than an hour based on some motions the court's going to hear outside of your presence during part of that break. So we'll probably have you returning for further evidence, hopefully around 1:30. And if we do that, I'll also inquire as to whether or not you think we could just go through 2 hours without an afternoon break, potentially if we start up around 1:30. So,
And I believe the state can do so as long as the jurors are good with it.
okay, I'll ask the jurors once you return back so we kind of know what is left in the afternoon after that. So we will go ahead and take our lunch recess at this time. I'll have the jurors be excused and we'll argue a brief motion after they've been excused from the courtroom.
All right.
Okay, I want to go over that phone call here in just a minute. Just as soon as they sign off here.
All right, thank you. Please be seated.
Reminds me of a certain song.
For those in the courtroom in attendance, you're welcome to stay for a motion hearing. You're also welcome to leave for the lunch break if you'd prefer to do that. It's a motion that we're going to just hear an argument at this time, whether or not it will be open or closed hearing. So if anybody does want to leave for the lunch break, you're welcome to. Otherwise, we'll proceed under this rule 32. Awesome. Thank you. We'll have the witness step down and return too. Sorry, I lost track of you still sitting up there.
Oh dear.
All right, council, we've got a motion in limine that was filed on April 15th by the state. It was filed on shortened notice just yesterday. I haven't expected defense counsel to be able to have time to make any filing in response. However, I've allowed Mr. Pryor an opportunity to review the motion and would permit oral argument. That hearing we're going to take up later after our lunch break. The question right now is the state did file this with a request for an expedited hearing, which I'm granting and having that heard on the merits today. Also under a motion requesting that the motion in limine be sealed. The court is holding a hearing at this time to determine on the state's motion whether or not the hearing will be sealed or will it be open. And so that's governed by our Idaho Court Administrative Rules 32. If the state wants to present any argument as to a basis for sealing the hearing this afternoon, I'll hear that at this time, and then I'll hear a response from the defense. So who is going to be arguing as to the motion to seal?
I will be, Your Honor.
Go ahead, Ms. Blake. And so to be clear, not into the merits of the motion in limine, just on the issue of sealing.
Correct. The state did file a brief. I recognize this is short timing and defense counsel may not have had an opportunity to do the same. In the brief, I think both in the motion to seal and then reference to the brief without getting into any argument lays out what the state's concern is depending on any ruling on the motion is why the state had requested that this be filed under seal. Depending on the outcome could have an impact in the future, but we do recognize that there is a jury that has been seated at this point and the court may determine that that is no longer a concern. So we would simply defer to the court on this and just reference back to the motion as to the state's rationale for the original request.
All right. Thank you, Ms. Blake. What's the defense response as to the issue of sealing or not sealing the upcoming hearing?
Judge, the state correctly pointed out that the jury's been sworn in. The evidence is has proceeded at this point. Without getting into too many factual issues, Judge, the information that's in question was listed as an exhibit and disclosed to the state on March 15th, I believe, originally in the list of exhibits and identified on that date. Then it was provided to them just before the start, a week, I think, before the start of the opening statements with the actual copy of that. So 3 weeks later now we're dealing with this. But just so everybody's clear, Judge, the information that I'm intending to use is going to be limited to impeachment. And as we all are aware, that if the information is used for impeachment, it's not necessarily admitted as evidence, but in all fairness to the state, it was provided as an exhibit. But the defense's intention is to use this solely for impeachment evidence.
All right.
So I would expect that this is nothing that needs to be sealed.
Okay. Well, the court in this case has previously many times sealed certain issues relating to evidence, mostly under Idaho Court Administrative Rule 32, which is a long rule with a lot of subparts. Somewhere among in there is a paragraph E, which is kind of a catch-all that indicates that things can be sealed if it's necessary to temporarily seal or redact documents to preserve the right to a fair trial. And in this case, of course, we had quite an ordeal and undertaking to find jurors who were not prejudiced by pretrial publicity, and pretrial publicity all seemingly tilted one way in the case, where many hundreds of potential jurors were unable to serve in this case because they already had a opinion that the defendant was guilty. So avoiding that and trying to get a fair and impartial jury led to the court's orders many times before on that very issue. The issue now where the companion case has already gone through trial and now we have a jury seated in this case and impaneled, my concern is alleviated as to picking jurors that are not predisposed to a opinion in the case based on pretrial publicity. And so without that concern going forward, the court will determine that the hearing does not need to be sealed. And so under Rule 34, the temporarily unsealed or temporarily sealed motion will be unsealed, as well as the hearing will be conducted in an open hearing today. When we argue that motion, counsel, I don't expect it will take too long to argue, but I indicated to the jurors they'd be back around 1:30 to start evidence again. So if we call the motion at about 5 or 10 after to give us a full hour for lunch and court preparations, is that time frame going to work for the state?
That will work for the state, Your Honor. Thank you.
All right. And will you be arguing that, Ms. Blake?
Yes, Your Honor.
All right. All right. Mr. Pryor,
And I'll be arguing it for the defense judge.
I understand that. So for terms of timing, then let's try to get that on the record. Let's call it at 1:05. All right. We'll be in recess on the lunch break until then.
All right.
Oh, imagine that. John Pryor's gonna argue for the defense. I never saw that coming. Okay, let's go take a quick review of that call and all of the problems. So here, let's listen to that. Here we go. I'll stop and start. Oh.
How can I help you today?
We just had a death in the family, and we really don't want anything but a cremation, and then to send the cremains to a family in Louisiana. Just a simple, nothing other than a cremation and sending him to his family for a service in Louisiana. So, is there any way to know a ballpark price on that?
Yes, and I'm sorry for your loss.
Thank you.
Let me transfer you over to the director who can assist you with the pricing. What is your name, please?
It is Chad Daybell.
How do you spell the last name, please?
Dabal, Daybell.
How are you related to the person who passed?
I'm his nephew.
Okay, line number 1.
And then also, this is for the Valley of the Suns in Chandler, correct?
Yes.
Thank you.
Yes, he lives there in Chandler. I live in Iowa, so I'm just trying to help out.
Okay, he lives in Iowa. The deceased is in Arizona. Okay, let's continue.
Oh, okay, thank you. Yes, what is your uncle's name for reference, please?
Oh, and he wants the remains shipped to Louisiana. So we've got 3 states involved. Oh, and the deceased lives in Texas. So that's 4 states. So let's continue. Oh, let's see. We've got Iowa, Arizona, Texas, and Louisiana. Okay, here we go.
He is John Daybell.
His last name?
Well, Dabal. The same.
Spelled the name wrong.
Do you have a middle name?
Myron.
Okay.
M-Y-R-O-N.
He gave a false middle name.
And Chad, what is your phone number in case we get disconnected?
This number, 515. I don't actually know my own number.
Why not? Okay, let me check that.
Look real quick.
Let's see if he's got the correct area code. Okay, he did give an Iowa area code. I suspect he didn't go through the trouble of activating a track phone for Iowa, but maybe he did. Okay, let's continue.
Mm-hmm. Five 402 0143.
Thank you. Is he at a nursing home, hospital, or residence?
He passed away in a hospital. I don't know the details.
Yeah. He died at Lori's house.
No, because sometimes it's different if it's a residential or hospital or a nursing home.
thinking they're sending him to the medical examiner. I'm not sure. I should have had more information before I called. I'm sorry.
That's okay. All right, cremation with shipping. To which city?
New Orleans. Yeah. Mm-hmm.
Okay, one moment please, Chad, stay on the line. Let me
Okay.
transfer you over to the director who can assist you with that.
All right. Thank you.
Thank you. Hello, Chad.
Yeah.
Thank you for holding. I do have the director, Carissa, on the line to further assist you.
Okay.
Thank you.
Your Honor, and I believe the court indicated, but made the state publish State's Exhibit 45.
Okay. Was that the full extent of the call? Let me.
Yes, you may.
Thank you.
I think there's more to the call still.
My name is Carissa. I'm a funeral director with Vallow System Mortuary Cemetery. I understand that your uncle passed away.
Yes. And I'm just starting the process for the family. He didn't have many relatives. I'm his nephew. I live in Iowa.
Okay, so he doesn't have many family members. He claims he lives in Iowa. He wants the remains shipped to Louisiana. He died in Arizona, but he lived in Texas. And doesn't he think that a funeral home would get suspicious if they get the death certificate and they see that he didn't die in a hospital, but was a victim of homicide? And oh yes, I forgot. He had to look up the phone number. He had to look up the phone number he's calling from when they ask for it. So, yes, yet another red flag. Okay, let's continue.
But what they want to do, yeah, sad to see him go. Yeah, I think he's going to the medical examiner. I don't know all the details, but what the family basically wants is just to have him cremated there in Chandler and then have his cremains shipped to New Orleans. And we'll develop the service later. So just trying to get a ballpark price.
Okay, so for a cremation, we are able to do our cremation for $1,695. Now, what that's going to include is the transportation and our care, the transportation to and from our crematory, our basic professional fees, as well as our crematory fee. Now, there's going to be a couple other charges there for you. So we are going to have death certificates, which are 20 away fees with a processing fee. $15 permit fee. And then we're able to do that transfer through the mail for you, and that's $150 fee for you.
Okay. Like UPS or something, yeah.
Okay.
So close to about 2,000 probably, in the ballpark, yeah.
Close to that.
Okay. Well, that helps me a lot. I'm going to call one or two others, but I'll get back to you and come that direction. Thank you so much.
You're welcome. If you need anything else, give me a call.
Okay. Thank you.
All right, thank you. Bye-bye.
Okay.
My dear beloved Uma.
There were so many lies right there. Let's see. Let's go back over to our main tab here while I get set up. Okay, let's resume with Jessie Kraszewski and her nearly 2 hour statement ahead of her sentencing by Judge Doro in her conviction for murdering Lynn Hernan with the eye drops. Now, she's already read in a supposed quote unquote farewell note where she leaves everything to Jessie and you know, basically says screw the real heir and so forth, and you know, you get the condo, blah 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 blah, and I killed my mother, and you know, using eye drops, and I'm gonna do eye drops here and so forth, and oh man, I can't believe she's got this much nerve. So let's see, here we go, let's pick it up.
I want to take the time to thank the jurors, the witnesses, court officials, from reporters, clerks, deputies, everyone and anyone involved in this case for their time, as it was very consuming. I also want to thank all of the attorneys I have had and you, Judge Doro. I have waited years for this trial and the truth to be known, but they got it wrong because nobody got to hear even half of what really happened. Nobody got to know the real story, or even the real us for that matter. Everyone on the state side gave the jury and everyone else who didn't know us preconceived notions of what our relationship was with Lynn. And the truth is, they didn't know her and they didn't know us to know any of that. Lynn was our family. Lynn was my mom's best friend. She was who my mom called for anything and everything. For me, at times, Lynn was a second mom, or Aunt Linny, or sometimes my best friend. She was all in one. At times, we were closer than I was with my own mom and some of my own family. Sometimes I went to her before my mom, or for things I couldn't or didn't want to go to my mom for. I want you to actually get to know who Lynn was as a person, the Lynn that I knew, the Lynn I grew up knowing most of my life, the Lynn I loved and cared for as my family, the Lynn I saw and was there for those days, daily for those last few months, versus the Lynn prior. Lynn loved to live life to the fullest. She was outgoing, adventurous, talkative. She would talk for hours. It was a running joke because sometimes my mom would fall asleep while on the phone with her. She loved animals. There wasn't a stray or shelter animal she would turn away. At times she'd have a bird or two, a dog here or there. She always had cats, at least two. Those were her favorite. Most were odd or had weird ticks. But she adored them. She gave them a home and they were her babies. She loved Summerfest. It was her all-time favorite. She went every year. It usually opened on or days around her birthday. She used to go every day, from morning festivals, watching all the live bands at the bars. She liked all different kinds of music, from AC/DC, Lady Gaga, Pink to Eminem. She loved black and white movies. Was one of her all-time favorites was Psycho Bates Motel. Others like Wizard of Oz, Sound of Music. She loved Marilyn Monroe, Betty Davis. Some of her favorite TV shows were So You Think You Could Dance, To Stars, Empire. She loved one of the main characters named Cookie, who played by Taraji P. Henson. Her fierce attitude, her style of clothes. She would call to make sure I was watching or saw the outfit she had on that day. And let's not forget her soaps, which she got me forever sucked into. General Hospital and The Bold and the Beautiful. She loved seafood, crab legs, and calamari, to spinach and artichoke dips, to a rare steak. If it was sunny, you'd find her out in the water. Lake, pond, or pool, it didn't matter. She'd be soaking up the sun, tanning on a floaty, or in a paddle boat with her sunglasses on her head, a cocktail in hand. A usual favorite was vodka with a splash of Coke. And I can't forget she'd have a cool cigarette lit in the other. She was a big smoker, smoking up to 3 packs a day. She'd put one out within minutes. lighting another. She was all about her appearance, bleach blonde hair with her bangs curled 2 inches out, teased with so much hairspray, they wouldn't move. She'd be tan, finger and toenails all painted, mostly neon bright colors. She wouldn't go anywhere without her lipstick on or high heel heels until she could no longer wear them. And lots of jewelry, big hoop earrings, rings, bracelets down both arms, and necklaces, mostly costume jewelry or family pieces passed down. She came on field trips, school field trips as Auntie Lynn with bags of candy. Everyone loved her. She loved to dye my hair, one color to the next, dress me up. I remember when I was younger, I would sometimes stay by her at night when my mom would work third shift. We'd watch MTV videos while eating snacks. When I came home from my dad's in Florida one year with lice, after my mom tried everything and couldn't get rid of them, ready to shave my long hair, as I sat crying, she called Lynn the beautician for advice and venting. She recommended kerosene, said it would hurt and burn, but they would be gone. She was right on all of those. In middle school, when I was having issues with some of the older girls, they came to my apartment looking for me, but she was there, waiting for them. She was tired of the school not handling the problem, so she took it into her own hands and scared the crap out of them. Or when I was older, or when she moved as I got older, friends and I would go over by her place after Skate U because she lived within walking distance. She was the cool aunt to hang out with. She would come to the campground by my mom and I where we would camp for drinks and bonfires, but leave at the end of the night because she wasn't a camper. She wanted her bed in a bathroom. My high school boyfriend and I would go out to her lake house on the weekends. She first taught me to drive, or should I say tried. She had a little red Fiero, but we gave up laughing because I couldn't figure out stick shift. She was really teaching me to drive long before I was age. So when we went out to eat or to the bars around her old place on Lake Phantom, I could drive us back home because she would have a few too many. She took me to Planned Parenthood to get on birth control without my mom knowing for a whole year. She threw my high school graduation party at her lake house. My whole family came. She was so excited. She loved being the host of all hosts for cooking.
Sorry, I didn't realize the tab had crashed. I was looking something up for a rental inquiry. So let me take a look at how far back it crashed. Let's see. Okay, it looks like about 4 minutes ago. Okay. Let me get it all set up and we'll do it again here. Backing up 4 minutes. Okay.
Without my mom knowing for a whole year. She threw my high school graduation party at her lake house. My whole family came. She was so excited. She loved being the host of all hosts for any get together. She was known for cooking, appetizers, dips, Chex Mix, and so much more. She was a shopper. She had so much stuff, and she was always picking up more. She was a wheeler and dealer to get the best price. She loved going to Menards, Kohl's, Sally's, or even the dollar store. Those were just some of her favorites. My mom and her loved going to rummages on weekends. It was their thing. She loved shoes. She once had a pair that she liked. She would go back and get in every color. Anytime she found something, whether it was clothing, decorations, anything, she'd always go back and get a second for my mom or I or others. My mom and her have had so many of the same boots, coats, decorations, plants, and more. We spent holidays and birthdays together as family, and she went all out. She would get so excited and kept pulling out more gifts hidden away, it was overboard. She was good at picking out things you needed, wanted, or you knew you would like. She loved going out to eat at her favorite restaurants or meeting at her usual bars for drinks. She loved being the beautician because she could make her own hours, working where and when she wanted. She never had a lot of money, but she was happy and did all she could for anyone. That was the Lynn before she went to prison for her 5th DUI, and it all changed. While there, she lost her dad. She was not able to be there with him, say goodbye, or go to the funeral. It crushed her, broke her, and she was sad, angry, and depressed, and was put on medication. She came out a totally different Lynn than we ever knew or saw. The only one constant was her drinking before and after. That stayed the same. She drank a lot. Maybe if anything, it got worse after because she wasn't doing much outside her home. Even when she was on extended supervision, she drank. She had bottles hidden around her apartment, so when she had home visits with her agent, they wouldn't find them. I know this because even when I was there, at her apartment off of Sunset Drive in Waukesha, the first place she got after prison. Back then, I was even helping drive her around to doctor's appointments and other things. That was in 2016. Little known fact, people who knew Lynn knew she hated Waukesha. She was living there because she was on supervision. Later, after her mom died, she purchased a Pewaukee condo. Her realtor pushed reluctantly because it was on the edge of Waukesha. She chose it. She got disability. She didn't like being around people, and she withdrew. She became a hypochondriac, anxious, paranoid, insomniac, and would only leave the house at certain times. Her health changed, as did her attitude and appearance. She would call us at all times, talking for hours about nothing and everything, sometimes making no sense at all, and completely drunk. She would sleep 2 to 4 hours and be wide awake, starting her day at 3, 4 a.m. outside, doing gardening or running errands, and home before 8, 9 in the morning, done for the day. Sometimes she would be drinking at all hours of the day and would be drunk by 8, 9, 10 a.m. Even her neighbor Jean testified. They had stopped regularly talking because of Lynn's drinking and an incident from when she was drunk. Another fact of Lynn, from the old apartment to the new condo, after some incidents there, she had also hid some of her alcohol bottles. If you remember, the deputy medical examiner testified about finding 2 bottles of vodka in the garbage. Lynn had 2 large garbage bins that she used for storage. They were never for garbage. She put towels, dishcloths, etc., and her vodka bottles, so they were out of sight. She used a plastic pick and save bag on the closet door handle as garbage and daily threw it in the large garbage bin in the garage. I also remember about 6 months or so before she had passed, I had went out to her condo with a friend whom she had never met. I was picking up a piece of furniture. We had went on a weekend morning, early, like 9, 10-ish, and she was drunk when we had got there. Offered us a drink and asked him if he had wanted some pills she didn't want. From her mom's death, she came into money. I never knew, nor was it my business, what she had got from her mother's estate. But due to this case, the money aspect, Lynn's letters, and her mother's death, I pushed my attorneys to look into it. According to the estate papers, her mother died without a will. The only heir was Lynn, leaving her as the sole beneficiary, which was odd because Lynn's letters state her mother was going to change her will to remove her. And then when the detective spoke to the cousin John, he stated another family member who was also an attorney handled the family's wills, yet he wasn't the one who handled her mom's estate. That leaves some more unanswered questions. I also noteworthy, her mom's estate left around $140,000 that went to Lynn. So how did Lynn buy a condo that she paid cash for and have $250,000 left to open a bank account, both right after her mother's death? Again, you heard her own words on how she was stealing from her mother while caring for her. Her mother found out, and that is why she changed her will, yet no will was probated. It's very frustrating. Everyone dug into Lynn's, my mom's, and my own financials between 2016 to Lynn's death, but nobody looked prior into Lynn's or her mom's bank accounts to verify or even discredit her letters, or to see when she came into that money, where exactly it all came from, and how Lynn had that kind of money. The state tried to say I stole over $500,000 from Lynn. Even the jury did not believe that. The problem, the only record obtained was her mother's estate, and it was during trial, and my attorneys never brought it up, so the jury never got to hear any of this. The state said they got records to review Lynn's spending habits and patterns, yet they didn't bother looking into prior to 2016. They only saw when she had money, not when she didn't, nor when she lived paycheck to paycheck, later behind on bills, or when she had no credit cards or no credit. It all changed when her mom died at the end of 2013. The only reason she even had an account at BMO Harris Bank was because that was where her mom banked. I bet if anyone looked at her mom's account her last years alive, you would notice some changes. If I had to guess, she was even added on her mom's account as a second signer, and money was taken and moved around. The day Lynn died, detectives took lots of photos. One was of a handwritten letter by Lynn to an employee from BMO Harris, who also was one of our defense witnesses. Lynn wrote her thanking her for all of her help with her mom's stuff. When my attorneys first spoke to her, she remembered Lynn until right before trial, and an attorney from BMO Harris got involved. And due to her being a witness for an alleged murderer who is all over the TV, nobody wants to be involved, let alone in business. So it all changed. She didn't remember Lynn, and she would only verify her signature and notary stamp. Lynn knew this person, dealt with her regularly to the point of writing her and talking about her. Doesn't anyone care to know the truth about it? This changes everything. She told her own truth in her own letters, but nobody, the detectives, the state, even my own attorneys, ever looked into any of it. The detectives had a person to pin her death on, and that was me. Case closed as far as they were concerned. Clearly, she got way more money that ever went through her mom's estate, and it wasn't from life insurance because she didn't have any. So where did it come from? What happened to Lynn's mom's will? Yes, this all matters because she took her mom's life and it haunted her to where she took her own. She stated that. I have every right to be upset, frustrated, irritated by all of this. I didn't do this, and nobody is giving a damn to look into what really happened. Her own letters said to look into her mom's death to understand. Even with the money, she was still on disability and still got aid from the state. She knew what and how to do things to avoid detection from the state. She was on Medicare, Medicaid, energy assistance, food share, and more. She was adamant how she moved money and what she paid from what account. Also, after her mom's death, when she first started doing her own will and other important decisions, writing constantly, talking about all of it and changing it. It was very odd, not normal conversation, and made all of us uncomfortable. I wasn't listed on her first will when it was done because I was in prison. She wanted me to be out and to see how I would do before, and she changed it shortly after. Everyone said during trial I reemerged or came into her life in 2016. Neither is true. I have known Lynn since I was little. That was proven during trial and when we first met and became friends and family with Lynn, and that never changed. We didn't drift apart. We didn't stop talking. I didn't reemerge or any of that. I was released from prison in February 23rd, 2016. Odd because my criminal complaint states on count 2 between January 2016 to October 3rd, 2018. Yet I was in prison till February 23rd, 2016. I did not reemerge in her life. I was in it prior, during, and after my incarceration. If anything, we were only closer because we had both done prison time, so we could relate and knew other things others did not from going through that. She talked to me on the phone, we wrote, she sent money while in prison, just like I did while she was. When I got out, she helped me rebuild, get on my feet, and start over. If she didn't want me around as others claimed, why did she call me and more than anyone else? Why did she put me and my mom on everything? Do you really believe over 3 years, as the state claimed, I stole over $100,000 in checks written to me, a loan, credit cards, and she wouldn't have known or seen? No way. Do you know how many times my name was listed on her medical records from those 2-week hospital stays she had? 43 times. 43 times. Yet Jim, her ex-boyfriend, took the stand and said she called him from the hospital. She didn't want him around her in her condo. How she had just met us, and that she was in rehab for alcoholism. Okay, that's right. He would know since he didn't even know she was in the hospital. Nor did he have to know anything or have anything to do with alcohol. He didn't regularly talk to her. And I have pictures that my attorneys didn't bother showing or asking Jim about. He knew me and my mom, and they were with us in Christmas when I was a little girl in our apartment. None of it makes sense. Lynn always loved Jim and cared dearly for his mom, Judy. He was the one who borrowed money from her all the time. And when he lost his grandma's house to foreclosure, she helped him pay for it. She helped him pay for hotels to live in. She helped him get his new house, even helped pay for his pool. When he went to jail, she bailed him out, paid his fines. I know this because she talked about it all the time. She hated cops, jails, courthouses. They made her nervous from her conviction and her incarceration. So when he called her, it was very hard for her to go there, and she went. He owed her lots of money, to the point where when she left information on it, letters expressing her frustration. She complained regularly in conversations about it and was upset he wasn't paying her back. He was the ex-boyfriend from back in the day who she really did love. They bar hopped, rode around together on his bike, partying while using drugs and alcohol. He lied to the police and on the stand about all of it. He is now sober, and that is only because he has no making all this up. I really have no reason to. It is not my intent to talk bad about Lynn. She is no longer here and cannot defend herself. I get that. Everyone makes mistakes and has things they aren't proud of in life. I want her to be remembered for her. I want people to know her, but I want people to know the truth. Lynn did not hide from her truth ever. Everyone who knew her knew that. She talked openly about drugs, alcohol, partying, her past record, past mistakes. All of it because, as she has said, she had lived one hell of a life and wouldn't change a thing. Those were her words. When she used to talk about all the things she had done, you heard about all my bad, and it isn't right not to hear about some of hers, since some of it affected her and her own death. These people weren't there. I was. I went to see her daily when she was in the hospital. I called her there. I spoke to the staff in person and on the phone daily. They all knew me. Jean came to the hospital. Judy, Jim's mom, talked to her while she was there because I told her when she called, like anyone else who called, even though Lynn didn't want them to know, I still told them. It was the same way with Jim's girlfriend. She found out when she called. They still didn't call or go see her after finding out. I told them she was in the hospital, even after Lynn asked me not to. I picked up her prescriptions with and without her. The pharmacy knew me. I went to Pick and Save with and without her. Her friend Lori, who worked there, also knew me. Some bank employees from her bank knew me, her jeweler, neighbors of her, and more, because I was the only one regularly around, just as I was the one she called when she found a Jeep to purchase. She had taken in her prior Jeep for service and ended up, while it was being serviced, found and purchased a newer Jeep. I was the one who she called when she needed and I was the one who took care of her and helped her. I was also the one who took care of her animals too. It was I who she called when she fell, needed a ride, needed anything, or just to talk. Do you know how many times I stopped whatever I was doing and drove out because she fell, needed water, cigarettes, vodka, wanted to go to the ER, wanted mozzarella sticks, a gyro with extra tzatziki sauce from Arby's, or a taco dip from Pick 'n Save because that's what she liked. Whatever it was, I went because that's what you do. I didn't say, hey, sorry, I'm out with Scott or this or that. No, I went because she needed me. You know why she didn't call Karina or Anthony? Because they were too busy with school or work and they had lives. That's what she said. She didn't call. They didn't call or come by her. She too stopped calling them. It happens. People have lives with other priorities. I made the time. I was there. I answered my phone. She was sick and she called me or my mom or Jean, her neighbor, and sometimes even Judy. I was also there spending time with her, watching her soaps, painting nails, having drinks, talking, and so much more. So when these people say I took advantage or that Lynn didn't want me around, it couldn't be further from the truth. During trial, it was brought up about what Lynn was and wasn't wearing the day she died. I want to get a few facts straight. Lynn didn't wear a bra or underwear, ever. And if you ever knew her, you would have known that. She didn't like them, nor did she own any. She used to wear swimming suit tops under her clothes in place of a bra, but hasn't done that in years. Her weight was constantly changing and she was retaining water. She had been wearing loose-fitting and long oversized t-shirts or button-up flannel shirts that she didn't have to pull over her head because it was harder for her versus buttoning or unbuttoning, as well as putting on other things that were too tight. She didn't need or want to wear shorts or bottoms while she was home, since the elastic at the weight was bothering her and irritating her dry skin. Said it felt too restricted for her stomach. She was also on and off with hot flashes and preferred less clothes, period. She had a hard time getting the shorts up and down without her falling. She did, however, keep a pair of large, loose-fitting shorts hanging on the bathroom door for when she needed. She had kept a blanket to cover up her waist and the top of her legs while sitting at home in her chair. She liked her feet always out from the blanket and never wore socks. And when the state said she would have had to put pants on if she was planning on committing suicide or knew somebody would find her, that is incorrect. She would not have. If anyone bothered to look at Defense Exhibit 541, page 1296, the hospital record shows under clothing what she was wearing when she was admitted. It says pants, shirt, footwear, no bra, no underwear. This was her, and she never cared about being naked, half naked, or who saw her like that. That is something that even her ex-boyfriend Jim should have known. And as far as her dad's dog tags, she always wore those. They made her feel close to him. These are things I know and most won't. Do you want to know why? Again, because it was me that was there. I want to circle back to the pets part. My mother and I were portrayed as cat killers too. What didn't come out and what was in Lynn's letters as she had left in Defense Exhibit 506, page 1, was another letter. It was just to me about her cat and how she wanted to poison her cat. I wouldn't use this because she died or wanted, nor would I give them to just anyone because they were older and they were used to being with just Lynn. I spent weeks checking out homes and people and who wanted them, and none were right. None of them felt comfortable for me to leave them with. So when I couldn't find the right home, we ended up taking them to join our 4 cats. Her so-called friend didn't step up, offer to check on them, feed them, or even take them. We did. Taking him to the vet, it was the best choice since he was in pain and suffering. The other one died 2 years later. I just wanted to clarify that. We are huge animal lovers, just like she was. That was another incorrect jab the state had said in trial because they knew how it would make us look. People love pets, so they would hate us even more to see that in the media. Now, when Lynn was sick, she didn't call those so-called friends to help, be there, etc. They didn't even know she was in the hospital. Hell, they didn't even know her birthday when asked. One had a birthday gift still 4 months after her birthday. Clearly, they didn't see or talk to her regularly. I don't know why my prior attorneys didn't listen and get the phone records. I repeatedly asked, like so many other records not gotten, because it would have showed they all lied and about talking to her those last years. Can you please explain why I need to make this up? Because it could and should have been verified. And it will one day be proven. So yeah, but they weren't close around those last few years as we were. We were her family, and we were there. If they were such good friends, even if she didn't want them there, why didn't they care enough to try and be there or call her? And I still called these people to notify them of her death. They weren't concerned. They didn't question how she died or ask many questions about her death or funeral or this or that, except when can they come to her condo to get what they want and who's getting her bracelet. I have never dealt with the death of someone, meaning handle the affairs, and I would never want to again. But what I can say, none of this was normal. She didn't want a funeral. She didn't want to be cremated. Like her parents, as it states in her own papers in Defense Exhibit 522, that would have never happened had I known about all this was to come. I would have had her body autopsied again in a heartbeat. Days after she died, I went and picked up her jewelry from the ME's office because she was being cremated, and secondly, because everyone was fighting over that stupid bracelet. People were upset and fighting over her things of value. Nobody talked about her. Her own estate attorney, who actually knew Lynn, another person my attorneys never called to testify, knew of these issues because I was calling and emailing her all the time because I was sick of the arguing over that damn bracelet and the other stuff. I sold it, yes I did, and because that's what she told me to do. It wasn't sentimental or a family item. She bought it a year before her death. Do you know why she bought it and all the other jewelry? Because of one of her many credit cards had cut the limit in half from $20,000 to $10,000 because she wasn't using it. She was so upset. She called my mom and I screaming for hours about it. She wanted us to take a trip, go shopping, anything to rack up her credit cards because it was her credit and she wanted to use it when and how she wanted. So she went shopping. She bought lots of expensive jewelry. And if you don't believe me, it is on her credit card statement. States Exhibit 108, page 18, 22, 25, and 29. I know these things. Her so-called friends clearly didn't. There was no funeral per her wishes, but I had decided on a dinner at her favorite restaurant, Open Flame, to remember her and get to know and meet these old friends of hers. One didn't even want to go because he was mad over Lynn's bracelet because he said he was to get it, but I found paperwork that told me not to give it to him. Her own words, and the letter stating he was not to get it after I had planned on giving it to him. In the last minute, he came and sulked the whole time. Other than that, we actually had a good time and enjoyed each other's company. Unlike what Jim said during trial, everyone talked of different stories and memories of Lynn while eating and drinking. We made possible future plans to get together for Lynn's birthday, put out some of her ashes, and talk about next steps. Lynn didn't want these people in her condo after passing. It was written on multiple things, and I still let them in. I had them all come out one weekend and pick up things they wanted, plus I had boxed up things she had originally wanted them to have as well. I tried very hard to get along with these people because they were at some point her friends. I didn't lie and say they weren't and make up things as they did to the police and during trial. Lynn did talk about these people. Judy, Keith, Anthony, Corrine, Jim, yes, she did, and a lot. And she was also upset because they weren't around. And it wasn't just her doing. What people don't realize is Lynn was not the same person she was prior to prison. She kept changing, and for some it was hard to be around her at times. And as people said, or as people do, they get busy. They have their own lives. It happens. You lose touch, out of mind, out of sight, and sometimes without meaning to. And before you know it, it's been first weeks, then maybe months without talking, and time just gets away from you without realizing. Maybe that's what happened. I really don't know. But what I do know is that they weren't around or talking to her. Not to mention, where were those same friends when I spent 4 or 5 months cleaning and emptying her condo and doing all the work? Corrine did come and help at times, but she was the only one. Her and I regularly spoke and texted for months about Lynn. Of her stuff, or her money for that matter. The state said it was all about money. That couldn't be further from the truth. If I wanted or needed money or anything else, all I had to do was ask, and she would give it to me, no questions asked. I think that's what bothers me so much because I never stole from her. Even years ago, when I did use my mom and grandma's name in forgery charges, it's embarrassed sitting here talking about how shitty of a person I was years ago and the wrong I did to my own family. I am ashamed, and it was brought back up, but I also admitted it. I served my punishment, and I changed from that person, and Lynn knew that. I am not proud to be a felon, but I also own what I did. I have forgery and misappropriate ID use convictions. And now a decade later, you are saying from that I turned into a murderer? There's no way. It's so far-fetched. So yes, it pisses me off, and I am outraged that the state assumes as their motive I stole from her. I had no reason to steal from her. None. She isn't here, so she can't say I didn't, so it's my word against the state, and without, they have no case. But you can see if you really looked or tried. I did not steal over $100,000 from her bank accounts, credit cards, and she didn't see it over a 3-year period. Her friend said she was talking about missing money. I'd like to know when, since they didn't talk to her and she never reported it to the police or even her bank when she was in the bank weekly. Nor did she talk to me or my mother, who she would have spoke to if there was an issue, immediately. My own mom was on her accounts as a second signer, and no, that wasn't added as fraud by me, as the state tried saying either, considering she was added on January 4th, 2016, while I was still incarcerated, as it shows on Defense Exhibit 586, page 1, and 587, page 2. She never called questioning her credit cards. She paid the bills, but you're saying she didn't see your notice? Because you would have heard it, considering the state had phone calls on her credit card, State Exhibit 104 and 105, but none stating issues or fraud. For 3 years, she didn't see her statements, use the phone, go to the bank, or function. That's BS, and you know it. She only stopped going out in her last month or two. And to say I killed someone who I considered my family, it just doesn't make sense. Lynn was very vocal. She did not hold back what she thought, ever. That is why I knew all about Jim and the money she gave him, because she was pissed, and she talked about it frequently. If she thought I or anybody stole, best believe, she would have done something, and immediately. She didn't hold back. If she had something on her mind, she was going to tell you. And if she ever thought, as the state alleged, I was poisoning her for months or even years, she would, and she didn't talk to it wasn't happening. She was no dummy. As she would say, you can't con a con, one of her well-known statements. As I said, she had her fair share of trouble, and she didn't hide from it, nor was she embarrassed by it. She actually talked about it regularly to others so they would learn from her mistakes. These so-called friends also said she would never commit suicide. There were no signs, they didn't believe it. Yet there were. Yet they weren't even around to know her or what was going on with her. Most people who commit suicide, even the closest people around them, say they didn't have a clue, there were no signs, like Robin Williams, Kurt Cobain, or Twitch, just to name a few well-known people who committed suicide. For me, suicide is hard to accept, period. Nobody wants to believe someone they know and love would commit suicide. I get that. I didn't either, and that's why I questioned everything. I called the medical examiner, but I sure as hell didn't go around accusing people of murdering her. I was there daily, and when I was asked if she was suicidal, I said yes and no, because I did see some signs, and I truly believe if she really wanted to commit suicide, she would have months prior. She would go on and on about herself, venting or telling you about your problems or what was going on. She would usually turn the conversation back to hers, because hers were worse, and I think she just liked to over-exaggerate to appease herself. She kept doing weird things, knowing I was coming out by her, so I assumed it was more of an attention thing. How do you think it makes me feel? That's the part I struggle with and feel guilty about, because I didn't see it or believe it. I couldn't help what I didn't know. I knew she was frustrated and upset of not getting answers. She was tired of being sick. I didn't know she was lying to me when she said she was dying from cancer. Yes, I lied to people who didn't know her and at her request. In April 2018, she changed her living will to add me, as it shows in States Exhibit 17 and Defense 607. Because she had finally got answers, she was sick and dying from colon cancer. It made sense. It fit her symptoms and issues she was having. And let's be honest, why would I think she was lying about cancer? She was so happy in a weird way because she had finally had answers. And as she had said, she didn't for so long. She didn't want anyone to know, to talk her into fighting or feel sorry for her. So I lied. I also quit working at her request to care for her and to be there for her in what remaining time she had left, because she wanted me there. And I wanted to be there as it was my family. She had tried for months to take her own life. I would come out and find things, or she would be doing things. It all made sense because she was in pain and dying, according to her. She wanted the gun, so when she wanted the gun, so when and if it got too bad, she could end it. We fought over that too. I didn't agree, but again, this was Lynn, and she was an adult, and she was going to do what she wanted to do. Can you tell me what you would do when somebody you know is sick and dying as she was, see them day in and day out going through it? She asked me if I would help her die, and when the time came and she couldn't take the pain anymore. I had said no because I couldn't and wouldn't be able to live with myself. It is not my place. I was not God. I have watched people sick and die from cancer. I have watched what it did to them and to the people they love, and vice versa. It is a horrible thing. I couldn't even imagine the pain they are going through. Days prior to her 2-week hospital stint, her neighbor came over and said she had looked like the Walking Dead. I remember like yesterday, Lynn said, "Yeah, well, I wish I were." The reason she finally went into the ER was because I kept pushing her to go and get help. The day before, I had walked in on her with a gun to her head. She was crying and babbling. She was not making sense to me and told me she had lied about having cancer. I told her this had gotten out of hand and she needed to go in for help. At that point, she had been drinking Visine for months. At first, it was to take her life, as she had did with her mom. I did not know either until after her death. She had continued drinking it because it took away or numbed her pain and helped her sleep. Those were her exact words. I know it sounds crazy. Who thinks to drink Visine? I had those same thoughts and lots more, staring at her in shock. But you didn't know, Lynn. You didn't see the things I saw her do, nor did you question her. Well, I did, but it didn't change anything. If she wanted to do something, she was going to do it. It was that simple. Yes, it sounds crazy. Part of it actually made sense to me. I don't get the why or how she tried it, but I got that it seemed to work in areas of numbing her pain and helping her sleep. So it did make sense when she kept using it, because I actually saw firsthand her sleeping and finally getting some pain relief. She was an insomniac and on Xanax for years for sleep. It wasn't helping anymore, hence why she kept taking more and more. Lynn did what she wanted, when she wanted, and how she wanted. She was 62 years old and wouldn't listen to me or anyone for that matter. Even my mom called her because I had told her about the gun and situations while she was in the hospital. There were a lot of things I am sure my mother would have talked about had she had the chance to testify. And I am not sure why my attorneys did not argue against the state's motion to exclude her testimony. Instead, they decided not to call her to testify. Everyone assumes because she was my mom, she would lie to protect me, but that is not my mom, nor would I want that or ask that of her. When I did wrong years ago and got my forgery charges, it was my mom who turned me in. It wasn't easy for her, but she knew I was in the wrong and I needed to be held accountable. My mom knew Lynn. She was her best friend, and she knew me, her own daughter. It was a huge blow to my defense that nobody got to hear from her, or what she knew or didn't know for that matter. My mom tried with Lynn nonstop until my mom couldn't deal with it anymore. I tried with Lynn. I talked to her all the time. That is why she did a lot of things I did not agree with when I wasn't around. When she died, Visine wasn't even on my mind because she was drinking it for months. That was according to her. I didn't see it for months. I only saw it shortly before the hospital stay. I was the one who wanted an autopsy and answers. I wanted to know if the doctors had missed something in all that time, if she really was sick, or if it was in her head. It had gotten to the point where we no longer knew if it was her or the doctors, because it didn't make sense how they weren't finding things wrong, yet all she did was complain. And then she would leave the hospital before she got answers or refuse tests. If she did this, if I had been back sooner that day, could I have gotten help, or what had really happened? Even the story of cancer, she had it, then she didn't. I really didn't know what to believe anymore. I called the medical examiner for answers, absolutely. It really affected me because I was always around, and then to find her dead, I had to know what happened. I needed answers, and I could not let it go. I went back to her condo that night. Yes, I got to put again about somebody giving me Visine in a drink. How could I say what had really happened? I had spent months emptying her condo, taking care of all of her stuff, and I haven't even processed her death, yet I was going through all the motions. I kept dreaming she'd come home wondering where all her stuff was and getting mad. It was Christmas, the first holiday we had that we had usually celebrated together, and I had tried to keep myself busy. After I was going through the boxes of hers in our basement, I came across her suicide letters. I had put them aside and forgot all about them, out of mind, out of sight. I didn't really know what they were when I had first found them. But when I did find them Anthony had testified. He said he didn't want to read or look at them. So I sat in the basement reading them. I cried, I was angry and shocked to learn all that I did, mostly about her mom's death and what she was going through. And that's when I fully learned about Visine, and only then did I research it. I never looked it up before that day. Yes, prior I knew Lynn drank it, but only to release her pain and help her sleep, as she had said. I was lost with all this new information. Within a week or two, at most, I had went out with friends to watch a live band. I had overdrank and came home. I was in my feelings. I was thinking of Lynn and how she would have loved going to watch a live band like that back in the day. How she would still be here. How she should still be here. Her suicide letters, life, all of it. I had missed her. I was mad and angry over all of it. I wanted to relate to her. I wanted to understand why she had done the things she had did. Most of all, I wanted to be close to her again. I was trying to see what the Visine did or how it made her feel because I didn't get it. Nothing had made sense to me. And I was trying to make sense of it all. I don't know how else to explain it. I went to the bathroom and I drank Visine. I went and sat outside crying before finally going to bed. I woke up the next morning sick and not feeling good. I was to take Scott's youngest son, who I adored and loved, to a birthday party. I was mad at myself because I couldn't take him. I had cherished the time we had had with him on weekends, and I didn't know how to tell Scott. So again, I did. I lied. How could I explain? Do you know how I struggled? How many times I wanted and needed to talk to Scott about Lynn? How many times I couldn't sleep or woke up in the middle of the night and would go outside and sit crying because I loved him and I lied about Lynn as she had wanted, and it had gotten so out of control and I couldn't talk to him. Then later, when I was arrested, I no longer knew what to believe myself. After all Lynn had said and the suicide letters, I didn't know what to say or not to say. Who would believe me because it was too much? How do you explain all I knew? I knew I didn't help her. I didn't take her life, and I believed that they would realize and figure out I wasn't involved. Then they brought up the Visine, and I was afraid because I did buy it for her at her request with other regular grocery items when I went and did her shopping. I didn't go to the store just for Visine. Then they started questioning on financials, and due to my past record, it didn't really matter what I said. They had their minds made up. I asked, offered, and took a polygraph test at my own.
I'm going to stop here for just a sec. If Jesse was so concerned about Lynn and drinking Visine and that she wasn't condoning what she was doing and so forth, why didn't she substitute water in the Visine bottles that she gave to Lynn? Excuse me. Okay, let's keep going.
Requests, not theirs. To this day, I have never been given those results or have seen them. This case came about for two reasons. First, because of who Lynn's distant cousin was. He was a prior district attorney for none other than here, Waukesha County. He had no relationship with her, and when she passed, he read about it in the paper. He inquired by calling and coming in person to the medical examiner's office. He was given my name and my number by the medical examiner because I found her. He never contacted me. He turned around and C-capped me. I never called him, and when she passed, I never called him when she passed because I did not know of him, nor was he on her personal list of who to contact. The second reason was from him C-capping me. My prior forgery convictions, he said, and I quote, "It did not pass the smell test because I was on her will." It didn't matter that I admitted to those charges back then, served my time, or changed my life since. Now, years later, or a decade later, they were brought back up in my face, nor did it matter that she too had had her own lengthy record. Lynn's cousin, his name is John, her ex-boyfriend Jim, and Anthony all came in person, called multiple times, and spoke with different people here, from deputies, sheriffs, detectives, people in the medical examiner's office, probate office, and even judges. Some were even friends of theirs or acquaintances, asking questions and voicing concerns, pointing fingers at us, my mom and I. There was so much done behind the scenes that this is not normal, and for that matter, appropriate. But it still happened, and none of that was talked about either during trial. The cousin did not know Lynn, or us for that matter, but he was sure to repeatedly voice his opinion of her friends, while the two main detectives laughed and joked with him about his prior time in office and how he was such good friends with the sheriff. The detectives told him he owed them a favor, and if he could talk to their boss for them and get raises and early retirement. Those detectives went to speak to him about an investigation into his cousin's death that he pushed, and they were laughing and joking with him how he owes them a favor. And no, I am not kidding. And told my family and my friends, I confessed. What they told them that I am a con artist and the worst of the worst, and I pry on people who have no one. Had them believe them. There was a chance that I even poisoned them. They asked them if they knew why I was on probation and told them it was for stealing $35,000 from my grandmother. And it goes on, which is all incorrect and not true. Let me tell you, these things did not come from my family or friends telling me this. They came from me reading and listening to my own recordings in my discovery that I have listened to. My own friends believed everything these detectives told them at face value. Why? Because they are cops and they would not lie, they said. Well, they did lie many times about a lot and even on the stand. So let's be clear, it was not just me who lied in this case. People think because they are cops, they tell the truth. Like they can do no wrong. Well, let me guess again, because they do wrong, just like anybody else. You see it every day. These detectives' evaluations and conclusions of this case were reached based upon their own biases and the bias from the cousin of a former district attorney, where normal conclusions should have been based on an objective analysis of the evidence. I feel their jobs, as well as the others involved, made them vulnerable to official influence. Nobody has a clue what it is like being locked up for something you know you did not do. The more you speak to the detectives, how much they repeat the same question 20 different ways. I was losing my mind as they twisted and turned everything I said. It is crazy. They literally had me start thinking and believing I actually did something wrong when I knew I didn't. And they were so caught up on what they believed that it didn't matter that there was no evidence, no proof. Once their mind is made up, they were determined that what you say no longer matters because they won't believe you. The detectives were laser focused on me, where they never looked at this case objectively to view all possibilities. It took me 4 attorneys for someone to listen and get handwriting analysis done who requested that. We got the evidence to prove it. We didn't hire an ordinary expert. We got the FBI. Why didn't the state bother to have those looked at or checked when they had years prior to do so? But yet, once again, once we got the FBI, the state tried to tell them that they requested their help. No, they did not. I did. They had even more of Lynn's writing that would have helped, but they chose not to send it off or even offer it to us to use. Do you know the state requested financial and phone records on Lynn, my mom, and I before they requested medical records? The state and the MA didn't even have or obtain her hospital records, nor did they even request them for that matter until 6 months after her death. I was a suspect in her death before they ever requested those records. Tell me how that makes sense. They didn't think it was important or part of her death to know why she was in the hospital or what had all happened to her those 2 weeks she spent there, considering she was released only 5 days before she passed. They never took me to the park when I repeatedly asked. They said there was evidence to help me. Why not tell them? So when I finally did, yet they wouldn't take me to find it, why? To this day, nobody has ever personally taken me to the park. Why? Are they afraid that I might be right? I have had 8 different attorneys and not one has even tried to put in a motion requesting the judge to allow it. They claim I did this. Why didn't I take out a life insurance policy on Lynn? Remember, as they say, I killed her for money. As the state said, I was stealing money from her for over 3 years. Why did I call 911? Stay on the scene. Why did I call wanting answers from the medical exam? I was on probation and told my agent I had police contact. I called 911 and found her dead, that I was her personal representative and everything. I was under investigation for 6 months. If I was responsible and left in the public for almost a year after her death before I was arrested, better yet, I never ran. I could have been long gone. I had almost had a year out, but I didn't. I had no reason to. I came in to talk to the detectives. I called for answers. None of this makes sense. None. I have played the what ifs for over 5 years now from that day I found her on October 5th, 2018. Nobody knows how I wish I knew what I know now. I wish I was back sooner. I wish I had tried harder to get her help long before that day. told the hospital and the doctors more, done more, period. I live with those regrets. But as I sit here from the beginning to now, and however many years from now it takes, I will not stop fighting because I was wrongly convicted by this crooked, corrupt, and biased county. They only put out what they wanted and allowed you to hear. And they also changed things to fit the story to use against me. My trial attorneys were not able to bring up Lynn's mother's death, which was a large reason Lynn took her own life, as she stated in her own words, in her own suicide letters, which were admitted in trial but not discussed, where Lynn explains how she poisoned her mother with Visine and how it has haunted her ever since. You heard those today at the beginning from me. Those detectives looked into her mother's death, subpoenaed multiple medical records. Some were never turned over, yet we couldn't ask or bring any of it up during trial. Again, I was on trial fighting for my life. We can't bring up how the deceased, Lynn, killed her own mother years prior when it was similar to how she took her own life, and why, if not all of why she took her life. How is that fair? I should be able to defend myself fully when these were the letters Lynn left and those were the things she wrote in them. Yet the state can bring up my old forgery charges I had over a decade ago. The state has been allowed to speak and put out anything in the media from the beginning, but I have been silenced by a protective order the courts gave me even after my conviction. The state, along with Anthony, held a press conference immediately after I was found guilty, and I still wasn't allowed to speak. But when I had put out a brief statement after the state's submission of fake letters, trying to defend myself because nobody else was speaking out for me, I was reminded by the courts of that protective order and being in violation. This is insane. I haven't been able to speak. Two witnesses, yet other witnesses have spoken to others, changing their stories to match. Hell, even the neighbor Jean, who personally knew or met Anthony or Corinne prior to Lynn's death, but sometime before trial became friends with them. When I had regular contact with her before and after Lynn's death, she was who I called sometimes to check on Lynn if I couldn't be there, or if she was having a bad day to go over, or if I was going out of town, or if Lynn fell and I needed help. We talked about Lynn a lot. Then I had people who knew Lynn in situations that later refused to testify or said they didn't know things on the stand that they prior did, because I am all over the media, and who wants to defend somebody accused of a murder charge? No business is going to back me or person wants to defend me, even if it's the right thing to do, or if they know and have information to help. It is not right and it is not fair. I was allowed to be plastered all over court TV and the media like a circus show. These are real people's lives. This is not okay. It is Lynn's life, my mom's life, and my own life on public display. Yet what's being displayed is not accurate or even close to the truth. You think because they report it and it's the news that that's what they say is true? It's all about ratings and what people think they want to hear. Forget the truth or displaying the full story. This case was highly hyped up and sensational in the headlines due to the Visine aspect, but it was also extremely and purely circumstantial case with no physical evidence to back it. Yet the jury chose to convict me. And you want to talk about every defendant has the right for representation and a fair trial? That's all crap. You can't afford representation. You have to hope and pray because you are given representation from the state public defender's office. How many public defenders or attorneys did I go through? 8. And to date, none of them have done enough for me. And then everything is funded by their office too, which is all from the state, which is the same one who was against you. During trial, the staff are experts about their payment and how much they were paid to testify. Truth is, everyone in my trial, including witnesses and jurors, are paid. They are all paid by the state, county, the same as the district attorneys, their experts, medical examiners, detectives, my attorneys, and my experts. So if you think the state has an unfair advantage because they are trying to portray it like that by saying my experts are being paid for, well, of course they are. They have a job to do like everyone else, and they aren't being paid to lie or change what they believe.
All right, council, thanks for returning. We've got a motion scheduled being heard outside of the presence of the jury. We're on the record on KCR 2221-1623. The state filed a motion in limine yesterday, along with a request to temporarily seal, which, based on a hearing earlier today, as well as the hearing being held in public here. However, again, outside the presence of the jury. I also have granted the fact that we are in trial and the issue has arisen and developed during trial, which doesn't permit the typical response time on the motion in limine. Response from the defense after the state argues the motion. And after consideration of the arguments, I should be able to make a ruling this afternoon before the jury's return. So, Ms. Blake, I understand you'll be arguing on behalf of the state. Is that correct?
That is correct, Your Honor.
If you'd like to present an argument in support of your motion limiting, I'll hear that at this time.
Thank you, Your Honor. And as this court is aware, we've already litigated a very similar issue in front of this court. However, this one deals with a different witness and some different materials. So during preparations in this trial and getting ready for witness prep with one of the witnesses in this case, specifically Melanie Gibb, the state had reviewed a discovery response that was provided by defense counsel. This was provided to us within the discovery timeline as required. This was my first time reviewing it in full. And this had previously been provided by the state, actually in the prior pending matters against both Chad Daybell and Lori Vallow. They were originally provided in cases CR 22-2755 and CR 22-2838 on approximately March 3rd of 2021. So defense counsel would have received them in that case initially. Subsequent to that, I believe they were re-provided in this case's discovery on December 14th of 2022. Defense redisclosed them to the state on or about February 1st. As indicated, in preparations for the trial, I had not reviewed those in full until recently. Upon a review of those and then coupled with defense's current state of cross and opening statement, looking at those, the state had concerns that we may be back to litigating in the future the issue of whether or not Prosecutor Wood is a witness. When I reference a previous hearing dealing with a similar issue, it dealt with that, wherein this court determined and quashed a subpoena that had been served on Prosecutor Wood. And while that was in relation to another witness, a review of these coupled with the arguments being made in the state of the cross-examination raised the state's concern that there could be another attempt by the defense to make Prosecutor Wood a witness, and specifically in relation to Ms. Gibb. The state disclosed in this motion the content of the communications that we feel the defense may be relying on or may use. We also have outlined an argument specifically starting with a determination as to whether or not the evidence is even relevant. This court had previously put in effect an order, and in the prior case numbers that were mentioned, the court had also mentioned the requirement for a taint hearing. Although those were in relation to other witnesses than Ms. Gibb, I think it would be a similar standard that should be required or would be required if it is the defense's intent at any point to attempt to call Prosecutor Wood as a witness. The reason the state brought this issue now is we don't want to get through the case in chief and have that become an issue if that's in fact where the defense is headed. We felt that it is an issue that should be determined sooner than later. We have suggested that if the court does have concerns that these could be reviewed in camera and or a hearing could be conducted outside of the purview of the jury, for this court to make a determination whether or not any prospective testimony would be relevant to this case and either to the state's case or to the defendant's case. In addition to that, we've outlined and gone through again, and I know the court saw essentially the same case law, the same argument in that previous case, but we did include that we do recognize a defense attorney can be allowed to call a prosecutor and a witness, but it is disfavored. Case law makes that clear, as well as that any attempt to do so should be decided in advance of trial. We've included the case law outlining that and essentially the test required or the high burden on a defendant to show that a prosecutor would need to be a witness, which is that compelling need test. We don't think that that's been met, and that would be the request if this court is inclined to allow these messages in and or even allow an attempt to have Prosecutor Wood become a witness. We feel that that would be appropriate for the court to conduct a 403 analysis outside of the purview of the jury and or a taint hearing if necessary. We would point out that from the state's review, it is very, very rare for courts to find that a prosecutor should be a witness. And in the cases the state found, it either involved the prosecutor being a witness to the actual facts, so a factual witness to the case, or where they are a witness to a statement that contradicts a later statement made by a victim or a witness, and they are the only available witness to that contradictory statement. So I don't think we're anywhere near that at this point, but the state did have concerns that's where we could be headed. In an attempt to avoid running into that issue down the road, we wanted to address this now. Further, I think it would Also, determining before Ms. Gibb takes the stand, kind of what the parameters are with regard to any allowance of those messages and or any parameters surrounding them would be prudent secondary reason for this. Finally, the state would argue that the defendant cannot invite error. We recognize that we are already into the trial. Testimony has already been given. The jury has already heard from the prosecutors in this matter. But we do believe that if there is any attempt to call Prosecutor Wood as a witness, that at this point, any objection to that has been waived by the defense and or would be invited error if we end up at that point. So we would also just note that for the record. But at the end of the day, we are asking the court to consider either excluding the messages and or excluding Prosecutor Wood as a witness or any attempt to call him as a witness and or if necessary, if the court has additional concerns that a taint hearing be conducted outside of the purview of the jury in order to determine whether or not defendant meeting that compelling need, which is a high burden. I think that's all the state has unless the court has any questions.
All right, I do. The question I have, I understand your motion as it relates to wanting to exclude defense exhibits 113. Also, on the issue of whether or not Mr. Wood could be called to be a witness and invited error doctrine that you've discussed. In your ruling, are you also seeking a specific court ruling as to prohibiting certain types of cross? I know the concern has been raised about the cross and whether or not trying to push into that territory. And in this motion, I guess I'm not entirely clear if you're seeking a ruling when you talk about parameters on disallowing some scope of cross, and if so, what you think the topics that would be disallowed would be.
Thank you, Your Honor. And I think I can try to clarify that. I guess where the state is asking that either the messages be prohibited and or that prosecutor would be prohibited from being called as a witness or the defense be prohibited from attempting to do that. When I talk about the parameters, I guess what I'm suggesting, and maybe it would require an in-camera review by the court, but if this court does determine that prosecutor would cannot be called as a witness, I think it would be parameters around the cross of a nature such as that. I guess the state's concern is if the defense is allowed just unfiltered cross completely, and this court has made rulings that they're not going to be allowed to call prosecutor would as a witness, we may still end up in the same position of an attempt to confuse or mislead the jury or to get into parameters or to get into areas that this court has essentially indicated are off limits. So I guess when I reference parameters, depending on the court's ruling, if certain of those messages can't come in, then I would think that those wouldn't be something that we get into cross-examination. Similarly, if prosecutor would not be called as a witness, I think the cross would need to be structured in such a way that it isn't suggesting or trying to set up that he would have to be a witness.
All right, well, I appreciate the additional explanation on that. Mr. Pryor, and I understand this was a hearing expedited, putting you in a tough spot in terms of the time you would have to respond. And I do have that in mind, so I haven't required you to submit any written response or expected it, quite frankly, knowing that we're in trial and this is a very short noticed hearing. However, I do want to give you an opportunity, knowing now that you have had an opportunity to review the state's motion and hear the argument. What is the response from the defense on this motion in limine?
And Judge, for the record, the state provided me their notice on Sunday night, I think at about 11 o'clock, which was a day and a half ago. I didn't get a chance to read it until after court. I was preoccupied the morning of yesterday's court with some other matters relating to this case as well, and eventually had to get to it late last night and took a look at it. This is my concern, is what the state is suggesting is that in some way they can dictate where I can go on cross-examination. They would like this court to enter an order saying, Mr. Pryor can only talk to certain witnesses about certain topics in a certain way, and they're trying to handcuff me from going into areas that they will find maybe a little sensitive to their case. That is extremely problematic. Okay, Judge, I'm going to cite Idaho Code 9-201. And 9-201, and I apologize, I don't have it memorized. My memory isn't as good as it used to be, so I'll have to read from this. But in pertinent part, Judge, it says who may be witnesses, credibility of witnesses. And I'm not talking about who may be witnesses. I don't have any desire to put Mr. Wood on the stand. That's not what this is about.
And so I do want to be clear on that point. You've said that. I've previously ruled on that in the other cases, and you are representing the court here at this time. You are not intending to call Mr. Wood. Is that correct?
I'm not. And I'm going to follow, although I don't agree with the court's previous order as it related to the other phone conversations with Mr. Wood and the 4 or 5 other witnesses in which we ran into some issues about similar problems here. The court made its ruling and I'll follow the court's ruling. But what I am allowed to do is they provided me with some information in the Chad Daybell's original case. They provided it in Lori Daybell's as well. So they had possession of it. And quite frankly, what it comes down to are emails between Melanie Gibb and Mr. Wood. And Judge, for the record, I'll make it clear that we're not talking about a couple of emails. From May 6th of 2020 to 11/4 of 2020. Well, let me change this. In essence, Judge, over a period of time, we're talking of 6 months plus period of time, we're talking about 340 text messages that the two of them exchanged. 143 can be assigned to Mr. Wood. 97 could be assigned to Ms. Gibb. And these are text messages for pertinent part, address issues relating to this case. Now, one of my concerns, Judge, is this, is that the question I am allowed to ask is have you had any communication with anybody, prosecutors in this case? And I've done it on previous witnesses here. And what the state would like to do is stop me from inquiring why Mr. Wood has had 340 exchanges of text messages between him and Melanie Gibb over well, I want to be careful about what I say here, 5/6/2020 to 11/4/2020. Portion of those, 7/13/20 to 8/3/20, a 2-week period, Judge, from 7/13 of 20 to 8/13 of 20, there were approximately 129 texts over that 2-week period. So this is the concern. And again, I'll go back to Idaho Code 9-201, and I'll read, this is the 4th line down. Therefore, neither parties nor any persons who have an interest in the event of a crime, nor persons on account of their opinions on matters of religious belief, although in every case the credibility of the witness may be drawn in question by the manner in which he testifies, by the character of his testimony, or by the evidence affecting his character for truth, honesty, integrity, or his motives, or by contradictory evidence, and the jury are the exclusive jurors of credibility. So what the state is trying to do is basically circumvent Idaho Code 9-201. What they'd like the court to do is they'd like the court to say, Judge, we're not going to let a jury hear what Mr. Wood and Ms. Gibb have been talking about for 340 text messages that are related to this case. And we're not going to allow the court to allow the witnesses or the jury to judge the credibility of what was said in those text messages. That's what they're trying to do. And Judge, that's in complete violation of 9-201. This isn't a balancing test. That's what the problem with their analysis, Judge, is. They'd love to put you into a taint hearing. The difficulty with a taint hearing, Judge, is this. 404 rules of evidence, 404 balancing, they'd like you to do 404B and do that. The problem is with 404B, Judge, at the bottom of 404B, you talked about it the other day. It applies to prosecuting attorneys who are trying to bring in prior bad acts. That has nothing to do with this, and this balancing act has nothing to do with this. The reality is this. Does this information go to the credibility of a witness? Is that when a prosecuting attorney engages in discussions with a witness to the tune of over a 7 or 8 month period, 340 texts, and I've included them, Judge, I believe it's 113 is my exhibit that I provided.
I do want to clarify. So 113 is not a summary, but it includes all of these texts you've referenced.
Right.
Okay.
And what 113, Judge, is it's a specific response to discovery that was provided upon seeking some information from the state. And it's I believe it's A through K, if I remember. And Judge, this was disclosed by the state 2 or 3 years ago. On the 15th of March of this month, I provided them a list of the exhibits that I was going to provide. And Judge, a week before the trial started, I took the liberty of providing them. I wasn't afforded the same courtesy, but a week before the trial even started, Judge, I handed the state a copy of all my exhibits. That was over 3 weeks ago. So they've had ample time. Last time I've checked, my count is there's 1 defense attorney and there's 4 prosecuting attorneys. And they should have had ample time to go through my exhibits, and suddenly this last minute quarterbacking of saying, this is a way we're going to stop Mr. Pryor from talking about evidence when we call Ms. Gibb. And I don't appreciate the tactic. I don't appreciate what they're doing here, but the reality is they're not allowed to do it. And under 9201, they don't have the authority to stop me from questioning a witness about communications with either a police officer or a prosecutor and try to show credibility, bias, or motive. And it's not an analysis of what you're looking at in terms of the content of those messages. And there's no authority that I'm aware of other than 90201 that gives them the right to dictate how I engage in cross-examination. Finally, Judge, I've made a representation to the court and I'm standing by that representation. I do not intend on calling Mr. Wood. What I do intend on doing is have when Miss Gibbs up there and either on my direct examination when she's called back or on my cross-examination, I'm going to call Miss Gibb and I'm going to question her about what kind of contact she's had with Mr. Wood over a certain period of time and the nature of those discussions. And I have copies of all the emails and I can question her. If she remembers the conversation and is able to discuss it, there's no need for me to publish it. But if she can't remember it, Judge, I have every right to refresh her recollection with copies of those emails. And I have every legal right to do that. And if that means that I show her copies of those emails to refresh her recollection, I can do that. That doesn't mean I need to call Mr. Wood. All I'm asking her to do is to recall a discussion she had with him about the case and the subject of those emails or excuse me, I keep saying that, text messages between him and Miss Gibb. And that's totally permissible. There is no limitation, nor is there any definition on what I can use to refresh a witness's recollection. I have free rein to use any information I feel fit to put it in front of a witness and say, will this help you refresh your recollection about testimony? And that's exactly what I intend to do.
All right. I will note, Mr. Pryor, on the issue of whether or not you intend to call Mr. Wood, we just before trial had a hearing where the court quashed a subpoena that was served on Mr. Wood. So I certainly understand the state's concern about a tactic, if it is, from the defense to call a prosecutor in the case. We've been through that since these previous cases, the 2755 and 838 cases dealt with that extensively in written rulings. It's been going on for several years now, the same issue, and the court's ruled multiple times. Going through that analysis, and again cited in the state's brief about, and I do agree with the way the state has framed the issue, looking at the State versus Aguilar case, 135 Idaho 894, that it is very disfavored for a prosecutor to be called. And in those rare circumstances where they are an actual observing fact witness, or perhaps the only other witness that could corroborate some testimony or something. Besides that, they have to show, in order for a prosecutor to be called, that the testimony would be vital to the case and the inability to present the same facts from another source. So again, with the subpoena being served just before trial, I'm not surprised the state still has that concern, and I will indicate without additional need for if that were a strategy here to not have the issue come to the forefront before trial started, and then attempt to do that unless it somehow met that very narrow structure that is laid out in the case law. I don't see that happening here. However, I do want to hear some additional argument back from the state on the issue of the Exhibit 113, the communications, and whether or not Mr. Pryor should appropriately be allowed to use that as a way to question the credibility of the witness or potentially impeach if there's contradictions in what the witness may say versus what could be contained in 113.
Thank you, Your Honor. And I guess to be clear, the state is not in any way trying to stop the defendant from being able, or the defense from being able to conduct appropriate. The court does have the ultimate discretion over the allowance of cross-examination in compliance with the rules of evidence to make sure people stay within the bounds. What the state has concerns about was any attempt by defense to misconstrue the content or attempt to create a situation where the defense then argues, well, we have to put Prosecutor Wood on the stand, and especially without conducting any kind of a hearing in advance. The state does appreciate the comments made by the defense that there is no intent to call Mr. Wood as a witness. I guess it still makes the state a little bit nervous because, as the courts pointed out, we've litigated this issue multiple times. The state also recognizes that sometimes trial strategies change. And if at any point that does, the state still doesn't want to end up in that position. Because I guess while defense says we're just going to question her and maybe show her the messages, it still creates a concern for the state that then later the defense is going to say, given her answers, given something, we now think we have to call Prosecutor Wood. So while I appreciate the representations made by defense counsel, I think that is still the concern surrounding these messages. The state does not disagree that so long as the defense counsel sets the proper foundation, he would be able to absolutely use these messages if he were trying to introduce them. I guess I should be clear on the proper foundation. I don't disagree. I don't think the state disagrees at all that cross-examination can include asking about meeting with the state, meeting with investors, conduct a taint hearing if necessary. I think the court was very clear with defense counsel that if there was going to be an attempt required, I guess the state is not still to essentially circumvent the court's prior orders. So that's the concern with the state.
Okay, thank you, Ms. Blake. Mr. Pryor, Ms. Blake was still talking, so I'm sure that didn't come on the record. What did you say?
If I could respond briefly, Judge.
You may.
Thank you, Your Honor. Judge, I've already assured the court, and I'm not going to violate the court's order about Mr. Wood. And frankly, the state can say if certain things happen, but the reality is this court can make rulings on relevance issues as it relates to certain things. But when we're talking about credibility, Idaho Code 9201 allows me the leeway to go forward and impeach a witness or ask a witness about communications with a prosecuting attorney. And it's perfectly permissible. Just because Ms. Gibb may say something different than what a text message is, I can show her, refresh her recollection, and that's as far as it goes. And I understand that. I understand the limitation that's put on impeachment and refreshing someone's recollection. That doesn't open the door, and the state's using this opportunity to say, well, Judge, in the past, you've stopped Mr. Pryor from having him talk about his many conversations with the other witnesses. But in this situation, it's a different story. Ms. Gibb is the witness in this case. Her testimony is crucial to the state even trying to prove their case. And the reality is that I'm allowed to talk about communications with Mr. Wood and Miss Wood, Mr. Wood and Miss Gibb to the tune of 340 text messages over a little more than a 6-month period. So I am allowed to go into that, and I'm going to go into content if that content. So the suggestion is that there should be a taint hearing. They are completely off base. And what they're trying to do is they're trying to, strap a motion that has previously been ruled on and say, Judge, there still may be some threat here. We really better go through this long process and have you evaluate things. And I'm going to object if that's where we're going. I'm allowed to go into the credibility, bias, and motives behind any witness. And I'm allowed to question them about anything that may go to bias, motive, and in that regard. So I appreciate the state conceding finally that I can use this information on cross-examination, and Judge, as a representation on cross-examination and maybe direct examination when Ms. Gibb is subpoenaed, that's where I intend to go. And again, I will reiterate, I do not intend to call Mr. Wood, nor do I plan some scheme. Sounds a little paranoid to me, but that's fine. But again, I'm going to follow this court's order. But 9201 allows me to go into the credibility of the witnesses, and I don't feel like I need permission to do that.
All right. The matter's been argued. I am ready to make a ruling on it. So I am going to put the ruling on the record, I'll just have an order entered that will say for the reasons stated, because I don't expect either side to draft out in an express order the analysis I'll go through here. So as it relates, first of all, I'll indicate that 9201, of course, reiterates the provenance of the jury, that they're the ones that determine credibility of witnesses ultimately, and that clearly states that. The matter of evidentiary ruling and relevance is always, though, for the court to determine what evidence comes in or what does not come in based on objections or proffers during the trial. And the court always has to consider Idaho Rule of Evidence 401, which is whether or not evidence is relevant, and 403, which is potentially, even though there is some relevance, evidence can be excluded if the evidence is unfairly prejudicial more than probative. And so the court determines that, and that doesn't run afoul of 9201, as the defense has argued it anyway, or the two are mutually compatible in that it's the court that will determine relevance based on 401 and 403. And then the jury's left to determine ultimately if a witness is credible or not. So in this issue here with Exhibit 113, I will indicate that much like the parties here, the court's busy as well during trial. I have not gone through Exhibit 113, and nor I don't know if I want to or care to read the hundreds and hundreds of text messages that are apparently, or other messages that are contained in the exhibit. Without knowing precisely what's in all of those, I can't make a ruling to just wholesale exclude Exhibit 113 as the motion in limine would seek and state that that's an irrelevant exhibit. Parts of it may be, parts of it may not be. The whole thing may not be relevant. The whole thing may be relevant. I just can't say at this point until the witness, Ms. Gibb, testifies. I would state that to the extent anything comes up within those messages that may well be proper on cross-examination as impeachment if the witness begins contradicting things that were previously said to the prosecutor or vice versa, or on other factual allegation. The court's going to deny the motion as it relates to a motion to eliminate, to just exclude Exhibit 113. Just have to see how the trial develops with the testimony of that witness. However, I will state that I'll be watching very carefully as to whether or not there really is any relevance to the testimony of Ms. Gibb, because attorneys are entitled to talk to witnesses, help them get ready for trial, not to change their testimony or not tell the truth. However, if it's just simply matters of, what time should I be there, that kind of thing, if it's not relevant, then I'm going to watch. And if an objection comes up about relevance on any of these prior communications, despite 9201, I can simply determine if I think it's appropriate that the jurors shouldn't be hearing about these communications if it does nothing to help them assess the credibility of the witness. So ultimately, it has to be an assessment of the witness's credibility. Quite frankly, I don't think a taint hearing is necessary or required at this point. If during the course of that testimony, we start going right into this, and it looks like there may well be an issue if that were to come up with credibility relating to Exhibit 113. I do agree that that should be done either in camera or at least outside of the presence of the jurors to avoid any unnecessary confusion the jurors may have sorting out what that means if it doesn't go directly to the credibility of that testimony. As it relates to Mr. Wood potentially being called as a witness. There's been a representation to the court today. That's not what the defense intends to do. This court's previously ruled that that was not going to happen. I still intend to have that happen. Say that happen because anything is possible. It seems in the I'm not going to predict what I don't see what the strict analysis is to put that. So absent some really surprising or extenuating development, Mr. Wood's not going to be called as a witness and would not be permitted to under the controlling law. And finally, on that invited error doctrine, again, as I mentioned, to the extent this would be some sort of invited error, I would watch for any objection to stave that off if we started getting into an issue that could potentially bring a motion for a mistrial. So the ruling at this time then is on those matters, Mr. Wood's not going to be called as a witness. The Exhibit 113 is not excluded, but the court will watch for any relevance objections if the state believes it's not relevant. And that's the ruling on the motion.
Thank you, Judge.
All right, Ms. Blake, do you have any questions on that ruling?
I do not, Your Honor. Thank you.
All right. And counsel, one final thing, as I mentioned, if it becomes necessary for either an in-camera review or just argument outside the presence of the jury, please try and flag that, or I will sua sponte before bell gets rung in front of the jurors they shouldn't be hearing. So that will conclude then the ruling on the motion. At this time, if we are ready, we'll have the jurors brought back in to continue testimony.
Yes, sir.
President.
All right, thank you, Mr. Bailiff. Please be seated. All right, we are on the record on case CR 22211623. The jury has returned, is all properly seated. Thank you for your patience while we went through a couple of matters outside your presence today. It would be the intent of the court then to go straight through till our time to end today at 3:30. Everybody on the jury okay with that plan? Okay, if anybody for whatever reason does need some break, just notify the bailiff. Otherwise, we'll intend to go through the afternoon. Ms. Blake, I believe you're still on direct examination with Detective Duncan. Is that correct?
Yes, Your Honor, that is correct.
All right. If you'd like to recall the witness, then we'll have them brought in.
The state would call Detective Duncan.
All right, Detective Duncan has returned to the stand. Let me just inquire. I'm not singling you out, by the way. I do this with every witness when I remember, but over this break, did you discuss your testimony with anyone else or anybody else's testimony? Ms. Blake, if you'd like to inquire, I'll remind the witness you're still under oath and you may question.
Thank you. Detective Duncan, before the break, we had just heard 2 calls that were linked to the same mortuary call. Do you recall those?
I do, yes.
And you recovered those as part of the investigation?
Yes,
And I believe you indicated the FBI had actually requested you collect those calls.
correct.
And prior to today, had you heard those?
I have, yes.
Have you heard Chad Daybell's voice?
I have.
Were you able to recognize the voice on that call?
Yes, I was.
And who was that?
Chad Daybell.
And during the call, did you hear him use any other name than Chad Daybell?
I heard him use a different spelling of the last name, yes.
And in that call, do you recall him saying where he was hoping to send the remains to once they were cremated?
I do.
And where was that?
Louisiana.
Do you know where Charles Vallow's place of birth was?
Louisiana.
Do you know if he still had family living there?
Yes, he did.
Did you also hear Chad give a location for himself where he was currently located in that call?
He indicated that he was in Iowa.
Through your investigation, did you ever find anything indicating Chad was in Iowa?
Did not.
And we've talked about that in your investigation, you looked at the iCloud accounts for Lori.
Yes.
Do you recall locating a copy of a patriarchal blessing?
There is an audio recording of a patriarchal blessing on Lori's iCloud account.
Did you listen to that blessing at some point?
I did.
And do you know who was giving the blessing?
Chad Daybell.
Do you know who he was giving the blessing to?
Alex Cox.
Are you familiar with what faith the patriarchal blessings are attached to?
I am.
And what faith is that?
So the Church of Jesus Christ of Latter-day Saints.
Blessing.
Sustained. And Ms. Pryor, your microphone next time, please.
Detective, as part of the investigation, did the LDS faith come up?
Yes.
And do you have some basic knowledge regarding?
Yes, I do.
Do you know what a patriarchal blessing is?
I do.
Do you know who's authorized to give those within the LDS faith?
The stake president is authorized to give those.
Do you know what if Chad held the calling of a stake president at the time the blessing was given?
My understanding, he did not.
So he would not have been authorized within the LDS faith to give that blessing.
Correct. I think it actually would correct myself. Like it's a stake patriarch that gives that blessing, not president, but a patriarch.
So it's a specific calling someone has within the LDS faith to be able to give those blessings to another person.
Yes, it is.
And Chad did not hold that calling.
My understanding, he did not.
And Your Honor, the iCloud accounts have been admitted into evidence. The state has what's been marked as State's Exhibit 50, which is the referenced recording, where those iCloud accounts are already in evidence by stipulation. The state would move for the admission of State's Exhibit 50.
No objection, Judge.
Okay, Exhibit 50 is entered and counsel, again, to be clear with those accounts, et cetera, as each individual item comes into evidence, as you just did, Ms. Blake, continue to please reference those specifically so the record remains clear.
Thank you, Your Honor. The state would ask for permission to publish State's Exhibit 50.
You may publish.
Chad Daybell, it is. We're going to give Alex Lamar Cox a patriarchal blessing.
Alexander Lamar.
Alexander Lamar Cox. On this special day, I lay my hands upon your head to give you a patriarchal blessing. As part of the member of the Church of the Firstborn that you have earned the privilege to be a member of, I do so by the power of the Melchizedek priesthood which I hold, and in the name of Jesus Christ, our Savior, who has authorized this blessing. Just grateful that you're receiving it as you move forward in your life. You are a member of the house of Israel, 12 tribes, and you are a descendant of Joseph through the tribe of Ephraim, which grants you many blessings, particularly of spreading the gospel in these latter days and protecting and preserving those who seek to learn the truth. And that has been your mission on this earth, and it will now expand into ways that we will discuss further in the blessing. I want to begin by opening up the portals of time and going back to your previous creations in which you've lived. I see you on the third creation as a valiant warrior fighting for truth and righteousness, always seeking to do what is right. Then you progressed and were selected by the Savior himself to be part of the fourth creation. Great warriors were needed in that creation. Powerful goddesses were needed to be protected, and you were selected to help protect Esther. And you helped her in numerous probations as a defender. You have a special bond even from the premortal world. You connected there. And as she grew in power, you were right there beside her, always with a humble heart. You both always were so humble. So as this fifth creation began, after you had been exalted in the fourth creation, when you could have gone on to exaltation with Holly, resurrected being, you accepted the Savior's invitation one more time to come to this mortal realm, to condescend as a God. You help us. You have already assisted us in ways that can never be repaid. But you will continue to do so as you move forward in this life. You were born into a family that needed you desperately, with a set of parents who spoke of the gospel with their mouths, yet did not live it. And once again, you were reunited with a sister who needed you to survive such an environment. In no way was it a reflection on either one of you that you lived in that home. You were put there to help each other persevere. But the lessons you had to learn in your youth have now made you both strong, powerful servants of the Lord that would not have occurred in a traditional LDS home. You had to go to great depths to achieve tremendous heights. And the fruits of those trials are beginning to be demonstrated. You were granted to be a member of the Church of Jesus Christ of Latter-day Saints, and that was a strength to you. You learned about your Savior and grew closer to him and rekindled in some ways the connections you've always had with him. And through adulthood, you have refined yourself. And I just want you to know that at this time, the Savior is saying unto me, well done. Thy soul is cleansed. All is well. And now you'll begin into your terrestrial phase of this existence, that you'll be a powerful servant. I bless you with that knowledge that you'll now move forward as a true warrior in ways that can be demonstrated through not only physical action, but through spiritual power that is coming to you, and will be bestowed upon you. I bless you with the knowledge that through marriage, you'll be united with a partner who will match your powers and complement your strengths. You'll be known throughout the world for your good-heartedness, your willingness to save souls all over the world through portals, and you will begin to gather the souls that come unto Christ. I see you in New Jerusalem, but more importantly, I see you as a messenger of the Lord. Surrounding New Jerusalem will be many small communities where people will come who aren't quite ready to enter those heavenly gates, those terrestrial gates. And one of your missions will be to go among the people and testify as a prophet that they can make it. You'll share your own experiences of overcoming adversity. And through your example, they will rise up. You will give tremendous blessings to them, raise their vibrations, and be like a brother to many of these fathers who may have had doubts, but through your strength, they will look to you as a hero, and you'll bring entire families that have been sanctified to the gates of New Jerusalem, and they will be allowed in on your word. Only just one of the many.
still feel connected to it. What
on the greater plane, that the spirit, you'll feel at that time the vibration will exceed all. Before the second coming even occurs, the Savior will let that body rest a day or two, and much like himself, you will be raised and be resurrected, so that when the Savior does return, you will be right at the front of that amazing team of angels who will sweep the earth, much like described in the renewed earth. You will be there. It will bring you great joy to help Mother Earth transfer to a terrestrial realm, to burn away the celestial refuse. At that time, you and Holly will still have assignments here temporarily, preparing a world for you two. And you will be able to be an eternal family with eternal children on that earth. And the glory will just continue for you out, on and on through eternity. So we bless you at this time with strength, power over the callings you will receive, and that you are part of a very special team of people that are moving towards translation and transfiguration, and that the Lord will be with you at all times. You will be a patriarch in your own home. You will give blessings similar to this. Your veil will be essentially gone. You will be able to see into the past and into the future for these individuals and share with them the same type of knowledge and truth. We bless you with protection throughout your mortal life, that angels will now be assigned to you as you've reached this vibration. You have 9 angels assigned to you now to watch you from all sides through your faithfulness. I know you will stay faithful. I bless you with a strong protection against Satan and his followers, Lucifer, Cain, anyone else who seeks to oppose you. You will feel a new vitality and strength against them, and to use your priesthood to defend against them. I close this by assuring you that you will rise to an eternal glory, and that you will have an eternal family, and is assured through your faithfulness. In the name of Jesus Christ. Amen.
November 24th that is spoken, 2019 by Chad. And the other thing that stood out was at the beginning when he mentions that Alex is part of the Church of the Firstborn. That stood out to me. And then second, and the third, sorry, is in there talking about how he had already helped us more than they could repay him.
And breaking that down a little bit, with regard to the Church of the Firstborn, is that affiliated with the LDS faith to the best of your knowledge?
Judge, I'm going to object unless there's some foundation.
Sustain.
And Your Honor, if I may respond.
Go ahead.
I'm happy to lay more foundation, but I think I've already asked this officer previously on a similar objection if he looked into the LDS faith and is familiar with some of the terms used. So I think we have laid foundation for purposes of the investigation.
Judge, that's a pretty broad statement.
Well, if you re-asked the question, I thought you were talking about a different church. So go ahead.
Through the investigation, and are you familiar with whether or not the Church of the Firstborn is affiliated with the LDS Church?
It's my understanding that the two are not affiliated.
Is that why it caught your attention?
Yes.
Then you talked about a statement in there that the statement was made already assisted us in ways that can never be repaid.
Correct.
And again, Chad was giving the blessing.
Correct.
And it's your belief Lori was also present for the blessing.
Yes.
And then circling back, you said one of the other things that stood out to you was the date, November 24th of 2019.
Yes.
Do you know if Alex Cox is still alive?
Alex Cox is still alive during that time. Yes.
And do you know when he passed away?
December of 2019.
So just shortly after this.
Yes.
In the blessing, did you also hear reference made, you will know when it's time to move to the other side?
I did.
And that's Chad telling that to Alex.
Correct.
On November 24th of 2019, were Tylee and JJ missing?
Yes, they were.
And on November 24th of 2019, was Charles Vallow dead?
Yes.
And on November 24th of 2019, was Tammy Daybell dead?
Yes.
I have no further questions, Your Honor.
All right. Thank you, Ms. Blake.
And it is.
Mr. Pryor, if you'd like
Thank you, Judge.
cross-examination. Back on. Thank you.
Okay. Done that twice. Not on purpose. May I refer to you as officer? Is that okay?
Absolutely, yes.
Okay, thank you, officer. So you made mention of the fact that you familiarized yourself with the LDS faith. Is that right?
I was born and raised in the LDS faith, yes.
Okay, so maybe you can enlighten me because this has been a learning experience for me.
It has me as well.
Okay, but you obviously have a hand up. Is that you were at least part of that faith for a while? I don't have that. So you're familiar with the term doctrine of covenants?
Yes.
Okay, and in the doctrine of covenants, it talks about the Church of the Firstborn as part of the LDS faith. You remember that?
Well, I can't speak to the doctrine of covenants. I know what the doctrine of covenants are, but
well, you spoke to the doctrine of covenants, though.
I know what they are, yes. Well, I don't understand the content.
We're already having an issue with you talking at the same time as Mr. Pryor and vice versa. So please question and answer and don't talk over each other.
And Your Honor, I'm going to object as beyond the scope.
Overruled at this point.
Ms. Blake talked to you about the Church of the First, and you said that it wasn't part of the LDS faith. Is that right?
My understanding that the two were separate is what I said.
Okay, but the doctrine of the covenants talks about the Church of the Firstborn as part of the LDS faith. So where did you get your information from?
Basically, I talked to other investigators that were part of the LDS Church, and we had heard through this investigation earlier the mention of the Church of the Firstborn, not understanding what.
So you really don't know whether it's part of the LDS faith or not, the doctrine of covenants, even though the doctrine of covenants discusses Church of the Firstborn being part of it, right?
Yeah, so like I said, other than I don't, based on my knowledge, yes.
Now, and I'm going to go off topic a little bit, but some of the other stuff that I saw is Aluma Pastena is talking about light and dark.
Correct.
And light and dark is part of the LDS faith too, right?
I have no idea.
Okay. Well, you said you familiarized yourself with it. Did you familiarize yourself with light and dark?
Not totally, no.
What about death and death percentages and things like that? Is that part of the LDS faith?
I've never heard of that.
Okay. But you don't know whether it is or not, right?
Correct.
Okay. And then we heard about some vibrations. I heard the word vibrations a couple of times. Are you familiar with that term within the LDS faith about vibrations?
I am not.
What about being possessed by spirits and praying for their removal from your body? Have you heard about that?
I have not.
Okay. But you don't know whether any of these theories are part of the LDS faith, right?
Correct.
Okay. Are you aware that in the LDS faith, that if someone is possessed, that if you pray for them, you can have them removed from their body? Are you aware of that?
I am not.
Okay. Now, we talked a little bit about the frequency with which, on a specific day where Lori Vallow texted Chad Daybell 3 times in the morning, right?
Yes.
And that was with Charles Vallow, right?
That was the day that Charles died, yes.
And you made a point of bringing that up, that there were 3 messages that day in the morning, or at least there appeared to be some communication. We really don't know what they said, though, right?
That's correct.
Okay. Now, when you go over the phone records, 3 calls in a day was not uncommon for them when I looked at the records, was it?
No.
In fact, it was frequently more than that in the morning, more than that in the evening, and more than that in the afternoon, right?
Correct.
So when you pointed out the 3, I got the impression what you were trying to suggest, that because Chad texted her or communicated with her 3 times, that somehow links him to Charles Vallow's murder. That's not what you're suggesting, is it?
No, I didn't suggest that. I made comment that that those show up in her CDR records, but they do not show up. Those contacts do not show up in her iCloud records.
Okay, so just because there were differences, but it wasn't unusual for them to communicate several times a day at various times of the day.
Correct.
Right. After all, they were having a relationship with each other, weren't they?
My understanding, yes.
Yeah. Okay. Now, Maricopa County, is that the county that you're in down there?
Yes, sir.
Okay. Do you know the prosecutor down there?
I know many prosecutors there, but are you referring to
Alistair Adele?
Hold on, Mr. Pryor, he wasn't done answering.
Oh, I'm sorry. I thought he was, Judge.
Go ahead.
I do know Alistair Adele, the prosecutor, but I don't know her personally, but I know who she is.
So you talked in great detail about the Charles Vallow case, right?
Correct.
Okay. And you're aware that Mr. Daybell is not criminally accused in the Charles Vallow case, right?
Correct.
You're also aware that in June 29th of 2021, the prosecuting attorney issued a statement in regards to his intent regarding Chad Daybell and the Charles Vallow case, right?
Yes.
Okay, and that was published on it was actually put on the web, wasn't it?
I'm not sure where it was, but I know we received something as part of our case file.
Right, and you're aware of what this prosecutor, after reviewing all of the information, made a determination, right?
Correct.
Your Honor, I'm going to object. The defense counsel's clearly headed into hearsay.
Well, it's already asked and answered without a timely objection, so overruled.
Okay. So did you happen to review what the prosecuting attorney's ruling was in regards to Chad Daybell and the death of Charles Vallow?
I am not privy to the ruling or the basically the discussion of why a decision is made, other than the decision has been made.
But obviously, and I'm doing it again, and I'll slow down, Judge. I'm sorry. A lot in my head, and I'm trying to get it out to talk to you. That's because there's different functions. Your function is to investigate a situation, correct?
Yes.
Gather evidence.
Yes.
Make a determination through the interview of witnesses.
Correct.
And then at the conclusion of your investigation, you're to submit that information to a prosecuting attorney.
Yes.
The prosecuting attorney is not to get involved typically in helping you interview witnesses, right?
I don't agree 100% with that, because on all of our homicides, we do have an attorney that responds to our scenes and is aware of the circumstances surrounding it, because that attorney would have to speak at a hearing later on. So they need to know about the case.
Would they be participating in the interview of the witnesses?
No.
That's unusual, isn't it?
Yes.
Okay. Okay. And it's unusual to encourage or tell witnesses what they should say and not say. Would that be fair as well?
For the attorney to tell witnesses?
Yeah, how to testify, what to testify to?
Yeah.
That's unusual as well, isn't it?
Well, there is witness prep in cases, so you can actually talk about, certain things, but no, I don't say it's not highly unusual.
Okay. So when we're talking about witness prep, that's a completely different thing than a prosecutor or an attorney getting involved in the actual investigation of a criminal matter, correct?
I can speak from Maricopa County.
Okay.
That they would be present during the investigation and they might have a suggestion or two, but they would stay out of it.
Right. Okay. So is there anything that would refresh your recollection in terms of what the prosecuting attorney's ruling was on June 29th of 2021 regarding Chad Daybell?
There is what's called a disposition sheet on my report that would show that, yes.
And Judge, could I approach, you don't remember exactly the wording the prosecutor used, do you?
I don't remember the exact verbiage, no.
Okay, Judge, could I?
I'm going to object to hearsay here. The answer is going to call for hearsay.
Right. I'd like to, in camera, just on a sidebar, review the exhibit proposed. All right, Mr. Pryor, you can continue.
Now, officer, as part of the disposition and a determination by a prosecuting attorney, and this is after the police officers have done their investigation, and the case is then put together and submitted to a prosecuting attorney. Are you following me?
Yes.
Okay, at that point, a prosecuting attorney makes a determination after they review all the evidence independently and make a determination as to whether or not they're going to proceed with charges against a particular defendant. Would that be fair?
That's fair.
And then in Maricopa County, how is that accomplished?
So we submit our charges to Maricopa County, the courts, and then they review the case and then they send us back their decision. So it's, like I said, it's been in the form of a disposition form. If they're not going to charge, they would send us a disposition form. If they are going to charge, then we would attend a grand jury or go through the process or preliminary hearing, whatever it may be.
And is that disposition form public record?
I believe so.
Okay. And do you recall whether or not the disposition record that was filed in regards to Mr. Daybell and his, even any potential involvement with Charles Vallow, was that public record?
If it is in the report, then that would be public record, yes.
Okay. And is that published anywhere that you're aware of?
What do you mean? Is it published?
Is it published on the internet? Is it published on any sort of media?
No, the report wouldn't be published. You'd have to request that report.
Okay. Okay. So in addition, there would also be a reason for, or an explanation for why they didn't prosecute. Is that correct?
Like I said, I would not be I wouldn't know that information other than I just get the disposition. I wouldn't understand their rationale for charging or not charging.
Okay, but they would give you some explanation in the reason on the disposition sheet, right?
Yes.
Okay. And did you receive a copy of the disposition determination by the prosecutor in regards to Chad Daybell in any potential involvement with Charles Vallow?
Yes, I did.
Did you review that?
I did, and I scanned it to the report.
Okay, and do you have an independent recollection of what the reason was that they didn't charge Chad Daybell in the Charles Vallow matter?
I do not.
Okay, is there something that could refresh your recollection?
Sure.
Would the disposition sheet refresh your recollection?
Yes.
Judge, may I approach this witness?
You may. Well, let's have the bailiff carry that over.
Approach this witness. And let me know when you're done reviewing.
Okay.
Are you done?
Yes.
Was there a reason stated in this document as to why they would not prosecute Chad Daybell in the Charles Vallow case?
Yes.
Can you tell me what that reason is?
The reason they provided was no reasonable likelihood of conviction.
So I'm going to repeat that and then make sure I said that and heard you correctly. At my age, I don't always hear clearly. No reasonable likelihood of conviction. Is that what it says?
Yes.
And to your knowledge, they're not pursuing this in any other way in the future against Chad Daybell. Is that correct?
That is never taken off the table. No.
Okay. But at this point, you don't have an active investigation against Chad Daybell, do you?
There are records that I would like to look at that other agencies have, but like I said, there's no statute of limitations on the
Right.
side. So
Oh,
yeah,
there's
I
never
could
a
always,
statute. I'm sorry.
yeah, I could always look at additional records, and if additional evidence came forward, then it could be charged.
But based on the evidence that you presented and the evidence you presented today, that was all provided to the prosecuting attorney, right?
And this is based on evidence as of 2021. Yes.
Right. So it's all, they have all the current evidence, right?
I'm not sure if they have other jurisdictions' evidence.
Okay.
They clearly have ours.
Okay. Well, other jurisdictions' evidence, they have evidence relating to the killing by Alex Cox and Lori Vallow of Charles Vallow, right?
Yes.
And at this point, according to this prosecutor, and that's what, 3 years ago? There's no reasonable likelihood of conviction of Chad Daybell in that matter, correct?
Correct.
Okay. And I could have that back, Mr. Bailiff. Thank you. Now, this is an unusual case because there's a lot of talk about religion.
I agree.
And Mr. Daybell, do you know how long that blessing thing went on for?
I have no idea.
Yeah, me neither. Was it written? Was he reading off of something?
I wasn't there, so I couldn't tell
You
you.
didn't hear pages on the video of him turning pages or anything?
Didn't.
I thought I heard some pages turning.
I heard a garage door open.
Okay, I didn't hear that.
Yes.
Well, all right. Well, you got better ears than I do. We talked about that before. You know what Chad Daybell did for a living, right?
I know he was an author. I don't know other than
Wrote
that,
books.
Yeah.
And as I was listening to that, it sounded like someone was writing a book. Would you agree with that?
Objection, Your Honor. I'm going to ask that the narrative be stricken. I think counsel can ask questions, but there's narrative being added.
Well, that, I'm going to make a ruling, Mr. Pryor. So on the last question, I'll overrule that, but to the extent it does become more narrative, Ms. Blake, you can object again.
Okay. Now, you know the name's Melanie Gibb.
Yes,
Did you ever interview her?
I did.
Okay. And David Warwick.
I know the name, but I never interviewed him.
And I could represent you that she was dating Melanie Gibb, eventually married Melanie Gibb. So
That
do you
sounds about-
recall?
sounds about right.
Refresher? Okay. And then Zaluma Pastenes.
Yes,
Okay. All of these folks, members of the LDS faith.
it's my understanding. Yes.
Okay. And all of them have made numerous references to some, at least what I would consider unusual beliefs.
True.
Talking about, as members of the LDS faith, they talk about vibrations. We've heard that, right?
Correct.
They talk about probationary periods.
I've heard that term. Yes.
Right. And that deals with what you did in your life before in that particular faith, what your role was in life before, right?
If you say so.
Well, I'm asking you because
I
if
don't.
you don't know about that?
I don't know.
Okay. And then there's some references to God and goddesses. You've heard about that, right?
I have heard that. Yes.
Okay. And in the reference to God and goddesses, are you aware that in the LDS faith that as you move forward, you become a god and a goddess in their faith?
I'm not. No.
Okay. And are you aware that in the LDS faith that when you their God lives on a planet and then angels are brought down to communicate with us?
I'm not familiar with that. No.
Not familiar. How long were you involved in that faith?
Until I was 18.
Okay. So is it because you're not aware of it, or is it because you don't believe it was part of the faith?
No, I chose to practice a different religion.
Okay. So you're not aware. You're just telling me you don't know whether it's true or not.
Correct.
Okay. Thank you. And we're not trying to you agree with me. We're not trying to disparage the LDS faith, right?
No.
We're just trying to point out that the stuff they're talking about may not be something that's out of the realm of discussion within that faith, right?
I'd agree.
When you're talking about spirits and exercising spirits, such as Ned. I guess we talked about Ned, right? That wasn't with you with Ned. Never mind. But that's all of this stuff because these folks were all actively involved in the LDS faith. These are things that came up as
Your Honor, objection. Counsel stating facts, not in evidence. And again, this is a narrative.
Sustained.
Now, you investigated this case, and there was a time when J.J. Vallow was exclusively with Charles Vallow, and Lori Vallow wasn't involved. Do you have any recollection of when that took place?
I'm not sure the time frame on that, but I know that JJ was with Charles in Texas. Yes.
Right. And at that time, Lori Vallow, and it's in this time period, right?
I'm not sure. I wouldn't be able to speak to the exact time period.
Okay.
So
do you know where Lori Vallow was living at that time during that 2 or 3 month period?
I don't recall.
Okay. All right. You don't have any recollection of that.
Correct.
Okay. So you're not suggesting because Chad Daybell gave Alex Cox a patriarchal prayer that in some way he was involved in the killing of Charles Vallow, are you?
I didn't say that, no.
Okay. And from what I understand, and please correct me, you have 18 years more experience than I do. I have 0. Giving a patriarchal prayer to someone, regardless of whether you can do it or not, is that a crime in Maricopa County?
No.
Okay. You wouldn't think that's a crime anywhere, right?
Correct.
Okay. It may not be the best religious practice. There may be other issues, but it's not a crime anywhere, right?
Correct.
And you would agree with me that just because you give someone a patriarchal prayer, a very, very long patriarchal prayer, that isn't to insinuate that you've committed any kind of a crime, right?
Correct.
Okay. You knew Zalim. Oh, wait. Go ahead.
You're fine.
Go ahead. I wish I had one. in the house.
Yes.
And at the time of this incident, both of those kids were present.
At the time of the actual shooting,
Well, at the time of the altercation, both of them were
on
present.
the date in question, all four of them were present.
Right.
And, yeah, when Charles arrived.
Right. And at that point, something with Tylee and a bat.
Yes.
Okay, tell me about that.
So what was explained to us through Alex Cox was there was an altercation, an argument between Lori and Charles regarding Lori taking Charles's phone from him, demanding the password to look into the phone. During that time, the argument continued. Tylee reportedly came out of her bedroom with a bat, and it was grabbed by Charles and pulled away from Tylee. It was that bat that Alex claimed that he was hit in the head with during this altercation. And then during this time, Lori had left the house with Tylee and JJ.
So Lori left the house with Tylee and JJ, and she was outside or something like that, right?
That's my understanding, yes.
Right. And at that point, Alex Cox took out a gun and, in your assessment, murdered Charles Vallow.
Yes.
Okay. And there's no indication that Mr. Daybell had any text messages or communication with Lori Vallow or Alex saying, let's kill Charles Vallow, right?
Not in those words, no.
Well, not in any words.
Correct.
So why'd you say not in those words?
Through this investigation, 2 days prior, I uncovered some messages between Lori and Melanie.
Melanie?
I believe it was Melanie Bedreau.
Okay.
And during that time, Lori had sent Melanie a message saying to give her 5 minutes. She's trying to find out what to do.
Okay.
And
That's a very generic term. Now, one of the things I noted on your exhibits, you talked about, and this was on the Lori for Styles on the second page of your exhibit. It was
You reference which exhibit, please, Mr. Pryor?
I don't have the number. It was the Lori for Styles. Well, maybe
49.
I think so, Judge. Could we hand that?
Well, so the exhibit's actually the PowerPoint. I don't mind the witness being handed a print-off version as long as we clearly state which exhibit that's coming from.
Judge, I could actually see if he can remember it because it's really actually a very short question. May I, Judge?
Yes.
So there was some discussion where you read off the exhibit, and this was in the Lori for Styles, where you said, it's not Ned, it's a new one.
yes,
Okay, and that was from Lori Vallow to Alex Cox.
correct.
So when I hear it's not Ned, and your suggestion is that Ned was someone who was possessed Charles Vallow's body, is that right?
Yes.
And what I read from that is it's a new one that's possessing Charles Vallow's body now. Would that be a fair assessment?
Yes, that would be a fair assessment.
And is it a fair assessment to suggest that when you're trying to extricate a spirit in the LDS faith from someone's body, you pray and that's how you get rid of a spirit?
Once again, you're talking out of my expertise.
Okay, that's okay. And I appreciate your honesty. Then there was some discussion from Nicole Earl to Lori Vallow. And Lori Vallow talked about, at least for yes, she awoke in the night coughing, threw up, collapsed, and passed away. And she said, oh my gosh, I did not hear that I'm in, it's Hawaii, it's 6 a.m. So Lori Vallow on that day of 10/19/2019, at least expressed shock at the death of Tammy, right?
Yes.
Okay. Melanie Gibb.
Correct.
And they had a discussion, and Lori again is that.
That would have been later in the day, yes.
Right. And then there were other numerous references where you talked about the fact that Lori Vallow may not have been completely honest about things.
In what way?
Well, is it your impression that she was manipulating some of these people?
I don't know if I'd use the word manipulation.
Okay. Okay. All right. Now I want to get to the phone call to the funeral home.
Yes.
Okay. Now at that point, when was that again? I'm sorry.
I'm not sure the date on that. No.
Okay.
Oh, actually, I am sorry. That is the evening of Charles Vallow's death.
Okay. And at that point, Lori Vallow and Chad Daybell were having an affair.
Yes.
And they were involved in a relationship.
Correct.
And Chad Daybell, that's not something you want someone to find out about. Would you agree? Involved and have a wife, and then you're making phone calls. Name, right?
Yes.
He said Chad Daybell.
Yes.
And then as it's going on, he maybe told some untruths, right?
Correct.
So if he tells people his real name when he's trying to cover up an affair, it's not the smartest thing to do to suddenly say other things when you've already told him who you are, right?
I'd agree.
Okay. All right. And that doesn't mean that he was involved in any way in the death of Charles Vallow, does it?
That phone call alone would not indicate
No, that's what they talked about. No likelihood of prosecution because he made a phone call to a funeral home about that, right?
I don't think that no likelihood in prosecution was directly related to the phone call.
Okay. It was directed actually to all of the evidence in whole up until the 21st of this year is what it was it involved, didn't it?
Correct.
Okay. Now, I want to go back and then we're done. I promise we're done. Okay. I want to go back to the parochial prayer. Did you have an occasion to look into Alex Cox's background a little bit?
I did not know.
Okay. Were you aware that this parochial prayer was approximately 2?
That sounds about right, given the
Okay.
date. Yeah.
And Alex Cox, his death was ruled and determined after an investigation to be natural causes.
Correct.
So there was no funny business with Alex Cox, right?
That we know of, yes.
Well, they did an independent investigation, right? Okay. Were you aware that prior to the parochial prayer that Alex had been seeking medical treatment for a number of medical maladies?
I was not.
Were you aware that Alex traveled to Mexico to get
You're on. Actually, I'll withdraw.
Go ahead. You can continue, Mr. Pryor.
Are you aware that Alex Cox traveled to Mexico before that to seek cheap medical prescription drugs to treat medical maladies that he was suffering from?
I am aware of that, yes.
Okay. And you were aware that because of Alex Cox's illness, that Chad Daybell, at the request of Lori Vallow, gave Alex Cox a parochial prayer?
I don't know if that's the reason why I gave it.
Okay. All right. Judge, I have nothing else. Thank you, Your Honor.
All right, that'll conclude Ross. It's time we can have the states redirect.
Detective Duncan, were you personally involved in anything to do as far as an investigation or responding to Alex Cox's death?
I was not.
And you indicated you were aware that he'd gone to Mexico.
I was aware that he went to Mexico. That's all that I knew.
So you don't know what he purchased
I
down
don't
there?
know. I know he purchased some medication, but I don't know what.
So you don't know what medication he purchased or what he took?
No, I do not.
Did he die shortly after the trip to Mexico?
I'm not sure I don't know the exact date he went down and then relative to his death.
But you also don't know what he purchased.
Correct.
And he received that blessing, and counsel indicated just a couple weeks before his death. Is that correct?
So November 24th was that blessing date.
And so if you were told he died December 12th, does that sound right?
That does, yes.
So on November 24th, Chad talks to him about crossing over, about his time here being done.
Yes,
And then December 12th, he's deceased.
correct.
When you're doing a homicide investigation, is a focal point the day of the actual killing?
Yes,
So in this case, is it fair to say that you really focused in on July 11th?
correct.
And then ultimately, did you look at times before and after July 11th as part of your investigation?
Yes, I did.
And to be clear, I guess for the jury's benefit as well, July 11th of 2019.
That is correct.
So you were asked about these messages that were deleted from between Chad and Lori.
Yes,
Is that why you included those and focused in on them?
absolutely.
And the content was missing,
Correct.
but they were in fact sent in close proximity to the time Charles was killed.
Yes,
And I think counsel had asked you, or you had started to answer a question from counsel about some messages between Lori and Melanie around the time of that July 11th date. Counsel cut you off.
yes.
Could you finish what you were saying there?
Yes, as indicated that on the 9th of July, there was some conversation or text message that Lori sent to Melanie to give her 5 minutes that she was trying to figure out what to do. At that time, she was talking to Chad Daybell on the phone.
You were also asked about a couple of assessments that you made. And one of them, counsel asked, was it your assessment that Alex murdered Charles?
Yes,
In your assessment, did he act alone?
I don't think he did, no.
You were asked a lot about what the prosecutor recommended in relation to Chad Daybell and Charles killing.
Yes,
Was something submitted to them to review in relation to Chad Daybell?
yes,
And you were also asked if the text messages alone made you think Chad Daybell was involved.
correct,
And you were asked if the blessing alone made you think he was involved.
correct.
And you were asked, I think, about some other things to say, and I think your response was not alone,
Correct.
that alone didn't. Counsel asked about your assessment. In your assessment, did you recommend charges for Chad Daybell?
I did.
I have no further questions.
All right, thank you, Ms. Blake. Any recross?
Recross?
If you may, yes.
Your Honor, I would object to recross. I don't think I went outside the scope.
Oh, he went in.
If we're outside on recross, raise an objection, otherwise I'll permit it. But I will keep that in mind, Mr. Pryor, no new
Right.
areas.
All the facts as it relates to Chad Daybell, Lori Vallow, and Alex Cox. Is that fair?
Your Honor, I'm going to object. This goes outside the scope of any redirect.
Well, it's a very general question, so I'll overrule the objection.
Go ahead, officer.
The data is based from every based on the information that I obtained and the totality of the circumstances, I recommended charges be filed.
Yeah, that doesn't mean he's guilty of anything, right?
Correct.
Okay. And the prosecuting attorneys whose job is to apply the facts that you give him to to what the law says, made a determination otherwise, correct?
Objection, Your Honor. This was asked and answered, and it's definitely outside the scope of redirect.
Sustained.
Nothing else. Thank you.
All right. Okay, that will conclude the testimony then of Detective Duncan. Before he steps down, I did want to reiterate a limiting instruction the court's providing at times during this trial and will be provided as part of the jury instructions with the jury. So let me provide that instruction and then the witness will be concluded. Ladies and gentlemen of the jury, during the course of this trial, evidence will be introduced for the purpose of showing that the defendant or an alleged co-conspirator has committed acts other than that for which the defendant is on trial. Such evidence, if believed, is not to be considered by you to prove the defendant's character or that the defendant has a disposition to commit crimes. Rather, such evidence may be considered by you only for the limited purpose of proving the defendant's motive, opportunity, intent, plan, or absence of mistake or accident. So that's the court's instruction. Again, it will be provided as part of your instruction packet as well when you deliberate. That concludes then Detective Duncan's testimony. You may go ahead and step down from the witness stand. Thank you.
Judge, is he excused?
Would he be recalled?
The state does not intend to recall Detective Duncan.
And the defense does not intend to call Detective Duncan. Thank you.
Okay. Well, on the issue of that exclusionary order, then, if Detective Duncan follows the case any further, he may be prohibited from testifying if he is recalled for any reason. So, thank you. Thanks. All right, counsel, I wanted to continue on to 3:30 if we could today. Does the state have another witness they'd like to start with, or do you want to discuss scheduling?
Your Honor, the state would call Mark Sorry.
All right, well, let's go ahead and get another witness going. And again, we'll conclude today at 3:30.
Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
Just keep plugging into the mic and you have the water there.
All right, before we get started, what is your preferred title? Is it officer or agent or some other title?
Special agent is fine.
Special agent. All right, special agent, before you testify, let me just ask, now that you're under oath, have you reviewed any of the previous testimony offered in this case?
No, I have not.
So you haven't observed any on the court's live stream?
No.
All right, Mr. Wood, you can inquire on direct.
Thank you. Can you state your name and spell your last name for the record?
Mark Saari, it's Saari.
What is your occupation?
I'm a special agent with Social Security Administration Office of the Inspector General.
Right. And how long have you been doing that?
Approximately 5 years.
Tell us about that. What do you do as a special agent?
Investigate allegations of fraud, waste, and abuse within Social Security Administration.
And how does one become qualified to do that?
So as a prior Deputy U.S. Marshal for approximately 13 years, I have completed the Criminal Investigator Training Program at the Federal Law Enforcement Training Center in Glencoe, Georgia. Glencoe, Georgia.
How did you become involved in the investigation regarding Tylee Ryan and J.J. Vallow?
So in or about January of 2020, the FBI out of Phoenix, Arizona contacted our office and to locate the whereabouts of JJ as well as Tylee Ryan.
So you were referred to it by the FBI?
Correct.
And I'm sorry, when did you say that was?
In about January of 2020,
What was the purpose of your investigation?
to determine if the whereabouts of the children were to be located, as well as if there's any kind of social security fraud involved.
What did you do in furtherance of your investigation?
So I met with local law enforcement, met with the FBI, as well as had several subpoenas issued as well.
I want to talk to you about Tylee Ryan. Did Tylee Ryan receive Social Security benefits?
She did.
Why did she receive Social Security benefits?
She received survivor benefits based upon her father, Joe Ryan, who died on April 3rd, 2018.
And how much did she receive a month?
Approximately $18.59 per month.
Where she was a minor child, was there a guardian or someone who represented her in those payments?
Yes.
Is there a name for that individual?
Lori Vallow.
And is there a specific, is it fair to call her a representative payee?
Correct.
As part of your investigation, did you look into what bank accounts Tylee Ryan received these Social Security benefits?
Yes, I did.
Do you know what bank account she received those benefits in?
It was to a JP Morgan Chase account.
And do you know if where she was a minor, was her mother also on that account?
I believe she was, yes.
Did the bank account she received payments into ever change?
Yes.
What did it change to?
To a BBVA account.
And do you know when that happened?
On or about August 20th of 2019.
Would there have been a notice regarding that change mailed to the representative payee or Tylee?
Yes.
And through your would that have been an automatically generated notice?
Yes, correct.
And in your investigation, have you honored asked that the witness be handed States Exhibit 114A?
Yes.
And you can save a trip. He's already had provided me a copy, and I'm no objection, Judge.
All right, I'll quickly look.
Your Honor, I just realized I did not provide courtesy copies to the court earlier as well.
Okay, and I'll just take a look at it as well. All right, Exhibit 114A has been offered without objection. It is admitted.
Detective, what is Exhibit 114A?
This is a notice sent by the Social Security Administration to Lori Vallow on behalf of Tylee Ryan on August 27th, 2019, notifying of the bank change that happened.
And does it state the change? Or I'm sorry, did you say what date it was sent?
The letter was sent on August 27th, 2019.
All right. And this just establishes that that bank account changed.
Correct.
Did Tylee Ryan stop receiving Social Security benefits?
She did.
When was the stop date?
In about January of 2020.
And do you know why, through your investigation, those payments stopped?
Due to her whereabouts being unknown, our agency turned off the benefits.
And are you aware of a last known sighting of Tylee Ryan?
Judge, I'm gonna object. It's calling for him to make a determination based on hearsay.
The way that question's worded, I'll sustain that.
I'll retract the question.
Thank
you. I want to talk to you really quickly about JJ Vallow. Pursuant to your investigation, did JJ Vallow receive Social Security benefits?
Yes.
Why did JJ Vallow start receiving Social Security benefits?
Due to his father, Charles Vallow, dying on July 11th of 2019.
And do you know how much he received?
$19.51 per month.
And do you know when those payments began?
It's in September 18th, I believe, of 2019.
Did he also have a representative payee?
He did.
Who was his representative payee?
Lori Vallow.
Okay, so the same as Tylee's.
Correct.
Do you know when JJ Vallow, or did JJ Vallow's payments stop?
They did.
Why did they stop?
Due to his whereabouts being unknown.
And now I want to ask you a couple questions about Lori Vallow. Did Lori Vallow receive Social Security benefits pursuant? In fact, and are individuals who receive Social Security benefits, are they notified that they are required to give that notice to the Social Security Administration?
They are.
Your Honor, I'd ask that the witness be handed States Exhibit 114B.
There won't be an objection to that either, Judge.
Okay, I'll just briefly review that before it's admitted. Exhibit 114B is admitted.
Thank you, and may I publish that to the jury?
You may.
And Your Honor, may the witness have another copy of that while
No
I publish?
objection, Judge.
If we have one.
I do.
I have it.
Okay. So, and to be, I don't know if it matters, Mr. Wood, but what should be published is the exhibit, not the copy.
Right. What I have is the exhibit that will be published.
Okay, and then I will allow the copy to be provided for reference to the witness.
Special Agent, what is this document?
This is the copy of the reporting responsibilities that were given to Lori Vallow upon the application for JJ Vallow.
And would that have been an automatically generated document?
Yes, correct.
And it would have been mailed to her?
Either mailed or handed to her directly. Either two of those would have happened, correct?
All right. And you said this lays out the notification requirements.
It does.
And what page is that on?
Page 1, I believe.
It starts there?
Page 5 of this document, but yes.
Okay. And so what are, again, you stated before, but what are some of the requirements that require notification for a change in circumstance?
On here, and notes any beneficiary dies or becomes unable to handle benefits. That would be one item on this document.
And if a beneficiary moves, are they required to notify the Social Security Administration of that change?
They are.
And you stated earlier, if one of the child beneficiary dies, they're required to report that?
Yes, correct.
If a person such as Lori Vallow, who's receiving parent and care payments, if they remarry, are they required to provide that information?
They are.
Special Agent, pursuant to your investigation, did Lori Vallow ever report to the Social Security Administration that Tylee Ryan died or was missing?
No.
Did Lori Vallow ever report to the Social Security Administration that JJ Vallow died or was missing?
No.
Did Lori Vallow ever report that Tylee and JJ had moved from Arizona to Rexburg?
No.
Did Lori Vallow ever report to the Social Security Administration that she married Chad Daybell on November 5th, 2019?
She did not.
And did Lori Vallow ever report to the Social Security Administration that she moved to Hawaii in November or December of 2019?
She did not.
Special Agent, the funds from Social Security, before they're paid out, who do they belong to?
They belong to the U.S. Treasury, which is part of the U.S. government.
Just one moment, Your Honor. Your Honor, the state has no further questions for this witness.
Very well. I'll allow cross at this time then, Mr. Pryor.
Thank you, Judge.
This is the exit.
Good afternoon, Special Agent.
Good afternoon.
Now, I heard a lot about Lori Vallow. Lori Vallow didn't do this. Lori Vallow didn't do that. Lori Vallow didn't notify of the deaths or moving. Are any of these documents, or is this case involved in any capacity with Chad Daybell?
No.
Chad Daybell's not on any of the documents.
Correct.
Chad Daybell is not under any obligation to report that he married anybody in particular, correct?
Correct.
And Lori Vallow is the one, if she's failing to do any of these acts, Mr. Daybell is not obligated to say anything, correct?
Sorry, repeat the question again.
Well, Lori married Chad Daybell. At that point, is Mr. Daybell obligated under the Treasury laws to report that to the Treasury Department for Lori Vallow's SSA payments?
I think if he were aware there was a violation of what's happening with the reporting responsibilities, it would probably be a problem for him. I would agree with that, actually.
Okay.
To repeat that, if he was aware that she had responsibility to report that, and that's actually a federal violation, and he was aware that did not support that, I believe that would be a problem, actually, for our agency to investigate.
It could be a problem.
It could be, correct.
Okay. But primarily, the person who's failing to report making those representations is the one who's primarily criminally responsible. Would you agree with that?
That's probably accurate, I would say, yes.
Yeah. And it would be unusual for a spouse to report on their own spouse that, oh, by the way, they're not, they didn't report about the benefits. It's really the onus is on the person receiving the financial assistance, right?
I would say so.
And that financial assistance was being put into Lori Vallow's independent account, correct?
Correct.
Okay. Okay. Now, if I'm adding this up correctly, you said Lori Vallow was getting $1,859 a month, commencing when?
In or about September 18, 2019.
And was that because of a death?
What
was the reason for that check?
For JJ or for
Tylee?
For Tylee. That was for her father dying in 2018.
Tylee's father dying.
Correct.
Okay, so Tylee's father died and Lori Vallow. Do you know when did that come in? That check started?
For Tylee?
Yeah.
Her father died in April of 2018, so she applied for benefits after that date.
Okay, so he died in April of 2018. Okay, and at that point, she was getting 18, or after she applied, she was starting in September of 2018. She was getting 18.59 a month, right?
September of 2019, she was receiving 18.59 per month. Every year increases based off of COLA, so it would have been a little bit less, I believe, in the previous year to that.
Okay. And at the same time, she was also getting this mother-child care as well, right?
In regards to Tylee?
For Tylee, did she get the mother-child care?
Not true, no. It would be for JJ.
Okay, well, I was just asking whether she did, so it.
Okay.
Okay. And then, JJ started getting the Social Security payments. Is that right?
In September of 2019, correct.
Okay. As far as Tylee is concerned, the Social Security payments end when?
In January of 2020.
In January of 2020, the payments would end, right? Is that what you said?
Based upon our stopping the benefits for her, correct? Yes.
Okay, what about age? When do the benefits end as far as age?
If she turned 18, they would have stopped.
So if Tylee had turned 18 years of age, they would have stopped automatically anyway, correct?
Correct.
And at the time of Tylee's death, do you know how old she was?
I don't have the exact age for at that time. I don't.
Okay, that's okay.
Yeah.
That's okay. And then as a result of Charles Vallow's death, JJ started receiving $19.51 a month?
Correct.
So my math is not great. We're about $3,800 between the two kids just from Social Security benefits. Is that right, that Lori Vallow received?
Are you asking per month or what time period?
Per month.
I'd have to add it up, but it'd be 1951 times 2 plus 1859 per month. So I don't have a calculator.
Oh, I'm sorry. That's right. The child throws another $1,900 in there as well, right?
With mother, child, and care, correct?
So 39 and 18 we're north of $4,800. $5,800 a month approximately, right?
I'd have to add it up, but it sounds right to me.
Okay. And that's money that she receives every month, and only because her third husband died, right?
Correct.
Her fourth husband died, correct?
Correct.
Okay. And then at some point, those funds would continue until the children would reach 18 years of age. Is that fair?
They would, with one caveat. If
Okay.
we had sent a letter to her address in that time period and the letters were being returned to us, we would have stopped benefits immediately based off of that happening.
Okay.
So at some point, we would have probably been sending letters to the address in Arizona. We would stop benefits based on the letters probably being returned to us. So,
But I'm talking in generalities. In generalities, if nothing had changed and everything remained the very same, and it just continued on with until both children reached the age of 18. Potentially, she would be, until Tylee turned 18, you'd be looking at almost $5,800 a month in payments for just the kids to her. Would that be fair?
until the children aged out, I believe that'd be correct.
Okay, all right. Judge, I have nothing else. Thank you, Judge.
All right, thank you, Mr. Pryor. State have any redirect?
Your Honor, the state does not have any redirect.
All right, is this witness intended to be recalled?
Not by the state.
Not by the defense, Judge. Thank you.
Okay, that'll conclude your testimony. Thank you for appearing. Can I have a quick counsel sidebar, please?
Okay, I suspect we are going to be signing off here as soon as the sidebar is done. Because they're stopping at 3:30. I can't imagine they would start a new witness so close to that mark. So, if that is the case, then we shall be back in the morning bright and early. We'll see if there's anything yet to go on the record before we sign off.
All right, thank you, counsel. Given the timing, court suggested maybe we break for the day before starting with the new witness and just breaking that up immediately. So is the state okay to conclude for the day? And if so, who will be taking the stand tomorrow morning?
We are good to conclude, and Chuck and Sidus will be starting in the morning.
All right, is the defense okay if we stop now?
Yes, Judge, thank you.
All right, ladies and gentlemen of the jury, then thank you for your attentiveness today. As we break for the day, I will admonish you, please do not do anything to investigate the case, look into the case in any way. If you see it reported somewhere in the media inadvertently, please try to divert your attention from that and don't talk about the case amongst yourselves or with anyone else. You'll only be able to do that once your deliberations commence with each other. So with that in mind, we will go ahead and conclude for the evening. And thank you all in attendance in the courtroom today for abiding by the court's order in relation to courtroom conduct. With that in mind, then we're in recess until tomorrow. We'll start again at 8:30.
All right.
Okay, it sounds like Eowyn is weighing in too. So, that concludes that. And yes, Indiana, get some more sleep tonight. It's going on 10 p.m. for you, I think. Let's see. So I will bid you all a good evening and see you bright and early. Bye-bye. Oh, hi, Lone Ranger. Yeah, we just ended Chad's trial for the day. So come back tomorrow. Bye-bye.